Hello everyone, welcome back to our channel. This video is going to be about CA Final, Self-Paced Online Modules, Set A, Corporate and Economic Laws. This is going to be a marathon session for the Securities Laws. So Securities Laws, when you see the SEBI Act, LODR regulations, ICAI regulations, takeover regulations, insider trading regulations, everything will be covered in detail in this particular video. So this will be in the form of conceptual along with the exam-oriented classes. So when you see conceptual, I will be telling you the meaning and then the logic along with the examples. Wherever examples needed, wherever the logic is needed, I will give it to you along with the explanation. And exam oriented, when you mean exam oriented means I will be telling you from where what are all the points the questions may come in exam. Nowadays we are getting questions from the unusual points also. Now, people will not think that from this point question will come, but from that point a question will be there. So that is the recent trend of the SET exams. They are asking tougher questions and from unexpected parts. If you want to clear the exam in the first attempt, you need the proper conceptual clarity by like this marathon session. So if you give proper time, you will get the clarity and you can clear in the first attempt. Not just in the SET, you will get the proper preparation for IBS also, so that you don't need to do the extra preparation for IBS. Just when you revise what you have learned already for SET, that will be enough when you're preparing for IBS. So all of this will be covered properly. What I will do is whenever I'm doing the explanation, I will be giving you the points. When you're doing the revision, what you have to do. This you are watching the marathon, that is okay. When you're starting to revise, which points you have to give more attention, that also I will be telling you along with the explanation, so that it will be helpful for you in the revision. After watching the marathon, you will get a direction for each topic, what you have to do the revision in that topic. So that also will be in this particular video itself. And here if you see, we are also having the other CTA lectures. CTA will be covering it in total 3 parts. First part is for the securities laws. Second part is for the economic laws. Third part is for the company law. So the company law, the entire 3 videos will get uploaded by the end of first week of August. So when you're watching this video after the first week of August 2026, definitely you will have all these 3 videos in our channel already live. So in this video description also, I will try to add the link of these videos. The videos link I will be adding in the description as and when they get uploaded, and you can check the description and in the pinned comment you will get the links, so you can watch these videos. And these 3 parts will be having a total of 24 to 25. In 25 hours you will be getting the entire content for CTA fully on YouTube. You will be getting it with in-depth conceptual clarity and then the exam oriented points which you need to notice when you're preparing. So all this will be available in YouTube CTA session. And when you see the Set B session, already we have uploaded the Set B session and it has got a very good reach, 360,000 plus views in the Set B videos. So I'm very thankful for that. And you can also watch these videos. If you have not used it till now, you can also use this for doing your SET B preparation. Many students have used our resources, and thousands of students have cleared SPOM SET B because of these videos. So these videos will be helpful for you also. You can try to watch this and then you will get the conceptual clarity properly. I have given you the logic also. In SET B lectures also I have given you the logic of the points, so that it will be helpful for you to understand and remember the concept. When you do mug up, you will be able to remember it only for that particular exam. That is also a little bit difficult, but you won't mix up if you're getting the proper conceptual clarity. You won't be mixing up the points and you will be remembering it for the IBS exam also. So SET B lectures also you can use. These 3 videos we are having for SET B. One is the practical sums marathon. In each and every chapter we will be covering the practical sums fully in this entire 12 hours. The total practical sums will be covered in this 12 hours. When you see the theory, the entire theory for SET B, we are going to cover it in 12 hours in this particular SET B video. And these 2 videos will be in English only. And when you see this video, this will be in Hindi plus English. These 2 in English, and in this video when you see Hindi plus English, this will be for the theory in the Hindi plus English manner. So that is also covered. These are all the detailed revisions, detailed sessions for the SET B and SET A. And when you want the super fast revision, you have already studied SET B, now you want a refresher, like you are brushing up the concept for IBS. No need to go in depth, just you need to remember what are the things you studied earlier. For that you will get the super fast revision. So this will be giving you a brushing up of the entire concept. For example, in SET B when you see total 4 hours, we are covering the entire SET B. All the things will be covered. And SET A when you see total 4 hours, we are covering the entire SET A. All the important concepts that are required for IBS purpose, that we are covering in this video. So this you can use it for IBS revision. If you're not having time, you can use the super fast revision for IBS. If you're having time, you can dedicate for a proper 1 week for SET A, 1 week for SET B, or at least in 1 week you can cover SET A and SET B. If you're having that much time, you can use this detailed marathon itself. So that will be helpful for you. And when you see the SET A and SET B super fast revision, we are having in English along with the Hindi plus English. So SET A and SET B, we are having English version also and Hindi plus English version also. You can check it out. And when you see SET C and SET D, for that also we are having the marathon session. This was one of the first marathon sessions we uploaded in our channel. This also has got a very good reach, along with 2 lakh plus views for SET C, and then 1,30,000 plus views for SET D. So this also you can check it out if you have not cleared SET C and SET D till now. So this will be helpful for you for covering those subjects. Now we can start the marathon session. Before that, I would like to give you one more detail. We are launching a IBS practice batch, which is exclusively for IBS purpose. Many CFN students, they know they are having the IBS, but they do not know the exact method, what they have to follow so that they can short clear IBS. That way I'm going to give it to you in this IBS practice batch. You will get the proper guidance in this practice batch. Now we can see the details of the practice batch. After that, we can start the marathon session. Now I will tell you about the IBS practice batch. So this is a very important batch for all CA final students. Everyone are going to write IBS, but most of you will not have the detailed idea about the IBS. What you have to do, everything you will not know in detail. So that I can tell you now, and I will tell you what is the problem in IBS. IBS is not a conventional paper. You will not be ready for that. Normally all the paper you will be able to write, but IBS when you see it is a very differently designed paper, and for that you need to think differently if you want to crack the IBS. Normal approach will not work. If you think that I will master all the subjects and I will write the IBS, I will clear, that is not going to happen. You need some different strategies so that you can approach this IBS paper properly, and then you can get the good marks in this. Many people are not able to clear the exams because of this IBS paper itself. So that is the reason why this paper requires the attention properly. And here first I will tell you what is the problem in IBS. When you see IBS, in that we are having a lot of resources to prepare, but we don't know what to do. And the main problem in exam is that we don't get the proper time to solve the questions, and then we don't know the order, which question we have to attempt first, which type of question we have to attempt first. In this itself we are having a lot of types of questions. They are designing questions of different types, and some type of questions, some category of questions, they take less time to solve, and some category of questions they eat away your time. So you have to choose wisely and prepare and present those questions. You have to write those questions first, which give you the most marks in less time. So like that we are having a lot of points in this IBS that all will be covered in this practice batch. I will be telling everything for that in this practice batch. What are all the tips and tricks that you can do, what are the strategies you can use, even if the toughest paper comes, what you have to do so that you can secure safely some 15 marks, that I will be telling you in this practice batch. Even in the toughest paper, this batch will guarantee you 50 marks. So I'll be just giving you the overall details. We will be covering the entire details. We'll be giving more details about how it will be happening, what will be there. Entire thing will be covered in a separate launch video. Stay tuned for that. So just I will give you the introduction of what will be there in this batch. We'll be doing some 15 case studies, writing practice. I will be doing the writing practice along with the timer. So you have to do with the timer. Only then you will be able to keep a track of the time. Second thing is that we will be doing the approach. In which approach you have to start the case study. That all you need to know. Because IBS question paper, the length is increasing attempt by attempt. So earlier it was only some 35 pages. But now it is currently 50 pages in the May 2026 exam. It is 50 pages. You should be able to read the 50 pages and you have to write the answer also. So that thing is there. So time is very important and the approach is very important. 15 case studies we are going to solve. That also from the most difficult case studies, from the PYQs, RTP, MTP, mainly from the PYQs we are going to do. And then the entire Jan 26 was the toughest attempt till now for IBS exam. So that entire question paper, all the 5 case studies we are going to solve with timer and along with the proper approach. So that is the main 15 case study solving. And apart from the January 26, that particular question paper, we are going to solve the other case studies also. From RTP, MTP, other PYQs, we are going to solve the toughest case studies along with the timer that we are going to do. And when you see, we are also having the other points. Here, when you see the total resources that you are having for IBS, we are having more than 200 case studies in IBS for that you need to practice. If you are searching for the entire case study list, you will get 200 case studies. Like you are having case study digest volume 1, case study digest volume 2, and then the RTP, MTP, PYQ, student journal case studies. Under those sources, we are having more than 200 case studies. I have analyzed all this and then come to a conclusion that not even a single question is repeating. So no need to do entire 200 case studies. I will be solving you the 15 most important case studies, and then I will be also giving you a important point, like what are all the tricky points in all these case studies. All these case studies will not be tricky. Only some points will be tricky, some points will be easy. All those tricky points we are making compilation, and that thing we will be solving. I will be telling you what are all those tricky points which you will not find usually in the study material. That point we are going to solve it separately. For that also I will be giving you a session, and that also everything will be included in the practice batch. After that, when you see we are having different types of questions like statement type MCQ, SEBI analysis questions, like that we are having different categories of questions. How to attempt those questions, everything I will be telling you in this batch. For SEBI analysis type questions, so like they are giving you a case study, you have to apply the concept like Porter's 5 forces or the vertical integration, McKinsey 7F framework, like that you are getting the concept. You have to link it with the case study, write the answer, and you should be getting the marks. That also they will be asking for 5 or 6 marks only, and you should be knowing what to write, what not to write, what are the keywords that should be maintained, everything you should know. For that also will be giving you predefined format. So that format, if you write it exactly and link it with the case study, you will definitely get the marks in SEBI analysis questions. And all this I have done by seeing the ranker paper analysis. So I have the ranker paper, the January 2026 PYQ rankers. Certified copies, actual exam certified copies I'm having, and in that I have seen some insights which the rankers are following. If you follow that, you will be getting the marks also. How they are attempting different kinds of questions, in which method you are getting the most mark. So that now I have analyzed, and I'm going to tell you that also in this particular practice batch. Along with that, you are also going to get the mock test. One mock test will be provided along with the practice batch, and that mock test you have to prepare it and you have to attempt it. Along with by using all the tips and tricks that I have told you in this batch, you have to try to attempt that particular paper. So you will get to know at what level of preparation you are currently, and the paper, when you see mock test paper, it will have the toughness similar to the January 26 and May 26 paper. So earlier, before these attempts, the IBS paper was relatively easy. But when you see these attempts, these are the standard. This is the maximum standard by which they are asking in the IBS paper. So this thing will be, the mock test will be on par with these papers. So when you do that, you will be knowing what kind of preparation you are in for the actual exam paper that you will know. And along that, we will be providing the index for all the case studies. The 200 case studies I told you, right? You cannot read the entire 200 case studies. You need to know what are all the points that are asking each question. For that, I will be giving you an index. Or for all the 200 case studies, we will be having the points. What are all the questions? What are the main points they are asking there? That point alone you can see from that index. So that you will be covering what are all that is there in the 200 case studies. I will be covering the important 15 case studies, and I will be covering all the tricky points. Along with that, I will be giving you that index also. You can refer that index so that you can see what are all the points they are asking in the 200 case studies. So that index also I will be providing. So all this will be available in the IBS practice batch. Along with that, we'll be providing the index also for each and every subject in the CA final, index for the IC study material. So all that will be included in the practice batch, and this practice batch is priced at 3,999. So this is the main point. 3,999 is a very nominal price only. So for this price, I'm going to give you all of this which I have told you till now. And in market, when you see for set A, if you are getting the lectures along with the books, you will get approximately 4,000 rupees minimum for any lecture for set A. That also will be for 30 to 40 hours only, the content. And that set A, I'm going to provide you entirely for free in YouTube. So that I'm going to I'm already providing for free in YouTube. And when you see the set A lectures without books, that also will be coming for a minimum 3,000 rupees. But when you see 3,999, this is the price that I'm offering you for all these particular things. All the things will be given to you just at this price. So, and one more thing, this will be a recorded batch. So these are all the things I would like to tell you about the IBS practice batch, and this is a very nominal price when you consider all the things that I am going to give you in this batch. So this batch we are going to conduct along with the proven strategies, everything, whatever the rankers are following. I have got the insights also from them. I will be including all those also in this practice batch. So you are getting all of this for just 3,999. So this will be the price of this batch. Even more details, what we are going to cover, everything will be in a detailed manner. Just I have given you the gist of what we are going to do. Even more things are there that I will be telling you in the launch video. So that's all about this IBS practice batch. This will be very helpful for you from this point of view of timing, what is the approach, most important points, and then the tricky case studies. Those things from this point of view, no one has launched a batch in India for IBS till now. So this is the first batch that is going to be done from this particular point of view. 30 to 35 hours of high impact content you will be getting. All those things, when you combine it, you will definitely get minimum 50 marks in IBS, even in the toughest attempt. So that's all about the IBS practice batch. Now we can start the marathon session. Hello everyone, welcome back to our channel. This video is about CA Final Self-Paced Online Modules Set A Corporate and Economic Laws. In this video particularly, we are going to see about the Securities Laws, that is the SEBI Act and the regulations. That also, we are going to cover the SEBI Act 1992 alone fully in this particular video. So the SEBI regulations we are having, right, that will be uploaded as separate videos. So this video, the main agenda is to cover the SEBI Act 1992 fully. And in SEBI Act 1992, when you see, we are not having that much concept and all. Like ECB, overseas investment, we are not having concept. In these, the concept will be there. But in SEBI Act, we are not having the concept. Just the procedural things, like what are the powers of the SEBI, and what is the Securities Appellate Tribunal, and what is the appeal forum. Like that, procedural things only are there. And I will be telling you some important ones from where the questions are being asked, and I will let you know where you have to focus on when you are doing your revision. So this is the SEBI Act video. So you can join the Telegram channel and in the WhatsApp community. There all the CFN students will be there, and all the resources also I will be sharing there only. Telegram channel and then the WhatsApp channel. You can join both of that. Even if one gets banned or shut down or temporarily one platform is not available, we will be able to connect using the other platform. So during the Telegram ban, many people were not able to get the resources. They had their exams, but they were not able to prepare properly due to the lack of resources. So when you join both of it, you will get the access to the resources at all the times. So that you have to do, you have to join both the channels. Now we can start the discussion. We can start the SEBI Act 1982. Now, when you see the SEBI Act, what is the entire thing of the SEBI Act to start? We are having a board called SEBI, Securities Exchange Board of India. It was created and it was given the powers so that it can regulate the capital market. So, it has various powers and it can give the case on you. If you are not following the rules and regulations of the SEBI and you are a stock market intermediary, then it can start a case on you. It will hear the case and it will give the punishment for you if you are not following the rules. So like that, SEBI is having various powers. If SEBI passes an order, you can go to appellate tribunal. Like that, we are having those provisions also. So like that, for SEBI, what all the powers are there, what all the scope of SEBI, and what all the penalties SEBI can give, and what is the appeal forum, and the finance accounts and audit of SEBI. Like that, we are having the procedural provisions, like what what is the thing that will be happening under SEBI, what are all the investigation powers SEBI has, what are all the powers of the SEBI, like that. Only procedural things are there in this chapter. So we are not going to do this from the study material. I am having the separate summary notes for this. So this summary notes I have prepared it. I am not having summary notes like this for each and every chapter, but for this chapter I am having it. So we can revise the SEBI Act, we can learn the SEBI Act, we can discuss the SEBI Act from this particular summary notes itself. So here when you see, we are having a summary of all the things in the study material for this particular chapter. So total 15 pages we are having, approximately 15 pages we are having. And here if you see, here it starts from the first page, and then when you see the end of the SEBI Act, it will be ending in some page. We can see how much pages it is there. So when you see here, LODR is starting. So here the SEBI Act is ending. When you see the page number, it is 51. So total 51 pages it is there in the study material, but we have summarized it, shortened it into a 15 page summary notes. So we are going to revise from that only. We are going to learn from that only. So here when you see the summary notes, we have everything in there. Whatever that is there in the study material, it has been given here. Just the language has been shortened and then it has been summarized. So here when you see, I'm not going to dive into the depth of each and everything, just a procedural thing. We can do this quickly and then we can learn the regulations in depth. The insider trading regulations, the LODR regulations, that is the listing obligation and then the disclosure requirement regulations, and then the ICAI regulations, also the substantial acquisition of shares and takeover regulations. Those regulations we can see in detail. No need to spend a lot of time in this and all. Just the penalties we are having in this chapter, there we are having a chance to get the question. So now we can start the chapter. So here when you see, everyone knows about SEBI. It is the regulator, financial sector regulator. We would have seen in the chapter of FEMA and then some other chapter also, we would have learned about the financial sector regulator. So financial sector regulator is a term used in those act and those laws. We would have explained in those laws, revision videos. Financial sector regulator like SEBI and RBI. So SEBI is a financial sector regulator. Now it was formed in this year. It was given the statutory powers in 1992. Then the act commenced on this date, 1992. I hope you all know the year. Scam 1992. It was the main reason for giving the statutory powers and all for the SEBI. Before that, statutory powers were not there. Then the act extends to the whole of India. So these are all just normal things only. Next, when you see objectives and duties of SEBI. Why was SEBI formed? To develop the securities market, to promote the development of securities market, to regulate the securities market, to protect the investors. That's all. Then features of SEBI. What are all the features? SEBI is a body corporate. Similar to all the companies, SEBI is also a body corporate. It can acquire a property, hold a property, it can transfer property, everything can be done. Perpetual succession, similar to all companies. Common seal. Then power to contract, head office will be there at Mumbai. For SEBI, the head office will be there at Mumbai at Nariman Point. Then may have offices at other places too. It can establish other places also office. So these are all the normal features of SEBI. Then when you see, we can come to the management of the board. SEBI we are seeing, right, in the SEBI who will be there? It will have the board members. The name itself, board. Securities Exchange Board of India. So when you see that, here the word board is used. So in board, obviously, board members will be there. Who are the board members? These are all the top management of the SEBI. Chairman will be there. Chairman will be nominated by the CG. CG will recommend who will be the chairman. Then two members, CG ministry. Two members will be there from the officers. They are officers from the central government ministry. Then one member will be from the RBI. Five other members will be nominated by the central government. At least three full-time members. Chairman nominated by central government. Two members from the CG ministry. One member from RBI. And then five other members. They will be nominated by CG. At least three full-time members. So this is the management of the board. These people will be in the top management of the Securities Exchange Board of India. That is SEBI. Then the general superintendents will vest in the board. The general management and all will be seen by the board only. The members will be persons of ability, integrity, standing. They will have knowledge or they will be able to solve the problems in the security market. So that such persons will be appointed here. Then when you see term of office and conditions, their appointment term, they can be appointed for a period of maximum 5 years in a single term. Maximum 5 years for a single term. After that, you can reappoint them. There is no problem. Age limit is 65 years. Not hold office after 65 years. If you attain to 65, after that you cannot hold the office. Then relinquishment, if they want to resign the office, the members, they can do it with 3 months notice to central government. Before resigning 3 months, they have to give the notice to the central government. After that, if central government wants to fire them, central government wants to remove them from the office, that also can be done, but they have to give the 3 months notice. If not possible, they have to give the 3 months salary in hand. So either they can give the 3 months notice, otherwise if you want to remove immediately, central government can give the 3 months salary and then remove them. So that is the thing. Removal of members. When the central government will remove the member? If the central government thinks that or the person is insolvent, has been adjudicated as insolvent or unsound mind or convicted in an offence involving moral turpitude, abused the position. Insolvent, unsound mind, moral turpitude, and then position. Abused the position. So you have to do the removal only after providing a reasonable opportunity of being heard. You have to hear the side of the affected person, hear the side of the member. After that only you can remove them. You have to give them an opportunity to present their problem. Then the next thing, meetings and proceedings. They will conduct the meeting and then whatever the decision that is taken, it will be taken by a majority vote. So majority of the people should vote for it in favor. Only then it will be passed. Then the chairman or the presiding member has the second or casting vote. If there is a tie, like 5-5, favor and against, if there is a tie like this, then the chairman will come and then the chairman will do the second vote or the casting vote. He will do the voting to decide the things. Then in the case of a tie, he will do that. Then member not to participate. If a person, a board member, here we are having the members, right? If those members have pecuniary interest or they are having some monetary interest, they are having the, what we can say, like self uh, self-interest threat. If they are having their interest, they are having a monetary interest in the company or some other entity in which regarding which the case is concerned, they are investing a case and an entity which is related to the case, that entity is controlled by or that entity has given share capital or that entity is beneficial to the particular member in the board, then that particular interested member, we can call them as interested member, that interested member should not participate in the proceedings for that particular case. Then they cannot participate in the decision also for that matter. Then, so we saw that we are having the composition, like one chairman should be there, two members should be there from the field ministry. So in this there is a defect. If there is a problem in this, like one member from RB that is not present when they are investigating a case, or out of this only one member is present from the CG ministry when they are investigating a case. Because of that, because of this defect in the constitution, it will not affect the case thing, like it will not affect the order and all. SEBI will investigate the case and it will give a final order. That order will not be affected by the constitution, by the defect in the constitution. So that's what they want to tell here. Even if there is a defect here, it will not affect the order of the case. The proceedings will not be invalidated. Even if there is a vacancy or there is a defect or there is a irregularity in the procedure, but it is not affecting the case. There is a problem in the procedure, but it does not affect the case. Then defect in appointment of person. One person was not appointed properly, like the procedure was not followed properly, then also it will not affect the proceedings and all. Then powers and functions of SEBI, it can regulate the stock exchange. Here this thing is not that much important, you can just give a reading. So here, however, we are not having a descriptive paper and all in CTA. Just you have to give a reading so that you will know what all the powers in general. And in IBS also, if they are asking, you can easily take the book and write it. So no need to mug up this line by line. They will regulate the stock exchange. They will regulate the investment advisor, portfolio manager. All the persons should register with SEBI. Depository, custodian, FII, credit rating agency, everyone will be regulated by SEBI. Then venture capital fund, collective investment scheme, self-regulatory organization, this all will be regulated and registered by the SEBI. After that, fraudulent and unfair trade practices, it should not happen. Insider trading should not happen. This should be ensured by SEBI. SEBI will take care that these things are not happening. Then investor education, intermediary training. Then for takeover of company, the SEBI will give the regulation. They can call for information. They can demand for information. They can do the inspection, they can conduct the inquiry, they can audit the stock exchange or the intermediary and associated person. The next point is calling for information to furnish it to other authorities. They can demand you to provide the information to other authorities other than SEBI. The authority may be in domestic country or in foreign country, but when you want to furnish the information to foreign authority, you have to get the central government approval. SEBI has to get the central government approval. Then they can levy fees for other charges, they can conduct research. So like that, we are having a lot of powers and functions in general manner. Then inspection of books and records. Power of inspection. Listed company or company proposed to be listed. Listed companies are under the scope of SEBI. SEBI will regulate the listed companies, and if you are a company proposed to be listed, you are going to be listed, then SEBI has a doubt that you are doing insider trading or you are doing unfair trade practices and fraudulent practices. Then SEBI will order an inspection of the books or documents only if it has reasonable grounds to believe, only if it should have some evidence. Some evidence should be there on a prima facie basis to get the doubt that you are doing this wrong things. Then power of the board. They can discover the discovery and production of books of account and other document. They can demand you to produce the documents. Then they can summon the people, they can enforce the attendance. You have to come compulsorily, you have to attend the meeting compulsorily, you have to attend the investigation compulsorily. So that power is there with SEBI, similar to a civil court. Then inspection of books, registers, issuing commission for the examination of witness or documents. So they can issue a commission. Like, what is the meaning of issuing a commission? Is they are appointing a commissioner, they are appointing a person for examination of documents. He will examine the documents and give the observation to the court. Or it will also give it, the person will also give it to the SEBI board. Then they can do the interim measures when the investigation is going on. Now they want to preserve the status. Now they want to maintain the same status. For that, they can give us some temporary orders. These are some temporary measures. They can suspend the trading. They can restrain the persons from accessing the market. They can place a ban on some people that they should not do the trading in the market for a specified time period. Then they can suspend any person. They can impound and retain the proceeds or securities. They can take the securities under their custody. Then they can attach bank accounts and other property for a period not exceeding 90 days. They can attach the properties for 90 days. Then they can direct any intermediary or any person to not dispose of or alienate an asset. You can give instruction to an intermediary, like a stockbroker is here. You can give instruction to them that you should not sell this asset. That asset is there with you, you should not sell this. That you can give it. That direction can be given by the SEBI to the broker. Then Measure 456, impounding and retaining the proceeds, attaching the property, and then not to dispose of the asset. When these orders, you are giving it to a listed public company or a company going to be listed, then it should be only based on the reasonable grounds to believe that the company is doing insider trading or fraudulent and unfair trade practices. So, when you are doing these measures on a listed public company or a company going to be listed, then you should have the doubt that this kind of things are happening in the company. Then the attachment you're doing, you are attaching the property, that you should get the confirmation from a special court. Then the board should give an opportunity of hearing before or after passing the order. This interim order, before passing it or after passing it, you have to give the opportunity of being heard to the concerned person. Then disgorgement of fund. The meaning of disgorgement is that, for example, you made some unfair trade practices or you made some insider trading. Then you got a gain of 5 crore rupees because of that. Then if SEBI gets to know that, then they will ask you to repay this money. They will ask you to repay this 5 crore money so that you will not enjoy the benefits of the insider trading. So that is the meaning of disgorgement of funds. That will be credited to the investor protection and then the education fund. Then we are having some powers of the SEBI under Securities Contract Regulation Act. That also they have given here. The SEBI can call for the returns. They can ask the persons to file the returns. Then they can do the direct inquiry. Periodical returns will be required. Then inspection of books can be done. Information or explanation can be demanded from the persons. They can do the inquiry. Then they can ask the persons to produce the documents. So this and all can be done by SEBI. These powers are given under Section 6 of the Securities Contract Regulation Act. This and all just give a plain reading. No need to mug up and all. We should know what are the general powers of the SEBI under various places. Then stock exchange. Like stock exchanges will have bylaws. That bylaws will be normally created by the stock exchange only. But sometimes it should be created by SEBI also. The bylaws should be created only after the previous approval of the SEBI. But sometimes if SEBI wants to make some bylaws on its own, they can also create the bylaws. They can also make the bylaws that will be applicable on the stock exchange. That the stock exchange has to follow. It will be treated as a normal bylaw only. Bylaw means the instructions in the stock exchange that should be followed by everyone who are dealing in that stock exchange. Then licensing of dealers in securities. It can give a license to deal in securities for some persons. Then when some persons want to do the public issue or they want to list the certain securities, then this SEBI can get their information and allow them to do the listing or the public issue only if they follow the certain criteria. So that also can be done by SEBI. Then central government has some powers. The central government can delegate the powers to SEBI or RBI. That also they have given here. Then other functions. That also we are having. Then when you see the next point is about the regulation or prohibition of issue of prospectus. SEBI thinks that some company is not good, so they can ban the company from issuing the prospectus. They cannot issue the prospectus. Then they cannot do the issue of shares. So like that they can give a ban or they can give some conditions. The company, when they are issuing the prospectus, they have to follow these conditions. So that power is there with SEBI. After that, we are having the point of collective investment scheme. So what is the meaning of collective investment scheme? The investment scheme will get the payment from the investor. It will receive the money from the investor. They will combine it, they will gather it, and then they will make the investment with a view to earn the profit, income, or property. They are doing it for getting the returns. They will manage the property on behalf of investors. The scheme managerial personnel, they will manage the scheme on behalf of investors. The investor will not have the day-to-day control of the scheme. Then such other condition may be specified. If the collective investment scheme follows these conditions, then also it will be called as a collective investment scheme. Like that, the conditions may be specified by SEBI. Then any scheme not registered with SEBI and not covered under exception. So this is the meaning of collective investment scheme, and we are having some exemptions. These are all, even though it resembles the collective investment scheme, but they are not the collective investment scheme. These are all not the collective investment scheme. That list we are having. And some scheme is there, it is not coming under the definition and it is not registered with SEBI, it is not covered under the exception. But when you see that the amount, the corpus amount, the collected amount from the investors, that is the corpus amount, it is 100 crore or more, then it will be deemed CIS. It will be considered to be CIS. We will not check the condition at all. It will be deemed to be a collective investment scheme. Now, what are all the exceptions? Schemes offered by cooperative society or non-banking financial companies or insurance contract or provident fund contract, then Companies Act, when you're accepting the deposit under Companies Act, when you're doing an Nidhi or mutual benefit society, you're doing chit business, then when you're subscribing to a mutual fund, then central government notified scheme, then this scheme will not come under the collective investment scheme. Then when you see the power to issue directions and levy penalty, SEBI will issue the directions that should be followed by everyone. And that direction if you do not follow, the SEBI will levy the penalty. So for what they will give the direction? For protecting the investor or to stop the actions to be done in a manner which is detrimental to the investor or the market. It should stop all the actions which are damaging the market. Then to secure the proper management of the intermediary, for that and all the directions can be given. Then the directions should be followed. Then disgorgement can be done. If someone does a wrongful gain, SEBI can disgorge the amount. They can ask the person to repay the gain amount. Then investigation. SEBI can do the investigation if it has reasonable grounds to believe that transactions are dealt in a manner detrimental to the securities market. You are doing the transaction, that transaction is damaging the security market. It is damaging the trust. So in that manner, if the SEBI has an opinion, then it can order investigation. Or else, intermediary or a person associated. Intermediary means stockbroker. Those people and all will come under the stock market intermediary. Person associated with the stock market. This will cover all the general people who are there in the stock market. If these persons violated the act, rules, regulations, or direction, then SEBI will order the investigation. Then SEBI can order them to produce the documents that we are having, custody of documents. The investigating authority will be appointed by the SEBI for that particular case. The investigating authority can keep the documents in their custody for 6 months. When they are having an investigation for 6 months, they can keep the documents in their custody. This timeline is important. Then, when you see the investigating authority can ask some persons to give the oath and examine them. Like they will ask a promise, whatever you are saying that is true. Like that, the person who's being investigated, that is the person who's doing the wrong transaction, that person we will examine him on a promise. Then whatever he is telling, that can be used as an evidence against him. It will be recorded also. So like this, we can do the examination on oath. This is also one more power with the SEBI. Order of court to seize the records. Now, the investigating authority has some reasonable grounds to believe they are having some evidence, they are having some information that the records, the books of accounts, they are getting destroyed. Some intermediary is doing a wrong transaction and he is destroying the accounts. He is mutilating the accounts, altering the accounts, falsifying, secreting like that. He is damaging the accounts. Now, the investigating authority should apply to the magistrate or the judge of the designated court in Mumbai. After that, he can enter, search and seize the record after getting the permission from the magistrate. After seizing the records, if you are seizing the records for a listed company or if it is a company proposed to be listed, you can do this. You can seize the records only if you are having a doubt that the company is engaged in insider trading or market manipulation. So this seizure of records, you are breaking into the building and then you are taking the records, and that you can do for a listed company or a company proposed to be listed only if you have doubt that it is engaged in insider trading, market manipulation. Then if you do not comply with them, failure to produce documents or failure to give information or failure to appear or failure to sign the notes of examination, then they will give you imprisonment up to 1 year or fine up to 1 crore or both. Further fine also they can give 5 lakh rupees every day for the failure when it is continuing. So that is the power. Cease and desist proceedings. What is the meaning of cease and desist proceedings? When SEBI gets the information, for example, a stockbroker is doing an illegal activity. Now, SEBI gets the information before doing the illegal activity. Either when he is doing the illegal activity or before doing the illegal activity, SEBI gets the strong proof that he is going to do the illegal activity or he is currently doing the illegal activity. SEBI has the proof. Now, they will order that the person should cease and desist. The meaning that the person who is doing the illegal activity, he should immediately stop the illegal activity. Like it is like a pause. You should not do the activity now. So after this order, if you carry on that activity, you will be imprisoned. So like that, that is a cease and desist order. It is an immediate order to stop all your activities which you are doing, the illegal activity. So if the board finds after an inquiry, they are conducting an inquiry, after that they are getting the information that any person is violating the act or it is likely to violate the act, he is going to violate the act rules regulation, the board can pass this order. If you are passing this order against a listed company or company proposed to be listed, then you should have evidence or primary evidence that the company is going to be doing the insider trading or market manipulation. So whenever you are passing any order to what we can say, do search and seizure or cease and desist, or you are passing any other order against a listed company or company proposed to be listed, generally it should be only when it is carrying out insider trading or market manipulation or fraudulent and unfair trade practices. Only then you can take action, strict action against the listed companies and companies proposed to be listed. Then registration certificate. All the stock market intermediaries should get the registration and have the registration certificate with the SEBI. Traditional intermediaries like stockbroker, sub-broker. This is the list of the intermediaries that we are having in stock market. Stockbroker, sub-broker, share transfer agent, trustees of trust deed, registrar to an issue, merchant banker, underwriter, portfolio manager, investment advisor. Then other notified intermediaries also we are having. These are all the traditional people. Now depository participant, custodian, foreign institutional investor, credit trading agency. All these people are the stock market intermediaries. They have to get the registration with the SEBI. Then fund and trust like venture capital fund, collective investment scheme, including mutual fund, alternative investment fund, business trust. These people should get the registration from SEBI. They are also regulated under the SEBI only. They are all different types of investment vehicles. People, they are collecting money from the people, so they have to get registration from the SEBI. Then the application, what manner you have to give, what form should be the application form, then fees, everything will be in the regulations. The SEBI can suspend your registration or cancel your registration if they have the evidence that you are doing something wrong. Then they have to give the reasonable opportunity of being heard. After that, they can do the cancellation or suspension. So that point is completed. The next point, when you see prohibition of manipulative and deceptive devices, insider trading, substantial acquisition. So for insider trading, they're having the regulations. You should not do the insider trading, but if you're doing the trading, it should not be done by an insider or with the insider information. So for that, we are having the regulations that you have to follow. Substantial acquisition and takeover. For that also, we are having the regulations that you have to follow. If you are following the regulations, there is no problem. Insider trading, you should not do it. Then manipulative and deceptive ways, that also you should not use it. So that is the thing they have given here. You should not employ any scheme so that you can collect the money from the investors and defraud them. So that kind of things you should not do it. Then now we are having the main penalties part that we can see in the last. I will complete the rest of the chapter. Now we can see the penalties. So this penalty is also important, but I'm keeping it for last so that we can do it at last. General penalty also we are having. Then from here we have to start. Power to adjudicate. Whenever something is happening, the SEBI will investigate and it will pass the order. It will pass the order through the adjudicating officer. The adjudicating officer will be appointed by the board and he will give the penalty under the section 15A to 15HB. So section 15A is the starting section of the penalty. Section 15HB is the ending section of the penalty. So the penalty will be given by the adjudicating officer. The penalty will be levied by him. The adjudicating officer can summon the attendance, can require production of documents. They will pass the order only after providing the reasonable opportunity of being heard. Then the board, SEBI can call for and examine the records of the proceedings. When they are conducting a case by the adjudicating officer, the board, the top management, they can call for the information about the case. Then if they think so, the penalty is low. They think that the penalty is low for the particular case. Then what they will do is they will increase the penalty. For example, the adjudicating officer gave a penalty of 10 crore. Now the SEBI is coming in, they are calling for information, they are reviewing the case. Then SEBI, if they think that 10 crore is very less amount for this particular fraud, they will increase the penalty to 15 crore. Like that, they can increase the penalty. Then they can do the enhancement of penalty within 3 months from the date of the order passed or the disposal of appeal, whichever is earlier. So 3 months from the date of order passed, this we can remember. The order passed by adjudicating officer within 3 months, they have to do the limit enhancement, the penalty enhancement. So after 3 months, you cannot do the enhancement. Then when you are giving the penalty, how much penalty to give? Like 10 crore penalty we can levy, or 15 crore penalty, or 100 crore penalty. How you will decide this amount? You will decide it based on the amount of gain or unfair advantage. By doing the illegal activity, how much gain the person achieved. So that you have to keep it in consideration. Amount of loss caused to investor. For example, in very big scams and all, thousands of crores. Loss will be borne by the investor. So that you should keep it in mind. Repetitive nature of default. If you are doing it for the first time, it will be lesser penalty. If you are doing it repetitively, multiple times you are doing the same mistake, then the penalty will be increasing. Then the penalties that they are collecting, that will be credited to the Consolidated Fund of India. Then settlement of administrative and civil proceedings. If you are not following any procedure properly, because of that, you are getting some penalty, you are getting some case. You are getting some case which is going to be investigated by the adjudicating officer. Now you can come for the settlement. You will try to make the penalty, all the payment you will do, and you will drop the case. You will ask the department to drop the case, and I will make payment of all the penalties, everything. After making the payment, they will drop the case. So that they have given here. Then Securities Appellate Tribunal. After completing the investigation under the adjudicating authority, the adjudicating officer will give the order. After that, you can go for appeal with the Securities Appellate Tribunal. Now, this is the appeal forum. So, the Securities Appellate Tribunal will be established by the central government. Then, it will consist of a presiding officer. One presiding officer, judicial members will be there, technical members will be there. Presiding officer, judicial members, technical members. Presiding officer, only one person will be there. This can be increased, not just one. There can be more than one. Then, bench. They will have various benches in the Securities Appellate Tribunal, and in every bench, at least one judicial member should be there, one technical member should be there. In one bench, one judicial member should be there, one technical member should be there. Then the bench will sit at Mumbai. They will conduct the proceedings at Mumbai. They can also transfer the member from one bench to another. They can transfer the member. That's not just procedural things. When you say qualification, presiding officer is the main one. He's like the chairman. Now he should be a judge of the Supreme Court, or chief justice of a high court, or judge of a high court. So he should be a judge of the Supreme Court, or judge of the High Court, or Chief Justice of the High Court for at least 7 years. Only then we can appoint him as the presiding officer. Then when you see the judicial member, 7 years we are having that. Judicial member, when you see, he should have been a judge of the High Court for at least 5 years. So judge of the High Court for 5 years. That is the judicial member. Technical member, when you see, he can be a secretary or additional secretary in a ministry of central government, or he should be a person with professional experience, with 15 years experience in the financial sector. So you can hire a person with experience of 15 years, or secretary or additional secretary from the ministry. Then when you see appointment process, the presiding officer and then the judicial member will be appointed by the central government by consulting with the Chief Justice of India. Central government and then the Chief Justice of India will appoint the presiding officer and the judicial members. Technical members will be appointed by the search cum selection committee. In this committee, the presiding officer will be there. These people will be there. Secretaries from the Department of Economic Affairs, Department of Financial Services, Department of Legislative and Legal Affairs. So those people will be there in the selection committee. They will select the technical members. Terms and conditions. So term is the duration of tenure, duration of the post, the tenure of the post. The presiding officer and then the members, they will hold the office for a term of 5 years. Their term is 5 years, and they can be reappointed for another term of 5 years. First, they will be appointed for 5 years. Again, they can be reappointed for another 5 years. Then 70 years is the retirement age. Earlier we saw that for the SEBI top management, the retirement age is 65. Here the retirement age is 70. After attaining 70, you should not hold the office. Then salary and terms, it will be provided in the regulations at all. There is no problem. Then removal and disqualification. So if a person is a member or part-time member of SEBI, a person is a member or a part-time member of SEBI, he is a member of the IRDA, Insurance Regulatory Development Authority, or he is a member of the PFRDA, Pension Fund Regulatory and Development Authority, or he is a member of the member in a senior management level equivalent to the executive director in these authorities. He is at the top management level equal to the executive director. Then when he is in the job, when he is in the job, he cannot be appointed as the appointed in any post in the Securities Appellate Tribunal. And after he leaves the job, 2 years cooling period. After that only he can join the Securities Appellate Tribunal. So for 2 years they cannot be added. Then validity of the proceedings. So earlier we saw that even if there is any problem in the constitution, there is a less number of members that will not affect the case investigation and in the case order. So that point they have given here also. Then resignation. The presiding officer or any member can give the notice to the central government, and then they can do the resignation. So the resignation becomes effective at the earliest of 3 months from the notice of from the notice receipt, a successor entering office, or the expiry of the term. So here when you see, the notice is there. You are providing the notice on one date. We will take 3 dates. First one is 3 months from the notice. From the notice, 3 months we will take. Second one, successor. Third one, expiry of term. So when you see, you are giving the notice within 3 months. For 3 months. So notice you are giving after 3 months. The last date in which the 3 months end, that date will be your date of resignation that will be effective from that date, or before that the successor comes, the new person who's going to be appointed in your post after you. Then if that person comes earlier itself, then you can resign from, then you can go away from that date. Or else if your term expires before itself, then you can go away from the term expiry date. So like this 3 dates we are taking, the earliest we are taking. Which comes first, that date we will take. From that date your resignation will be effective. You are resigned from that date. So that they have given. Then removal. An inquiry made by a judge of the Supreme Court. After that, the central government will remove the member. So they are giving an offence involving moral turpitude. If the member is convicted, then they will remove the person, or he has abused the position, or he has a financial interest which is prejudicial to his functions. So he has a financial interest in the company. Because of that, he cannot do the work properly. He will be, what we can say, he will have a conflict of interest. So in that case also, we can remove the person after an inquiry made by the judge of the Supreme Court. They can fill the vacancies. So that point also they have given, just a procedural point. Then appeal to Securities Appellate Tribunal from the order of SEBI Adjudicating Authority or IRDA or Pension Fund RDA. So from these people you can go to the appeal to Securities Appellate Tribunal. You have to file the appeal within 45 days from the date of receiving the order. 45 days, that you will remember. But from the date of receiving the order, that is the most important thing. 45 days from the date of receiving the order. Then the Securities Appellate Tribunal will investigate again. They can confirm the order. They can leave the order as it is. Then modify the order. They can give an opposite order. Then set aside the order. They can cancel the previous order. So that is the power with the Securities Appellate Tribunal. Then if you are not making the application within 45 days lapsed. Now you are going with an application. The Securities Appellate Tribunal can accept if there is sufficient reason. If there is a proper reason, then they will accept it. The Securities Appellate Tribunal will try to dispose the appeal within 6 months from the receipt of appeal. So after the case go to SAT, they have to complete it within 6 months. They have to do the order. They have to give the Securities Appellate Tribunal has to pass the order only after providing the reasonable opportunity of being heard. Then when you see procedure and powers, the Securities Appellate Tribunal is not bound by the Code of Civil Procedure. Then it is guided by the principles of natural justice. They are having the same power as civil court. Discovery and production of documents, receiving evidence, issuing commission, everything they are having. Same like SEBI, they are having the powers. Difference of opinion. If they are having different opinion and there is a tie, even if there is not a tie, the matter will be decided by the presiding officer, and a decision by the majority of members who heard the case. Now the members, they are hearing the case, but they are having a difference of opinion. Now majority of the members can give a recommendation. Majority of the members can give a recommendation that we have to send this case to the presiding officer. Then legal representation, chartered accountants, company secretaries, cost accountants, legal practitioners, they can present the case in Securities Appellate Tribunal. Then no civil court can have direction over any matter in which adjudicating officer or SAT is empowered. So if a case is under the scope of SAT or adjudicating officer, then civil court cannot take up the case. The members, everyone will be considered as public servants. Then after SAT, you are not satisfied with the order of SAT, you have to go to the Supreme Court. You can go within 60 days. Appeal you can do only for question of law. Only if you think there is a question in the law interpretation, or the law is wrong, like that you are having some doubt in the law, then only you can go to the Supreme Court. If you are not going within 60 days, then extra 60 days. Original 60 days is there, extra 60 days time can be provided by the Supreme Court if there is proper reason. Then finance, accounts and audit. Central government can give grants to the board. Central government can give grants to the SEBI. Then what are all the credit, grant, fees and charge collected, other sources, where they will spend the money, salary, allowance of members, officers, employees, other expenses, that and all they will spend the money. Accounts and audit. Accounts should be maintained, and then they will prepare the annual statement of accounts also. Audit of accounts. It will be audited by the comptroller and auditor general, or the person appointed by him. It will be audited by the C and AG. Then laid before Parliament. The accounts will be laid before the Parliament. They will present it before the Parliament. Then when you see the central government oversight, central government can issue the directions. So central government will issue the directions, board should properly follow it. When central government is making a direction, before making the direction, they should ask an opinion from the SEBI. Then when you see central government can supersede the board, meaning that they can cancel the board, like they will pause the board, pause the power of the board. They will pass the power of the board, and for a temporary period, central government will do all the work of the board. Whatever the power that is there with the SEBI, that will be exercised by the central government. So that they can do. When they can do, central government has an opinion that board is unable to perform the function. Board is not doing the work. Then central government can supersede the board. They can take over the board and they will do all the functions done by the board till now for a period not exceeding 6 months. Temporarily for 6 months they can take over the board by a notification. Then what are the reasons? Grave emergency. Then in board there is a persistent default in complying with the directions. The directions given by the central government, it is not followed by the SEBI. Then default in discharge of functions, it is not doing the work properly, or there's a but as a result of that, there's a deterioration in the financial position. They are not doing the work properly. Because of that, the financial position of the board is in a very bad state in public interest. So in these cases, they can take over the board. Then, when they're taking over the board, what will happen? All the members, they will vacate their offices. They are vacating their offices effective immediately. All the powers, everything will be exercised by the central government. Then the property will be vested with the central government. The central government will exercise the property also. They will take over the property also. Then, expiry of supersession. When this particular takeover will end, then central government is creating another fresh board with all the fresh members. So, and one more thing, persons who vacated are not disqualified. Persons who vacated, right, they can also be again appointed. From them also we can take some members and appoint it in the new board. Then the supersession notification. Why they did the takeover? The full report will be presented before the parliament. The returns and report. SEBI should furnish the reports to the central government. Then SEBI should give the annual report within 90 days from the end of financial year. Within 90 days from the end of financial year, SEBI should submit the report to the central government. Annual report. The copy of annual report will be presented before the parliament. So now that's all we are going to end the session. Just some pages are remaining. When you see public servant, board chairman, members, everyone are public servants, we already saw that. Then any person, central government board officer or any employees of board, they did something to do the actions under the act. They have been given some powers under the act, or for carrying out the purpose of that, for doing their work. For doing their work, they exercised some powers and they did something. Because of that, you cannot start any case on the persons. You cannot start any case on the board, SEBI, or the employees or the officers. On anyone, you cannot start a case just because they did their work. So, if they are doing their work and in that there is something inconvenience caused or something happened that damaged your entry, that and all, the board is not responsible. So, even if there is any damage to you, you will not be able to start a case against the SEBI and all. Then, offense and prosecution. They can give the punishment for contravention, then failure to pay penalty or comply with direction. You are not paying the penalty or you are not following the direction, then you will get the imprisonment, fine and all. That information they have given. Then, no court shall take cognizance of any offense punishable under this act. Whatever the offense that is punishable under this act, any court should not take notice, and they should not file any case by themselves. Then composition of certain offences. We saw that we are having some offences. First type offence, we are having only imprisonment or imprisonment plus fine. Both should be levied. Then in that case, we cannot compound the offence. Composition we cannot do. Then type 2 offence, we can compound it. There is an option to pay only fine and get released from the case. So in that type of case, we can compound it. We will pay all the amount. Then the proceedings will be dropped. Then central government. If some kind of a problem is there, like some illegal transaction has happened, any violation has happened, and the person who did the violation or person associated with the violation, he came forward and he gave all the information to the central government or SEBI, then what will happen is that person will be protected from prosecution or penalty. We will not put any penalty to that person because this person helped us to solve the case. He gave us all the information to investigate the case. So that person will be protected. The SEBI will give the recommendation to protect this person, and central government will grant the immunity from prosecution or penalty. If immunity not granted, if prosecution already started, now this immunity we can grant only if the case not started. Till now, case not started. But when case started, we cannot grant the immunity. Till now, case not started, then we can give the immunity. Then we gave the immunity, now we can withdraw the immunity also. When you did not follow the conditions or he gave false evidence, the person who was granted immunity, he did not follow the conditions properly or he gave false evidence, then the immunity will be withdrawn. Then we will try the person also for offense. We will conduct the case on that person also. We will impose the penalty on that person also. Then when you see special court, the central government will establish a special court for speedy trial of offences under this act. For all the offences that are punishable under this act, we will establish a special court. In that only single judge will be there, who will be a sessions judge or additional sessions judge. Then all the offences under this act will be investigated under using the special court. Then from this you have to go to the high court for appeal. So that they have given. Then contravention by companies. When companies violating the act, the company and then the person in charge, everyone will be liable to be punished. So then, if one person in charge proves that I did not know anything about the fraud, I did not allow the fraud, like that, if something is proved by the person in charge, then we will leave the person in charge, we will not give any penalty. Then, if some person in charge, it was proved by someone that the person in charge also worked together to do the fraud, then in that case, we will punish the person in charge also. We will recover the amount by appointing a recovery officer. We will attach the property, sell the property. We will attach the bank account. Then we will arrest and detain the person in prison. We will appoint a receiver for management of the property. We will appoint a liquidator, receiver, and all. Like that, we will do the thing. And before recovery starts, the person alienated some assets, sold some assets for what we can say inadequate consideration or without consideration, then we can recover those property also. Like that, we are having one provision for relatives if they are transferring, then we can recover that also. Then when the person dies, the legal representative will get the liability. They have to give the property only up to the extent of the deceased estate. So the person who died, right, he will have some property. For example, if the property is 1 lakh rupees, then the liability that is there, that is 10 lakh rupees. Now the legal representative shall pay only up to 1 lakh rupees by selling the property of the died person. So that is the thing. The remaining 9 lakhs no need to pay. Then, okay, all the proceedings will be continued against the legal representative. Then central government can make the rules, regulations, everything. It will be laid before the parliament. So these are all some normal provisions they have given. So that's all about the entire SEBI Act. We have to see the penalties alone now. Now, when you see the penalties, we are having a general penalty. Like this one penalty, you have to remember minimum 1 lakh, maximum 1 lakh per day up to 1 crore. Minimum will be 1 lakh, maximum will be 1 lakh per day, and then it will be up to 1 crore. So this is the minimum penalty. This is the general penalty. Like this, you can say as the base penalty. This will be repeating in many places, in many sections. So this you have to remember. Minimum 1 lakh, maximum 1 lakh per day up to 1 crore. Minimum 1 lakh, maximum 1 lakh per day up to 1 crore. Now we can see the things. So these 4 sections when you see 15A, 15B, 15C, 15EB. So failure to furnish the information or failure by intermediary to enter into an agreement. Intermediary and all, stockbroker and all, they have to properly execute the agreement. If they are not doing that, or they are not redressing the investor grievance, the investor is having a problem, they are telling it to the company or intermediary, and the intermediary is not responding, then also it is an offense. Then default by an investment advisor or research analyst, these people are doing some default, then also the base penalty will be applicable. What's the base penalty? Minimum 1 lakh, maximum 1 lakh per day up to 1 crore. Minimum 1 lakh, maximum 1 lakh per day up to 1 crore. Then for intermediaries and funds, we are having these penalties. Default by the collective investment scheme and the mutual fund. They are carrying the scheme without getting the registration. They are not following the certificate of registration conditions. They are not listing the schemes. They are not dispatching the unit certificates to the purchaser, to the investor. Then they are not refunding the application money. They are not investing the collected money properly. Then also the base penalty will be applicable 1 lakh and 1 lakh per day up to 1 crore. Failure by the asset management company to comply with the regulations. Asset management company is not complying with the regulations properly. Then also base penalty. Minimum 1 lakh, maximum 1 lakh per day up to 1 crore. Then we are having the other types like alternative investment fund, investment trust, and then real estate investment trust, infrastructure investment trust. Now these people, alternative investment fund, infrastructure investment fund, real estate investment trust, they are not following the direction issued by the board. Then the minimum will be 1 lakh. The base penalty not now. Now we are having a special penalty. Minimum is 1 lakh. Maximum will be higher of these two amount. A amount 1 crore, B amount 3 times the gain made out of such failure. They did the failure right. Because of that they got some gain. 3 times the gain amount. Out of this we will take the higher. Minimum 1 lakh same. Maximum will be higher of 1 crore amount, and then second one 3 times the gain made. Now, when you see default by the stockbroker, here we are having 3 things. Failure to issue the contract notes, failure to deliver any security or making the payment, or charging excess brokerage. There are percentage for the brokerage. You should not charge more than that. So, failure to issue contract notes, minimum 1 lakh, maximum 1 crore. Here, deliver any security, make payment, base penalty. Minimum 1 lakh, maximum 1 lakh per day up to 1 crore. Then, charging excess brokerage. Excess brokerage is wrong. So, here also, minimum 1 lakh, but maximum is 5 times the excess brokerage. So, this is a special penalty. Now the next thing when you see market abuse and then takeover violation. Here when you are doing insider trading, you are dealing in securities with UPSI or you are communicating UPSI to such other person, like that you are not following the insider trading regulation. Now what you have to do is that the penalty will be not less than 10 lakhs. Minimum is 10 lakhs, but the maximum amount is higher of 25 crore or 3 times of the amount of profit made. So minimum is 10 lakh, the maximum will be higher of higher of A 25 crore, or B is the 3 times the amount of profits made. Minimum is 10 lakh, maximum is higher of 25 crore or 3 times the profit made. Now, non-disclosure of under the takeover regulation, you are doing some default. Then also same thing. Minimum 10 lakh, maximum will be, here it will be 25 crore or 3 times the profits made. Same thing. Here for insider trading and then non-disclosure of takeover. That also we are having the same penalty. Fraudulent and unfair trade practices. Here we are having the penalty. Minimum is 5 lakhs. Earlier we had 10 lakhs. Now here we are having the 5 lakhs minimum penalty. Higher will be same. 25 crore or 3 times the profit made. So here in these three, when you see for insider trading and then the takeover, we are having the same penalty, which is minimum 10 lakh, maximum will be higher of 25 crore and then 3 times the amount of profit made. And when you see the fraudulent and unfair trade practices, minimum will be 5 lakh, maximum will be same like 25 crore or 3 times of the profit, whichever is higher. Then penalty for digital and record keeping misconduct. If you're tampering with the database, if you're not maintaining the database properly, you are altering the database, destroying the database, you are introducing computer virus to corrupt the database, then in that case, minimum will be 1 lakh, maximum will be higher of 10 crore or 3 times the amount of profit made. Higher of 10 crore or 3 times of amount of profit made. That will be the maximum amount. So this penalty you have to remember. Now, general penalty. For any other offense where the penalty is not given, you have to take the penalty as minimum 1 lakh, maximum 1 crore. So the base penalty you have to remember that will be applicable in many cases. And when you see some special penalties, you have to remember that when you do writing practice, when you are preparing for CTA, this you have to remember it. So when you do writing practice like 1 or 2 times, you will remember the penalties easily. There is no problem here because they are asking some 1 or 2 questions from the penalties. So that's why I am covering the penalties also. Now we have completed the entire SEBI Act. Now we have completed the topic successfully and we have reached the end of this video. So that's all about this chapter. We have completed it fully. We have done the full coverage and I have also given you the important points. Wherever they are asking the questions, I have also mentioned it along with the explanation. So that's all for this video. If you found this video helpful, share this to your friends, subscribe to the YouTube channel, like this video and leave a comment whether you like it or not, what are the suggestions that you can tell and what are all the things that you are having the doubt and what topics for which you need the next videos. That also you can mention it in the comments. I will try to make videos for those also. So all the best for your exams. Prepare well. Thank you. Now we can start the SEBI LODR regulations. So in the SEBI LODR regulations, we are going to see that, and this will be applicable to the listed entities. So what is the meaning here is that listing obligation and disclosure requirement. When you are becoming a listed entity, when you are listing your shares or the specified securities, like when you're listing your specified securities in this list, when you're listing it on a stock exchange, you have to follow certain regulations. You will be regulated by SEBI. The moment your stocks are listed, you will be regulated by SEBI. And SEBI has given regulations that you have to follow. That is the listing obligations. When you're doing the listing of your securities, you have to follow certain obligations. Then disclosure also you have to give. So for that, we are having this regulation. Then the next thing, when you see the applicability they have given, that is not relevant for us. Now we can start to see the regulations one by one. So when you see the regulations, we are having substantive provisions. The main regulations we are having in the main body of regulations, and then the procedures and all we are having it in the schedules. The first regulation is regulation number 17, which talks about the board of directors. So the board of directors of the listed entity. Everywhere you are going to talk about the listed entity only. The entity that is listing the specified securities in the stock exchange. Then the composition of the board. What will be the what we can say, the members of the board. Who will be the members of the board? When you see here for a listed entity, the board shall have an optimum combination of executive and non-executive directors. So executive, non-executive, that should be in an optimum combination, and not less than 50% of the board shall be non-executive directors. So 50% of the board should be non-executive directors. That is a minimum requirement. Minimum 50% should be non-executive directors. Then at least one woman director should be there. So for the listed entity, at least one women director should be there and 50% should be non-executive director. So this is the first requirement. Then if your company is in top 1000 listed entities, then at least one independent woman director should be there in your board of directors. So this is what they have given as the requirement. Then where the chairperson is a non-executive director. So here we are having two cases. Chairperson, either he is an executive director or he is a non-executive director. So this is a safer side. This is a little bit dangerous side. So when you see, when you are having a non-executive director as a chairperson, then you have to keep 1/3 of the board as independent director. When non-executive director is the chairperson, you have to keep 1/3 of the board as independent director. But when executive director becomes the chairperson, you have to have 50% of the board as independent directors. So here if you see non-executive director, 1/3 should be the independent directors. If it is not a non-executive chairperson, that is he is the executive director, at least half must be independent directors. If you are keeping the chairperson as an executive director, you have to appoint more independent director. Here 33 independent director will be there for 100 the percentage. Here 50 independent director should be there out of 100. So the percentage when you see here it is higher. When you keep executive director as chairperson, you have to appoint more independent director. Then the next thing when you see when the chairperson is a non-executive director only, but he is related to the promoter. He is related to the promoter. Then also you have to keep 50% independent director. So then also the same thing here. Non-executive director, chairperson, 1/3 should be independent director. Executive director becomes the chairperson, 50% should be independent director. Non-executive director only, but he is related to the promoter. Then also you have to appoint 50% as independent director in the total number of members in the board of directors. Then when you see the board of directors of top 2000 listed entities comprise not less than 6 directors. For the top 2000, they have to have minimum 6 directors. So that is one more point. Then here when you see for a listed entity, any person who has attained 75 years, they cannot be appointed as a non-executive director. Any person who has attained 75 years, we cannot appoint them as non-executive director. So that point they have given. But if you want to appoint them, you have to pass a special resolution. That requirement they have given. So this is an important point. Age limit 75, you have to remember it. Special resolution you should pass, only then you can appoint the person who is aged more than 75. Then board meetings and quorum. How much times you have to conduct the board meetings? At least 4 times in a financial year. At least 4 times in a financial year. Then the maximum gap between two meetings can be 120 days only, not more than 120 days. The maximum gap will be up to 120 days. Between one meeting and another meeting, the gap should be only 120 days. The next thing when you see quorum, minimum number of members that should be there, only then we can start the meeting. So the quorum for every meeting, for the top 2000 listed entities, for the top 2000 listed entities, we are having one quorum. That will be 1/3 of the total strength or 3 directors, whichever is higher. So for the top 2000 listed entities, 1/3 of the total strength or 3 directors, whichever is higher. So when you see top 2000, 1/3 or 3 directors, whichever is higher. So that you have to follow. Then when you see at least one independent director should be there in the top 2000 listed entities for quorum. Top 2000 listed entities, at least one independent director. Then review of the compliance report. The board will periodically review the compliance report of all the laws. Whatever the laws that is applicable to the company, whether they are properly following it or not, for that will be revealed in the compliance report. That will be reviewed by the board of directors. Then the evaluation of the independent directors shall be done by the entire board of directors. The entire board will be doing the evaluation of independent directors. Then in that what they will evaluate? They will evaluate the performance, whether they are performing properly. Why we are keeping the independent directors in the company? Because they will give us some valuable insights. When they are independent, they will not be biased. They will be unbiased. And these independent directors, they will be having years of experience. And those people, we are keeping them in our board so that we will get valuable insights about the industry and what we can do, and they will give us various ideas when we are conducting the business. So for that only we are having the independent directors. Also when there is something wrong that is going on in the company, these independent directors, they will inform the outside authorities. Why they will inform the outside authorities? Because they are unbiased, they want to protect the shareholders. For that only they are inside the company. So they will not be biased, they will be the whistleblowers in some kind of. When something extremely wrong is going on with the company, they will inform it to the outside authorities. For that only we are keeping independent people as the independent directors. So when they are such persons, we have to evaluate whether they are doing the work properly. That performance they will evaluate. Then whether they are fulfilling the independent criteria. So whether they are truly independent. Independent means they should not get a high amount of money from the company. Monetary transaction should not be there. Like that, we are having a lot of conditions that we will be seeing in the Companies Act. So whether they are truly independent according to the conditions that we will be checking. So this is the evaluation of independent directors. Then the next point when you see maximum number of directorship. Maximum number of directorship means a person can be a director in maximum how many entities? One person can be a director in maximum how many entities? So that we are having the answer as 7. A person shall not be a director in more than 7 listed entities. Maximum 7 listed entities you can be a director, and maximum you can be an independent director, that also in 7 listed entities. The person shall not serve as an independent director in more than 7 listed entities. 7 is a very important number. You have to remember it. More than 7 listed entities, you cannot be a director. More than 7 listed entities, you cannot be an independent director also. The maximum number is 7 for both the directorship and an independent directorship. Then, if you are already a whole-time director or managing director in one listed entity, then remaining is you can be the independent director in not more than 3 listed entities. If you are already managing director or whole-time director in one listed entity, then the limit remaining is you can be an independent director in 3 listed entities. Independent director in 3 listed entities. That is the limit that you are having remaining. So that limit they have given here. This is one important point. Maximum number of directorship. They may ask questions from this point. And here also this point is important. This 75 years point. Also this board composition. This point is important. So this particular topic itself is important. Board of directors and then the maximum directorship in this particular chapter. Then when you see restriction of on number of memberships. So membership of the committee. So we will be having committee like nomination and remuneration committee, audit committee, risk management committee, nomination and remuneration committee, and then the audit committee. Like that, you will have a lot of committees. These committees will be established so that each committee will consist of the board of directors. We will appoint the directors only in the particular committees. They will be specially taking care of that particular work. Risk management committee means they will take care of the risk of the organization, like the financial risk of the organization or the foreign exchange risk of the organization, like that. Those risks. Foreign exchange means we are having payment. We have to do payment in dollars. Whether the exchange rate increases or not, that will be affecting us a lot. So we have to do the hedging and other strategies. That and all will be done by the risk management committee. Will be decided by the risk management committee. Nomination remuneration committee. They will be the one hiring the people for the company. So those people who are working for hiring the workers for the company, they will be hiring the employees, and then they will be deciding the remuneration of such employees. Hiring and remuneration. Audit committee, they will be supervising the statutory audit. They will be assisting the statutory auditors. They will be overseeing the financial reporting process. They will oversee the preparation and presentation of financial statement. They will make sure that adequate internal controls are there in the company. Everything will be done by the audit committee. So that is the meaning of the committees. In those committees, one director can be a member in maximum how many committees? One director can be a member in 3 committees or 4 committees or 10 committees. Like that, that number maximum we are having a limit. When you see, the director shall not be a member in more than 10 committees. When you are going to be a member, in that you can be a member of maximum 10 committees. Then, if you are going to be a chairperson, you can be a chairperson of not more than 5 committees. Maximum 5 committees allowed across all the listed entities. So here when you see the committee also, the committee will have one chairperson and the committee will have the members. In chairperson, you can be maximum 5. Member, you can be maximum 10. So when you see that here, this should be across all the listed entities. So listed entity 1, in that you are a member in one committee you are in member, and 2 committee you are the chairperson, and another listed entity you are having 2 committee membership and 1 committee chairperson. Like that, totally they will check all the chairperson, all the committee member, total they will see across all the listed entities. So that point they have given here. Now, when you see the next thing, here the companies you are counting, right, all the companies, in that what should be excluded? All the public limited companies will be included. All public limited companies will come inside. All the public limited companies, whether listed or not, that will be included. So they will see across all the public limited companies, whether it is a listed company or unlisted company, they will include the membership in the committees. And all other companies, in other companies, the private limited companies, foreign companies, Section 8 companies, those will be excluded. So they will see the committee membership and the chairperson membership of all the public limited companies, but they will not check the private limited company or foreign company or Section 8 company. Then, for the purpose of determination of limit, chairpersonship and membership of the audit committee and stakeholder relationship committee alone shall be considered. So they will see the committee membership and then chairpersonship of the audit committee and stakeholder relationship committee. Only if you are a chairperson or member of these 2 committees, they will include it in the limit. Otherwise, you can be in other committees, you can be any number of members. So you can be a member in 10 risk management committee or 12 risk management committee in various companies. That also you can do. But audit committee and stakeholder relationship committee, that only they will check. So for this limit purpose, every director shall inform the listed entity about the committee position in other listed entity and any changes. So if you are appointed as a risk management committee chairperson, then you have to inform this fact to all the listed entities in which you are a director. Then corporate governance requirement with respect to subsidiary companies. Then you are a listed entity When you are a listed entity, you are occupying a very important position in the economy. People are buying your shares. So you should be in a very, what we can say, responsible position. Now, you should monitor not only your company strictly, but also you should monitor the subsidiaries. That also material subsidiaries. Material subsidiaries and significant subsidiaries you have to monitor. In that subsidiary, mainly the important transactions that you have to take a note of it, and then you have to analyze it properly, whether the subsidiary is properly doing the transaction or not. If this subsidiary incurs a loss, what will happen? Obviously, the holding company, you, the listed entity, should contribute it. So, people will look at the group picture. Subsidiary along with the listed entity, they will look at it. Only then they can understand the financial health. Only if a subsidiary is good, the listed entity will also be good. If the subsidiary goes into bankruptcy, listed entity will try to pull it back. For that, the funds of the listed entity will go into the subsidiary. So, that risk also there. So, the subsidiary should also be properly monitored by the listed entity. Subsidiary of the listed entity should be properly monitored by the listed entity. Now we can see the regulation, how they will monitor. In the material subsidiary, unlisted material subsidiary. So here they take the unlisted material subsidiary. If that material subsidiary that is listed, then that will follow the proper regulations. Then no problem. If it is an unlisted subsidiary only, you have to check the regulations. So for a material unlisted subsidiary. Now we are having listed entity. In that we will have the board of directors. In that we will have the directors. Now out of this, one director should be appointed on the board of directors of the unlisted material subsidiary. You are a listed entity. In your company, we will have one director. That one director, we have to appoint him on the board of directors of the unlisted material subsidiary. That's all. Simple requirement. Then when you see the audit committee of the listed entity shall review the financial statements of the subsidiary company. We also said that we have to review the important transaction. Generally, the financial statements of the subsidiary company also you have to review. That requirement we are having. The minutes of the board meeting of the subsidiary, unlisted subsidiary. The unlisted subsidiary is there, right? There we are having board of directors. They will conduct the board meetings. In that board meeting, you will get the minutes of the meeting. That should be reviewed by the listed entity board of directors. This is also a very simple requirement, a monitoring requirement that should be done by the listed entity. Now here when you see what is a material subsidiary, that is one important point. What is a material subsidiary? It is a subsidiary whose turnover or net worth exceeds 20% of the consolidated turnover or net worth. Turnover, net worth you have to see. The subsidiary turnover or net worth exceeds 20% of the consolidated turnover or net worth. It is more than the 20% of the consolidated turnover or net worth. We can see one example. So here if you see we are having the consolidated turnover. For example, we can take the consolidated turnover is 100 crore. Now the percentage is 20%. This percentage you have to remember, it is very important. 20% of the consolidated turnover. What is 20%? 20 crore. Now whatever the subsidiary that has the turnover more than 20 crore, that subsidiary we have to make a list. In that list, whatever the subsidiary that is unlisted, that we have to filter it. Now, that final unlisted subsidiary list, unlisted material subsidiary list we are having, right? For those subsidiaries, these requirements will apply. Now we can see the next point. So the next point, when you see the management of the unlisted subsidiary should give a statement of all the significant transactions to the board of the listed entity. The unlisted entity, we are having the management there. That management will give a statement. What statement? They will give to whom? The board of directors of the listed entity. What will be the content of the statement? It will contain all the significant transaction done by the unlisted company. So that will be there. That should be reviewed by the board of directors of the listed entity. We already saw that all the important transactions should be reviewed by the listed entity. That requirement is coming here. What is a significant transaction? Any transaction, individual transaction or arrangement that exceeds 10% of the total revenue or total expense or total asset or total liability. Now we can take one example. We are having the total revenue, total expenses, total asset, total liabilities. We can take 10% of those, 10% of every item total. For example, we can take this comes to 10 crore, this comes to 12 crore, this comes to some 20 crore, and this comes to some 18 crore. Like that we can keep. For example, now here if you see the transaction, if it exceeds any one of the limit, if it exceeds 10 crore, if it's more than 10 crore, if it's more than 12 crore, if it is more than 20 crore, if it is more than 18 crore, we will get the lens. Now it will become a significant transaction and then we have to report it to the board of directors of the listed entity. Now more than 10 crore means exactly 10 crore is okay. So up to 10 crore no problem, up to 12 crore no problem. Exactly that amount means no problem. If it becomes more than 10 crore, that is it becomes 10 crore 1 lakh. then in that case, this will become a significant transaction. So that is the thing here. They may ask numerical questions like this also. Now, when you see the listed entity shall not dispose shares in the material subsidiary to less than or equal to 50%. Now, the listed entity is having the subsidiary. Subsidiary means 51% share capital should be there. So that is the meaning of a subsidiary. Here when you see, if the listed entity, the holding company sells the shares, then the shareholding will drop. That should not happen. The holding company can sell the shares, but the total shareholding after the sale should not drop to 50% or less. So that only they have given here. Before selling the shares, which will result in the shareholding to 50% or less, it will lose the control. Then we will no longer be the holding company. The listed entity will no longer be the holding company. If you want to do that kind of sale of shares, then you have to get the special resolution. You have to get the special resolution. After that only you can do that. Then if you are doing the sale of shares based on a insolvency and bankruptcy code as per the scheme approved by the court or tribunal, then there is no problem. Normally you have to pass the special resolution. If you are having the court or NCLT approval, then no problem. You have to disclose it to the stock exchange also. Then the most important assets in the subsidiary, we will have some key assets. That assets you should not sell it without getting the permission. The permission from the shareholders through special resolution. You cannot sell, dispose or lease the assets of more than 20% of the material subsidiary. This is the all material subsidiary, listed material subsidiary and unlisted material subsidiary. For any material subsidiary, you cannot sell the assets. More than 20% assets, you cannot sell it. For that, you have to get the special resolution. So that point also we are having here. Then where a listed entity has a listed subsidiary, then the listed subsidiary should follow it for its subsidiaries. Listed entity, we are having one listed subsidiary. Listed subsidiary, it also has many subsidiaries. Now, this will be a holding company. Listed subsidiary will act as a holding company and it will follow all the regulations for its respective subsidiaries. So that point they have given. Then they have given the corporate governance report, like what is the format of the report, that they have given under each and every heading, what should be the items, what should be information displayed, that they have given here, that you can read it by yourself. That is not that much important. Just you can give one reading. They will not ask, write the format exactly like that and all, they will not ask you. So just give a plain reading. That will be enough for that. Then here the most important part starts. General obligation of compliance. From this only the important part starts, and this thing is not important from the exam point of view, this corporate governance report. And this point we saw, right, the significant material subsidiary, significant transaction, and then unlisted material subsidiary. These points are very important. They're asking questions. In SETI also they're asking. In IBS also they're asking questions from this. Particularly the significant transaction reporting point, that and all they can test it. Then the special resolution point. This point also you have to remember it properly. When you want to do something, a major modification or a significant alteration to the subsidiary, then you have to get the special resolution. Like that you can remember it in short. Here when you see general obligation of compliance, this regulation should be followed by the company properly. For that they have to appoint a compliance officer. It should be a qualified company secretary. He will be a part of the key managerial personnel. He should be at least one level below the board of directors. Board of directors is there. You can keep the company secretary in the same level, or else if you don't want to keep it the same level, one level below. So in this level, you can keep the company secretary. Below that, you cannot reduce the rank of the company secretary. In the organizational structure of the company secretary should have a power that is equal to one level below the board of directors. It can be equal to the board of directors also, but minimum should be one level below the board of directors. Below that, you cannot reduce the rank or power or the structural hierarchy of the company secretary position. Then the complaints officer should be responsible for checking whether the provisions are followed properly. He will be reporting to board. Board means board of directors, and then the SEBI. You can take it in any manner. Then he should verify that all the correct procedures are followed. Then quarterly compliances. For every quarter, every 3 months, like January, February, March, one quarter we are having. April, May, June, we are having one quarter. Like that, for every quarter, some compliances should be done, some reports should be filed. The investor grievances report, like in the beginning of the quarter, how many investor complaint you had, and then in the quarter, how much you received, and how much you resolved, that you have to minus. And then that you will have to take the closing complaint, that you have to display separately. So that you have to give the investor complaint, investor grievance report. After that, you have to give the other corporate governance requirement report also. That point they have given. The next point, when you see, the listed entity should submit the shareholding pattern. What are all the shares that are there in the company? Who are all the shareholders? How much which person is holding how much percentage shares? Everything should be given in a detailed report to the SEBI. 1 day prior to listing of securities. For each class of securities, like for each class of equity share, for each class of preference share, or for equity share, preference share, like that, you have to give the shareholding pattern report. 1 day prior to listing of the securities on the stock exchange. 1 day prior to the listing you have to give the report, or also on a quarterly basis. This is 1 day prior to listing. Additionally, on a quarterly basis, within 21 days from the end of each quarter, you have to make this report and file it. Within 10 days of any capital restructuring or any in the capital restructuring, the change is happening more than 2% of the paid up share capital. Then also you have to give the report. 1 day prior to listing, 21 days from the end of quarter, 10 days of capital restructuring if there is a change more than 2%. Then the statement of deviation or variation. You are raising the money from public through public issue, rights issue, preferential issue. You are collecting the money from the public. You will be giving what is the purpose for which I am going to use the money. I am going to invest in an infrastructure project. I am going to do a proper contract. I have got a very big contract from the government, a tender, like that. Some purpose you will be mentioning. So for that purpose only, you have to properly use the money that you collected. For that we will be checking it. If you did not use it properly, if there is any deviation, that you have to find it out, and then the listed entity should file it as a report to the SEBI. That also we are having categories wise variation. You have to say for capital expenditure we allocated, we planned this much, but this much happened actually. This much is the deviation. Like that you have to give the category wise allocation variation. Financial result. The financial statement, the quarterly financial statement, you have to file it with SEBI within 45 days from the end of quarter. This financial statement is nothing but the interim financial reporting. We would have studied in the Ind AS, right? The same thing you have to do it and you have to submit it to SEBI. So here only the LODR regulations, we are getting the requirement to prepare the interim financial result. So according to this requirement only, we are having the Ind AS and we are preparing the interim financial statement and all. For that all the information, instructional, everything will be in the Ind AS. Then for the company for which the insolvency code, the process, that is the CRP process, we have completed and we have got a resolution plan approved. You have to file the financial result within 90 days from the end of the quarter. Normally 45 days. If you are getting the resolution plan or something like that approved under the insolvency bankruptcy code, then you have to file within 90 days. Then when you are conducting the board meeting, you have to inform it to the stock exchange, SEBI, everyone you have to inform it. So in the board meeting, normally also you have to inform it. After that, when you are doing some special business, that also you have to inform it to the board. You have to inform it to the stock exchange. Here when you see at least 2 working days in advance, you have to inform it to the stock exchange. What are the special business? You are going to make a proposal for buyback. You are going to discuss a proposal for buyback. You are going to present a proposal for voluntary delisting. You are taking away the shares from the stock exchange. You are moving away from the listing. You are delisting. You are removing the shares from listing. That is called a delisting. You are fundraising by way of issue of securities. You are planning to issue some debenture or some shares you are going to issue. Then also you have to give intimation. In the board meeting, you are going to discuss the special business like this. Declaration of dividend, declaration of bonus, alteration in the securities, alteration in the date on which the interest is being paid. So those things when you are changing, you have to inform it to the stock exchange 2 days prior to the board meeting. 2 days in advance, excluding the date of intimation and the date of meeting. So if you're doing the date of intimation, here date of meeting is there. Here in between 2 full days should be there. So that should be the intimation criteria. So the next point is when you are making such an intimation, prior intimation, you have to mention the date on which the board meeting is going to be held. That also you have to mention it in the intimation. So when you're making a record date or you're creating a date of closure for transfer books, like for dividend declaration, bonus declaration, for issue of shares for conversion of debenture, you are converting the convertible debenture. Then shares arising out of rights attached to debenture for any convertible security, merger, demerger. For that, you will give the record date. The record date will be the date on which the register of members will be seen, and then on that date, whoever is the shareholder, they will get the dividend, they will get the bonus. That is the record date. When you are specifying the record date, you have to give an intimation to the stock exchange at least 3 working days, excluding the date of intimation and record date. So here when you're having the record date, you have to have 3 working days gap. Here this is the record date. Now here 1 day should be there, here 1 day should be there, here 1 day should be there. This should be the date of intimation. You should intimate it to the stock exchange. 3 full days should be there between the intimation and then the record date. For these purpose, you are creating a record date, you have to inform it to the stock exchange. Then all the things should be changed in the website also within 2 working days from the date of change in content. So the points they have summarized and given here, the timeline they have given 2 working days for this purpose and 3 working days for this purpose. Then now the next thing is the annual or yearly compliances. Earlier we saw the quarterly financial statements filing. Now here it is the annual financial statement filing. We have to file it along with the audit report and statement of impact of audit qualifications. So what is the meaning of this statement? The statement shows that, so what is the reported figures? What is the reported figures in the financial statement that they will show, and they will show another column. What will be the another column? The auditor would have issued a qualified opinion, like he would have issued a qualified opinion or a disclaimer of opinion or an adverse opinion, like that. Some opinion with a qualification would have been issued by the auditor. Now the management will re-prepare the financial statement based on the qualifications. So if they amended the financial statement as per the qualifications of the auditor, then what would be the amended figures that they will present? So these two they will present, and the variation also they will present. This will be the statement of impact on audit qualifications. Impact of audit qualifications. So that will be the statement. The reported figures, actual figures which they reported, and then the figures which would be the output if they amended the financial statement as per the auditor's recommendations. So that will be the two figures that they will be giving. So that will be there in the statement. Annual report. They will also submit to the stock exchange and they will publish on the website. What they will publish? A copy of the annual report which they are sending to the shareholders. For every listed company, they will prepare an annual report. Like Reliance Industries Limited, they will prepare an annual report every year for every financial year. So that report you can easily find it in the Google itself. So that report they will submit to the stock exchange. They will also publish it in the website. If they are making any changes to the annual report, then they will send the revised copy along with the explanation not later than 48 hours after the AGM. After the AGM, you are doing some changes. After AGM, 48 hours you are having the time. Before that, you have to send the revised copy along with explanation to the stock exchange. So that is the annual or yearly compliance. Now the next thing is corporate governance. Now, in corporate governance, when you see the compliance report on corporate governance, you have to give the quarterly compliance report within 30 days from the end of quarter. The annual compliance report, you have to give it within 6 months from the end of the financial year. You can also submit it along with the second quarter report. That also they have given here. Now, this is the timeline you have to remember. Quarterly compliance, 30 days from the end of quarter. Annual compliance, 6 months from the end of the financial year. This compliance report, you have to file it within this timeline. The next thing is related party transactions. Now we can start the topic of related party transaction. Now in related party transaction, this is an important topic in SEBI LODR, and in the Companies Act also, they are having the related party transaction topic. That is also an important one only. In exams in CTA and IBS, they are asking questions from this related party transactions many times. So this part is important, whether in Companies Act or in SEBI, this is important part. That is the first point in this topic. The next is the point when you see the related party definition. In Companies Act, we are having a related party definition. The same thing will be applicable in SEBI also. Along with that, additionally, these people also will be there in the related party. So first we can see the Companies Act definition. Here I will not be giving the explanation for each and every point. Just some points I will tell you the explanation. Rest you can read by yourself. So this is a normal related party definition only. A director or a relative. For a company, the director will be a related party. Relative will be a related party. Director's relative. Then KMP or his relative will be a related party. A firm in which the director, manager or his relative is a partner. So a partnership firm we are having, in that the director is a partner. Then the firm will be a related party. The manager is a partner. Then the firm will be a related party. If the director's relative is a partner, then also the firm will be a related party. Manager's relative is a partner. Then also the firm will be a related party. Then a private company in which the director is a member or a director. The manager is a member or a director. Their relatives also a member or a director. If any one of these things happens, then the private company will be a related party. Then a public company in which the director or manager is a director and holds along with the relatives more than 2% of the paid up share capital. The director or manager of our company is a director in a public company. Now, in that public company, the director or manager, along with their relative, they are holding more than 2% of the paid up share capital. Then also that public company, it will be a related party to our company. So like that, we are having a lot of definition points here. Remaining you can read it by yourself. So these are all normal points only. You can read it. So that's all the related party definition. Additionally, this is the normal Companies Act definition. When you see the additional points, the person or entity forming part of the promoter or promoter group of the listed entity. So we are having a listed entity. For that listed entity, if there is a promoter individual, promoter is an individual, the person who started the company. Then the persons who's related to the promoter, like his relatives, those people will come under the promoter group. Then the listed entity will have some holding company, will have some subsidiary company. Those companies also will come under the related party definition. Now, for the listed entity, if the promoter is a holding company, then the listed entity will have the holding company as a related party, and then the subsidiary companies of as the related party. The holding company will have other subsidiary companies. That subsidiary companies will also be a related party. These all will come under the promoter group companies. So those companies will also be the related party. Then any person or entity holding equity shares of 20% or more or 10% or more in the listed entity. So in our listed entity, some person he is holding 10% or more or 20% or more equity shares, holding equity shares. Then that person will be a related party. And if 20% or more is there and then 10% or more, it is with effect from 1st April 2023. So this also will be there. Those people will also be the related party for the listed entity. Now what is the meaning of a related party transaction? Here one more point. This definition will not be applicable for mutual fund units. That they are giving another point. The next thing when you see, what is the related party transaction? So, on one hand, the listed entity will be there. On the other hand, related party will be there. That's all. Any transaction will be called as the related party transaction. Or, we will have the listed entity in one hand and any other person on the other hand. The benefit will be going to the related party. Listed entity will be on one hand, any other person will be on other hand. The transaction will be happening. The benefit of the transaction will be going to some related party. Then also this main transaction, it is called as the related party transaction, RPT. So that is the meaning of related party transaction. These are the two types of related party transaction. Then the following will not be a related party transaction. When you are issuing securities on preferential basis, preferential allotment, as per the ICDR regulations, then it is not an RPT. Then dividend payment, subdivision or consolidation of securities, that one security, one share with face value 10, it is divided into 5 shares of face value 2. Then that will not be a related party transaction and all. Buyback, right issue, bonus issue, then acceptance of fixed deposit by banking or NBFC companies, that is not an RPT. Then, so that is not an RPT, we are having that list. Next point when you see material RPT. Here also normally everything will be RPT if it is coming under the definition. Material means if it is exceeding a numerical threshold. If it is more than some amount, then it will be called as a material RPT. So when you see a normal RPT, it should get the approval from the audit committee. But when it is a material RPT, it should get the approval from the shareholders. So that is the main difference. Normal RPT, audit committee approval is enough. Material RPT, shareholder approval is needed. Now, what is a material RPT? If the transaction value, individually the transaction or together with the previous transaction during the financial year, transaction to the related party, with one related party when you are doing individually the transaction or together with the previous transaction, the aggregate value, it exceeds rupees 1000 crore or 10% of the consolidated turnover, whichever is lower. So, first point you have to take 1000 crore as the first amount. Second amount is 10% of the consolidated turnover. Take the lower amount. Now, in that, you have to take the lower amount. Now, the lower amount, for example, you are getting 100 crore. Then, whatever the transaction, if it exceeds 100 crore, if the value is plus 100 crore, more than 100 crore, then in that case it will be a material RPT. Then when you are doing payment to a related party, why you are making the payment? For brand usage or royalty. From one related party, we are having a brand. That brand you are going to use it. That brand you are purchasing or taking it on, what we can say, on an agreement. Then you are making a royalty payment. Then in that case, we are having a material RPT, that number. Here when you see it exceeds 5% of the annual consolidated turnover. So the transaction will be material RPT if it exceeds 5% of the annual consolidated turnover. More than 5% of the annual consolidated turnover. Then a company has listed the securities on the small and medium exchange. Then the transaction material RPT will come only if it exceeds 50 crore or 10% of the turnover. Here normally we had 1000 crore or 10% of turnover. Here it is 50 crore or 10% of the annual consolidated turnover, whichever is lower. So normally here we will have 1000 crore, but now for a company which is listed on a small and medium exchange, it will be 50 crore. Then the next thing, approval of audit committee. All the related party transaction and subsequent material modification should get the prior approval of the audit committee. All the transaction will get the audit committee approval. Then in the audit committee, we will have independent directors, right? Only those people will approve the related party transaction. Only those people will be eligible to approve the transaction. Other people will not be there in the approval. Then omnibus approval. For each and every transaction, we cannot come and get the approval. There will be some routine transaction which we can do it. For that, the audit committee will prepare a list and these transactions you can do it. And then that approval is called as the omnibus approval. You will just do the transaction based on that particular approval and in the conditions. And at the end of the year or some periodically, the audit committee will review the transactions. So that is the meaning of omnibus approval. The criteria will be given by the audit committee. These transactions you can do it. There is no problem. Then this will be given when the transactions are repetitive. Multiple times you are going to do the same transaction. Then this kind of approval they will give you. The audit committee will properly investigate, and after that only they will give the approval. They will give the name of the related party. To this related party, you can do the transaction. Nature of the transaction, it's a purchase transaction or payroll transaction or sales transaction. That they will give it. Period of the transaction. You have to do the transaction for this 1 year. Within this period, you can do the transaction. Maximum amount up to 1 crore you can do it. Up to 50 lakh you can do it. That should be there. Base price and the formula for variation. The normal base price will be 50 crore, and then formula for variation 10% will be extra if the volume is 10,000 units. Like that, they will give you the variation formula also. Everything will be there in the specified permission given by the omnibus approval given by the audit committee. Other conditions also they may impose. Then, where you cannot get the related party transaction approval, where you are not having the time to get the approval, immediately you want to do an unexpected transaction or an emergency transaction, then the audit committee will give an omnibus approval for such emergency transaction that you can do it 1 crore rupees per transaction. Emergency transaction 1 crore rupees. Then the audit committee will periodically review the approvals given. Then the approval will be a valid for a period of 1 year, maximum 1 year. After that, you have to get the fresh approval. So this is the audit committee approval process. Then when you see the approval of the shareholders, all the material RPT will get the prior approval of the shareholders. After that only the transaction you have to do it. And in the approval, they will go to the general meeting and they will present the resolution for doing the related party transaction. Then in that place, no related party shall vote. Whoever it is a related party, that person shall not vote in the particular resolution in the general meeting when they are getting the approval of the shareholders. No related party, not in the particular transaction. So, for example, we are having one related party, one transaction where A and B and C, these three are the related parties. These three are also shareholders. Then we are having another related party transaction where D, E, F, all these people are related parties. These are also shareholders. Now, when, for example, transaction 1 is presented, now A, B, C also cannot vote. D, E, F also cannot vote. So, all the related party in all the transaction, they cannot vote. Not only the particular related party for the particular transaction, any related party cannot vote in the presentation of the RPT in the general meeting for the shareholder approval. So that point also they have given here. Then when you are doing a resolution plan, when you are doing something, when you are doing a related party transaction based on the resolution plan, they have given the permission under the resolution plan, court or NCLT has approved the resolution plan, then you also informed the fact to the stock exchange. You also told to the stock exchange that we are going to do the related party transaction based on the resolution plan. Then no problem, no need to get any approval, you can do it. Exception, you no need to get the audit committee approval. You no need to get the audit committee approval in these following cases. When the transaction is being done between two government companies, then no need to get the approval of the audit committee. Then holding company we are having, and then 100% wholly owned subsidiary we are having. Between these two companies, some transaction is there, that is a related party transaction. No need to get the approval. Only one condition you are having: the accounts of the wholly owned subsidiary should be consolidated, and then it should be placed before the shareholders in the holding company general meeting. So the accounts are consolidated and placed before the shareholders. The transaction is happening between holding company and then the 100% wholly owned subsidiary. Then when the transaction is done between two wholly owned subsidiaries, so here we saw that between holding and then the wholly owned subsidiary, we are having the transaction. Here when you see holding, wholly owned subsidiary number 1, wholly owned subsidiary number 2. Now between these two subsidiaries we are having a transaction. Then also no need to get the approval. Now here also you have to see that both the accounts are consolidated and placed before the shareholders of the holding company. Then when you see we have to do the secretarial audit, we have to do that by peer-reviewed company secretary. We have to annex the secretarial audit report. We have to prepare the secretarial audit report, attach it with the annual report. Then that they have given types of committees under LODR regulations. Audit committee we saw. Then nomination remuneration committee I told you. Then stakeholder relationship committee, risk management committee. Like that we have to form various committees. So when you see the audit committee, the main work is overseeing the statutory audit process, financial reporting process, ensuring the internal controls, ensuring the preparation and presentation of financial statements is going properly. So that is the main work of the audit committee. This is the main concept. Now when you see the actual points, minimum 3 directors should be there as the members. Minimum 3 directors. This is all you should remember. They may ask you, for an audit committee, the company appointed only 2 directors as the members, whether it is correct or not. That they will ask you, you have to say, no, it is wrong. So this type of knowledge you should have. So this point is important. Audit committee, this point is important, and the entire related party transaction discussion. The entire discussion video related to the related party transaction, that is very, very important. I am repeating it again. Then when you see the audit committee, we need minimum 3 directors. In that, minimum 2/3 director should be independent director. Now here when you see, you can note one thing, we will have the related party transaction and then the committee and then quorum, those things and all we will have in both board meeting. In the normal companies act, as per normal companies act, for the board meeting also we will have the quorum, we will have the timing for the board meeting, like that everything will be there in the normal companies act also. When you see the SEBI also, we are having various committees, meetings of the committees, board of directors meeting, the timing, everything is there in the SEBI also. You have to see the requirement of the question, whether they are asking for a normal company or they are asking for a listed company. When they are asking for the listed company, you have to follow the listed company regulations and you have to answer as per that requirement. And when they are asking for a normal company, you have to answer as per the Companies Act. Check whether it is a listed company. If it is a listed company, directly think about the LODR regulations. You have to use the provision given in the LODR regulation because they have to compulsorily follow it. So when they are asking about the audit committee for a particular company, check if it is listed. If it is listed, go to the LODR regulations. Otherwise, you can use the normal Companies Act provision. Now, when you see, minimum 3 directors should be the member we saw, then at least 2/3 of the member should be the independent director. At least 2/3 of the member. This means that 66.67% should be the independent director. This is for a normal listed entity. And when the listed entity is having SR equity shares, that is the superior voting right, that kind of differential voting right equity shares are there in the company, listed entity, then only independent directors should be there in the audit committee. You cannot keep any other director. So, normally when you see, we are having minimum 3 director and then 2/3 of the director should be 2/3 of the member should be independent director. This is for the normal listed entity. If it is a listed entity where SR equity shares are there, then only independent director should be there in the audit committee. So this you have to remember. Then the next point, when you see, the chairperson shall be an independent director. The chairperson shall be an independent director. He should be there at the AGM also. That point you can leave it, but the chairperson should be an independent director. That is the most important point. Then all the members of the audit committee shall be financially literate, and one member should have the accounting or financial management expertise. Now, when you see the audit committee, all the members should have the financial literacy. They should have the financial literacy. They should know what is a balance sheet, what is a financial statement, and all. So that should be there for all the audit committee members. And one member should be there with the financial management expertise. They should be an expert in the field. So that requirement we are having here. One person with expertise, all the members will be financially literate. Company secretary will be the secretary for the committee, and then the audit committee may invite the finance director or the statutory auditor representative. One person as a representative for the statutory auditor, then finance director. Those people can be invited by the audit committee for the meetings. Then the meeting shall be held at least 4 times in a financial year, same like the board meeting under SEBI. And then 120 days shall be the maximum gap between two meetings. Between two meetings, maximum gap should be 120 days only. The quorum, the minimum number of members so that we can start the meeting, that should be 2 members or 1/3 of the members, whichever is greater. 2 members or 1/3, whichever is greater, along with 2 independent directors. Minimum 2 independent directors should be there in the particular meeting. That is the quorum requirement. Then the audit committee can investigate any activity. They are there to prevent, detect, and correct the frauds only. They have to create the internal controls for those purpose only. So they will have the power to investigate any activity within the company, so that they can investigate and find out some wrong things that are happening in the company. If anything is wrong happening, they will do the investigation. Nomination and remuneration committee, as we already saw, it will be for the hiring of the people and fixing the remuneration of the people. It will also have minimum 3 directors, and all the directors should be non-executive directors. All the directors should be non-executive directors. Then 2/3 shall be independent director. Same like audit committee, 2/3 shall be independent director. Chairperson shall be independent director. Here also same as audit committee, chairperson shall be an independent director. Chairperson shall be an independent director. Then the chairperson, whether executive or non-executive, may be appointed as a member of NRC but not chair such NRC. So here, when you see the board of the directors, for the company we will have the board of directors. For board we will have one chairman of the board of directors. This chairman, he can be a member of the NRC. He can be a member of the NRC, that is allowed, but he cannot be a chairperson of the NRC. Nomination Remuneration Committee, he cannot be the chairperson. He is already the board of directors chairman. He cannot be the chairman of the Nomination Remuneration Committee. That point they have given here. Then the meetings, they shall meet at least once in a financial year. Here it is a relaxation, like they are not having that much strict regulation like audit committee. They shall meet at least one time, that is enough. Then the quorum will be same like two members, or here we are having one third, whichever is greater. The same thing, two members or one third, whichever is greater, and at least one independent director. Earlier in the audit committee, we had two independent directors minimum requirement. Here we are having at least one independent director minimum requirement. Then stakeholder relationship committee. Here also we will have the chairperson. The chairperson shall be a non-executive director. Earlier in the two committees, we had the chairperson to be independent director, but in the stakeholder relationship committee, the chairperson shall be a non-executive director. Then at least three directors should be there. One director should be an independent director. At least three directors, at least one should be an independent director. Then chairperson will be there at the AGM and all. The meeting should be held at least once in a financial year. Then risk management committee. Then minimum three members should be there. Majority of the members being the members of the board of directors with at least one independent director. The board of directors members were having like normal directors. Those people itself, they can be the members of the risk management committee. At least one independent director should be there. Then if the listed entity has outstanding SR equity shares, that is the superior voting rate equity share, then at least two-thirds shall be the independent director. Normally, at least one independent director is needed. If the listed entity is having SR equity share, two-thirds of the committee should be the independent director. Then chairperson shall be a member of the board, and senior executive shall be the members. So, member of the board, from board of directors, one director can be the chairperson. Then risk management committee shall meet at least twice. Two times they have to meet in a financial year. The quorum is same, two members or one third of the members, whichever is higher. Then they can meet on the meeting will be on a continuous basis, not more than 210 days shall elapse between two consecutive meetings. They can conduct the meetings in such a manner that between two meetings, 210 days should be the maximum gap. 210 days shall be the maximum gap. The board of directors will give the roles and responsibility of the committee, everything is there. The provisions of this regulation shall be applicable to top 1000 listed entities and a high value listed entity. So for these two entities, the regulation will be applicable. The risk management committee can get information from any employee. So they will get the power to demand the information from any employee. Then if you are not following all the regulations, the LODR regulations have come to an end. If you are not following the regulations properly, you will get fine, suspension of trading. The trading of your shares, SEBI will suspend it so that no one will be able to trade on your company's shares. Then they can freeze the securities. They can take any other action. So we have completed the LODR, everything we have completed. Now here when you see the audit committee is important. And then nomination remuneration committee, stakeholder relationship committee, till that it is important. So committee itself we can keep it as important, and then the related party transaction, that topic is important. After that, when you see the board of directors, the initial discussion we saw, right, this particular composition of the board for the top 1000 listed entities, and then what should be the proportion of the non-executive and then the executive directors, and then the material subsidiary point. This point, corporate governance requirement with respect to the material subsidiary of the listed company. So this is also an important point. So these are all the important parts of this chapter. Now we have completed this entire LODR regulations. Now we have completed the topic successfully and we have reached the end of this video. So that's all about this chapter. We have completed it fully. We have done the full coverage and I have also given you the important points. Wherever they are asking the questions, I have also mentioned it along with the explanation. So that's all for this video. If you found this video helpful, share this to your friends, subscribe to the YouTube channel, like this video and leave a comment whether you like it or not, what are the suggestions that you can tell, and what are all the things that you are having the doubt, and what topics for which you need the next videos. That also you can mention it in the comments. I will try to make videos for those also. So all the best for your exams. Prepare well. Thank you. Now we can start the SEBI ICDR regulations. So here when you see what is the full form for ICDR, the full form is issue of capital and disclosure requirement. So when you are issuing the capital, when you are allotting the shares, when you are listing your shares, then only you have to follow these regulations. Either it is an IPO or FPO, you have to follow the regulations. And here if you see the first part of the chapter, we are having the classification of issues. Issuing means you are allotting the shares, you are listing your shares. That is called as the issue of capital. Now that issue we are having a lot of types. Public issue, rights issue, composite issue, bonus issue. These are all very basic things only. All of you already know that, but I'm just giving you a small introduction. Public issue means you are issuing the specified securities to the public. Now when you say specified securities, in this two categories of securities are there. One is the equity share, normal equity shares. Other one is the convertible debenture. So when you issue even one of those, you have to follow the ICDR. It will come under the public issue. Public issue, when you see in that, IPO will be covered, FPO will be covered. These two will be covered under public issue, and these two issuance will be covered under specified securities. So wherever you see in the ICDR regulation, you will see the word specified securities. It is nothing but the equity share or the convertible debenture. Now, here if you see, IPO means an offer of specified securities. You are offering the specified securities to the public for the first time, and you should give it to the public, not to the existing shareholders. Then FPO, you are giving it for the subsequent times. Then rights issue. You know what is rights share, that and all no need to explain. Composite issue. Here in composite issue, you are doing public issue. You are doing public issue plus rights issue at the same time. You are issuing shares to the public along with the right shares to the existing shareholders. These two are doing simultaneously. So that is called as composite issue. Bonus issue, everyone knows. Private placement. Here, you are selling the shares privately to a group of people or a specified number of investors or to particular institutions. Then it will be called as private placement. You are making the issue of shares to a group of selected group of persons not exceeding 50 or such higher number, which is 200 persons. So 50 to 200. So it was 50, but now the number is 200. If you're allotting to persons up to 200, the number of persons should be up to 200. Then in aggregate in a financial year, then it will be called as a private placement. It is not a right issue, it is not a public issue, it is called as a private placement. Now, here when you see preferential issue, we are having qualified institutional placement, we are having preferential issue you are doing as per the chapter 5 of this regulation. ICDR regulation chapter 5 you are following and you are doing the preferential issue. It may be done, but it cannot be done to employee stock option scheme, employee stock purchase scheme. This and all will not be covered under preferential issue. If you do that, it will be separate only. It will not come under the preferential issue. Then qualified institutional placement. You are issuing the securities to qualified institutional buyers. To institutions you are selling it on a private placement basis. Then it includes an offer for sale of specified securities. So the promoters or some other shareholders who are already having the securities, they are selling the securities under their holding. This is their holding. They are currently having the shares in their name. Now this they are selling it to the new investor. That new investor may be individual or institution. That new investor they are selling the existing holding of the promoters. Then it will be called as an offer for sale. This is the meaning of offer for sale. Already you are having shares that you are offering for sale to the new investor. Now that you can also do it in the qualified institutional placement. So the shares with the promoter you can do offer for sale, that you can sell it to the qualified institutional buyer. Then that they have given. Now the other relevant definitions. This and all no need to read and all. Just these are very easy definitions only. All of you know the basics already. Now the applicability of the regulations. For what are all the issues? For what are all the issues the regulations will be applicable? That is given below. Here in IPO by an unlisted issuer, till now not listed IPO, a rights issue by listed issuer, a FPO by listed issuer, preferential issue by listed issuer, qualified institutional placement by listed issuer, IPO of IDR, rights issue of IDR. IDR is nothing but the Indian Depository Receipt. IPO by small and medium enterprise, listing on the Innovators Growth Platform, IGP platform. Then bonus issue by listed issuer. For these issues, the regulations will be applicable. Now, when you see we are having a lot of regulations here for some main regulations. For main regulations, which are the main essence of this chapter, I have made some charts. So those regulations will be seeing from the charts so that you will be remembering it very well. So now we will be seeing those regulations from the chart. We can see one by one. Where the chart is required, I will show you the charts. Now here if you see reference date, so the conditions under this regulation you have to follow it as on the date of filing the offer document. You will be filing the offer document that will be released to the public and you have to file it with the SEBI stock exchange. You have to file it. The date of filing the offer document, that is the date. That is the reference date. On that date, you should be fulfilling, satisfying all the conditions. Now here I would like to tell you one thing. Here we are having IPO and then FPO. Now we are having symmetrical regulations. Like here we are having one regulation, respective regulation we are having here also. The regulations are similar to, only some small changes are there. So what we are going to do is that when we are seeing the chart, we will first see the regulation for IPO, then we will see the regulation for FPO immediately, so that we can cover the same particular regulation in both IPO and FPO quickly. So that will save our time. So this is the approach we are going to do. Now we can first see the need for ICDR. Why we require ICDR? Wait a minute. So here if you see, when you are a company, you are an unlisted company. Now in an unlisted company, it will not be regulated much. Just the normal company act will be there, no strict regulations. But when this company wants to raise capital, it can go to public or it can go to some investors or some institutions. But when it goes to public, the money of the public is risked. The public are investing in the company. So there should be some preliminary verification for the company. It should be a credible company. There should be a verification of the credibility of the company. Only credible companies can be allowed to issue shares. Otherwise, all the people will start the companies. All the fraudsters will start the companies. They will issue the shares. They will collect a lot of money. Then they will go abroad. They will be untraceable. So that kind of scams should not happen. So that's why we are having the ICDR regulations, where we are evaluating the company very well. We are getting the company compliant with all the conditions. We are putting all the strict conditions so that such scams does not happen. We are checking the company very thoroughly. After that, we are allowing the company to raise capital from the public. So what all the kind of condition we are having? So entities not eligible. We are having one topic called entities not eligible. If the promoters or the directors, like they're debarred by the SEBI, or they are fugitive economic offender, like there are some offenders who did economic offenses, like they did some scam or non-repayment of loan, then they went abroad. Now we are not able to trace them. So those people, they should not be allowed to do the issue. So those people, they will be considering under the entities not eligible. Then this is the first negative list. Then when you see, we are having the eligibility conditions. Why we are having these eligibility conditions? So to ensure that the company is a fully functional entity. They are actually doing the business. For that only we are checking this eligibility conditions. So here we will check the assets of the company, whether they are having proper assets. That assets also should be in what we can say non-monetary way. Non-monetary means like plant and machinery, furniture. Monetary means it is like in the form of cash or amounts which are which are receivable in fixed and determinable amounts. Like for example, you have given loan to someone or you have made some investment. Those amount will come under the monetary assets. When these are coming under monetary assets, you cannot do business just with loan and investment. You need some plant and machinery, equipment, building, everything you need. That are called as a non-monetary assets. So when you are having just this monetary assets, you are not doing any productive investment. Now, when you are doing the business using plant and machinery, then only you will be allowed to do the issue. So you should be having the non-monetary assets. We will be seeing all this in detail. Just I am giving you some overview so that you can understand the intent of this legislation. Now, non-monetary assets we are having. Why we are checking the non-monetary assets? So that we can check that the company is properly doing the business. Then we will check the profit, whether it is a profitable entity. Only then we will be allowed it to issue the IPO. Already it is a loss-making entity. Then if we allow it also, it will make further losses, and that loss will be transmitted to the public also. So we will allow only the profitable entities. Then eligibility conditions we saw. After that, we will give the general conditions. This is the condition to be checked for the specific entity, the assets of the specific entity, profit of the specific entity. Then we will check some general conditions. After doing this three level of checking only, we will allow them into the IPO process. Then the next level of condition is that after allowing them into IPO, after they issued the shares, after raising the capital, after that, after completing the process, after completing the issue process, then also we are having some conditions like the minimum promoter contribution, lock-in period, minimum promoter contribution, and in the lock-in period. Like what is the minimum promoter contribution? Promoter means the persons who started the company, like that you can understand, or the persons who are controlling the company, like that you can understand for now. Now those promoters, what will happen if this condition is not there? The persons, the promoters will be there. They will start the company, they will do the listing, they will raise the capital. We already saw that we are having an option called offer for sale. They can sell the existing shareholding of the promoter to the public. Now here what they will do? They will do offer for sale and they will sell all the shares to the public, which are in the holding of the promoter. Now what will happen? The promoter will take the money and go away. No one will be there for managing the company. So they can easily exit Without managing the company in the future, they can easily sell their holdings through offer for sale, and then they can move away from the company. So this should not happen. The promoters should be there. They should be running the company after that also. After surrendering the shares to the public will be the persons holding the shareholding. But they should be the promoters who can run the company. They are the ones managing the company. They should be running the business in future also. So that we should make sure that the promoters are having the shareholding in the company even after completing the issue. Even after the shares are issued to the public, the promoters should have the shareholding in the company. We should mandate that. Only then the promoter money will be locked in the company, and they have to manage the business somehow. They cannot go away from the company. They cannot leave the company. So for that we are having the minimum promoter contribution and then the lock-in period. Like for example, what is the minimum promoter contribution is that 20% of the post-issue capital. After issuing the capital, after issuing the shares, if you are having 100 crore capital, then out of that 20% should be there with the promoters. Only then they will have their money inside the company. Then only they will manage the company properly. Then lock-in period. This shares, this 20% you should have in the company, right? That you cannot sell it for a minimum of 18 months. For 18 months you cannot sell it. Otherwise they will do the issue. Then the other day they will sell it and they will go away. So we are having the lock-in period. Like this we are having the process. So these are all some of the main points we are having this regulation. So I have given you the reason why we are having these points. Now we can see the conditions one by one. So first we can see for the IPO. IPO, when you see entities not eligible, who are not eligible? An issuer, promoter or promoter group or director or selling shareholder. Selling shareholder are the persons who are selling their shares in the offer for sale. The existing holdings are being sold in offer for sale. Who are selling those holdings currently? Who's the owner of these shares? They will be called as the selling shareholders. Issuer, promoter, promoter group, director, selling shareholder. If they are debarred by the SEBI, then that company we cannot enter into the listing. Then, if promoter, director, if a promoter or director in any other company which is debarred, so your promoter or director is there. This is your company. Now we are having this promoter director. They are acting as the promoter or director in some other company. Now this company is debarred by SEBI, then your company will also be debarred because it is under the control of the same promoter director. This promoter director, they are controlling both your company and then the debarred company. Then the control is in the same person, risks in the same person. So your company will also be debarred. Your company cannot also do the listing. Then, if issuer, promoter, director, they are a willful defaulter or fraudulent borrower, then also not allowed. Then, if you are a fugitive economic offender, like we already saw, you are doing an economic offense and you are going abroad, you are not traceable, you are not arrestable, then you will be called as a fugitive economic offender. If your promoter or director is an economic offender, then also your company will not be allowed. Then, here they are saying that one more point, the debarred, the promoter or debarred or the promoter, another company is debarred, that debarment should be currently in force. If they were debarred in the past, but the debarment period is already over, then there is no problem. Okay, the next thing when you see, when you are doing the issue, you should not have any outstanding convertible securities. So all the shares should be fully paid up. That is one more conditions. All shares should be fully paid up. And if there is any convertible security, if there is any convertible debenture or convertible preference share, then you should first convert them into equity share. Then you can do the new issue. So that condition we are having. Here if you see, outstanding option granted to employee. If you have given any option to employee, then that will not be covered. That can be there. That is allowed. These two are stocks given to the employee stock option plan. Then, if you're having the convertible securities, but before the date of filing of a document, you will convert it into equity share. Then there is no problem. If you're having convertible securities, you will convert it into equity share before the date of filing of a document. Then no problem. You can do the listing. You can enter into the IPO process. So the next thing when you see, this is the entire entity is not eligible to make IPO, that particular topic. Now we can see the same thing in FPO. Now, this is the respective regulation in FPO, further public offer. So here also if you see issuer, promoter group, director, if they are debarred from capital market, then the promoter director is acting as promoter director of any other company which is debarred, then also the company is not allowed. Issuer, promoter, director is a willful defaulter or fraudulent borrower or fugitive economic offender. Those 4 points are there here also. But the convertible debenture point is not there. That's all about the further public offer entity is not eligible. So we have completed 2 regulations, one in FPO, one in IPO. Now we can see the next regulation, which is for the initial public offer eligibility requirement. We already saw that eligibility requirement should be there. There are two conditions I told you. One should be non-monetary assets should be there with the company. They should not keep a majority of their assets in cash or loans given like that. It should not be there, or investment. It should not be there. Then the other thing is profit. They should be a profitable entity. Now here, if you see, its net tangible asset is at least 3 crore rupees. So this thing we can see in chart. It will be more easy for you. We can open the chart for this regulation. So here if you see, this is the chart. This PDF also I will give it to you. It will be in the Telegram channel and in the WhatsApp community. You can join both of them by using the links in the description and in the pinned comment. So here if you see eligibility conditions for IPO, the net tangible assets should be 3 crore or more. The assets should be 3 crore or more, net tangible asset. Then in each of the preceding 3 years, from the date preceding 3 years, it should be 3 crore or more. Then the tangible asset, maximum 50% can be monetary assets. Monetary asset means already we saw cash, loans given or investment. Those are called as the monetary assets. In monetary assets, maximum 50% only should be there. If you are having total 100 crore net tangible asset, only 50 crore should be there in monetary asset. Remaining 50 crore should be there in non-monetary asset like plant and machinery, building, furniture. So this is for the business of the entity, whether they are doing actual business. For that, this condition is there. And if you, for example, 100 crore is the net tangible asset, but you are having 60 crore in the monetary asset. Now what you can do, you can either leave it out, or you can go away from the listing. You can go away from the listing. Otherwise, you can give firm commitment. Like you can make a promise that 50 crore is the allowed limit, but currently I am having 60 crore. Now this 10 crore difference I am having, that I am promising you that I will make investment in plant and machinery or building. I'm making firm commitment to utilize it. So that you can do, and then proceed with the IPO. Then the average operating profit should be 15 crore or more in the preceding 3 years, with profit in each year. 3 preceding years you have to see the average profit should be 15 crore or more. Minimum 15 crore should be there. Then every year profit should be there. So you can have loss in 1 year but abundant profit in another year. Those two will shut off and you will get an average 15 crore profit. That should not be there. Every year profit should be there and average profit should be 15 crore. Then net worth. Net worth should be 1 crore or more in each preceding 3 years. In each preceding 3 years, 1 crore net worth should be there. Then if you have changed your name in the last 1 year, you have changed your name. Like from furniture, your name was, for example, A Furnitures Limited. From that you changed to A Steels Limited. Then you have changed this name the last 1 year. The 50% of the revenue that you get, that should be from the steel business. You have changed the name to steels, 50% of your revenue should be from the steel business. Only then we will allow you to do the IPO. Now, here if you see, this is the condition for IPO. IPO done. Now, when you see FPO we are having only one condition. Just when you change the name in last 1 year, 50% of revenue you should earn it from the new name activity suggested by the new name. So here if you see why we are not having these conditions, these three conditions why we are not having. This is for the preliminary conditions. When you are an unlisted company, for the first time you are coming to issuing the capital, then we will check all these conditions. But already for FPO when you see, already the company is a listed company. For listed company, we are already having a lot of regulations in SEBI LODR regulations. They have to file quarterly returns, they have to file annual returns, everything they have to do. They are having a lot of compliances. So it is an already monitored entity. So no need to have that much strict regulations. So those three conditions are not there, only this condition is there. Then the next thing when you see, these are all the eligibility conditions. If you are not following the conditions, then also we are having one alternative route. If you are not following the conditions, we are having one alternative route. Under that alternative route, you can do the IPO. So that we can see here. Alternative eligibility through book building process. Book building process. What is the meaning of book building process? So book building process is a process by which you will determine the price of the share that you are going to issue. So we will file the prospectus. The offer document we are saying repeatedly offer document, right? It includes the prospectus and in the red herring prospectus. This topic you would have studied in the CA intro itself. Under the prospectus chapter in law, red herring prospectus you would have covered. So this we will be doing when we are doing the book building process. So what will happen in the book building process? Normally, when you know what is the price of the share, everything you know, you will directly issue the prospectus. It is called as the offer document. Offer document includes the prospectus. Now you will directly issue it to the public and you will do the issue. But you don't know the price. You don't know the price. Now you have to determine the price based on the demand available in the market. So what you have to do is that first you have to create a red herring prospectus. In that all the details will be there as the same prospect, in the same normal prospectus only. But just the price details will not be there. The final price will not be there. Instead there will be a price band. Like floor price will be there and then the maximum price will be there. And then the people, the public, they have to do the bidding. Based on this bidding, the company will get to know about the suitable price for the share, and after that they will issue the normal prospectus. In that the price will be mentioned. They will decide the price based on this process, and they will issue the final prospectus with the final price. Now this is called as the book building process. So you have to go through that process. Then you have to allot 75% to QIB, qualified institutional buyer. You have to allot 75% to them. Then, if you are not able to allot 75% to QIB, then refund the full subscription money. Whatever the money you received for subscription application, the full amount you have to refund it. Book building process plus 75% allotment to qualified institutional buyer. Otherwise, refund the full subscription money. This is the alternative eligibility for IPO. When you see the alternative eligibility for FPO, the same thing only. Book building process, allot 75% to QIB and refund the full subscription money if it is not satisfied. The QIB condition is not satisfied. So this is the alternative eligibility for FPO. Now, we saw the alternative eligibility also. The next thing when you see general condition for IPO. So, what are all the general conditions? These are all the general conditions. You should follow it whether you are doing through the normal or you are doing through the alternative eligibility. You have to follow these general conditions. So what are all the general conditions? To obtain in principle approval from the stock exchange. Then agreement with the depository. These are all normal points. You have to do it when you are issuing the capital. All the holdings of promoters should be in demat form. This is one point. Whatever the holding till now you are having with the promoters, that should be in demat form. You have to convert it into dematerialized form. You have to convert it into electronic form. Then all the shares must be fully paid up. This we already saw. Then firm arrangement made for 75% of fund for project. So here, when you are doing the issue, you will be obviously doing it for some project. You are getting a tender or a project you are having. For that you need funds. For that only you are issuing the capital. Now, for this project, for example, 100 crore is needed. Already 75 percentage, that is 75 crore, you have already made the arrangement. For the remaining 25 crore only you are doing the issue. Only in that case the issue will be allowed. For the project, 75% of the amount, 75 crore, you should have already made a firm arrangement, like some kind of a bank loan or some kind of a pledge, something you should have done, and 75 crore is ready. Only remaining 25 crore you have to get. For that you are doing the issue. Then there is no problem. For the project when you are doing the issue, this is the condition. 75% should be already arranged properly, the money. Then the amount you are getting right, the issue proceeds. For what purpose you can spend the amount? That is also one more question. For what purpose you can do it? For the purpose for which you raised it. In that, some expense might be done for the administrative purpose or general corporate purpose or some unidentified investment. You are acquiring the shares of another company, that also you can do. But there is a limit. Mainly you should use it for the purpose only. For example, you are constructing a building or preparing a complex or you are doing something, a big project you are doing. For that project you have to use it. For these purpose and all, a limit only up to a certain limit only you have to use the amount. Mainly you raised it for some main purpose. That only should be the main priority. So here if you see, general corporate purpose means it includes the working capital purpose or some other short-term fund requirement. Everything will come under the general corporate purpose. For that you can use up to 25% of the amount. Then unidentified investment target. Why we are calling it unidentified is that in the offer document you did not tell anything about the investment. You did not tell anything like I am going to buy the shares of the company. That you did not mention in the offer document. Then that is called as an unidentified investment target. So when you are doing the investment using the issue proceeds, that can be done up to 25% of the amount. Then combining these two, you can take only 35% of the issue proceeds. You can use it for this two purpose. General corporate purpose 25%, unidentified investment target 25%, general corporate purpose plus unidentified investment, the total will be 35%. Above this you cannot spend for these purpose. Mainly you have to spend for the mainly you have to spend for the project or the purpose for which you got the money. So this, here when you see the 75% of funds, we have to make the arrangement right. That is excluding the proposed issue and the internal approval. So the 75% amount, 100 crore we saw, out of that 75 crore should be already arranged. That should be other than the issue. The issue you are doing, that amount don't consider. Then remaining internal approval. Internal accrual means like an ongoing contract to stay. From that, after 3 months, I will get a cash flow of 10 crore. Then I am going to do something else. The investment which I made, in that I will get some 5 crore. That and all you should not add it in the 75 crore which you are already keeping ready. 75 crores should be absolutely ready. You should not depend on the internal accrual. Internal accrual, this 10 crore cash flow, you may get or you may not get. So there is an uncertainty. So you have to follow the proper absolute readiness. Like it should be in cash with you, or you have to get a proper approval for a bank. In that kind, it should be there. You should not depend on the issue or the internal approval. So that point also we are having. So we saw the general condition for IPO. Now we can see for the FPO. Same stock exchange approval needed, depository agreement should be done. Here one condition is missing. What is the condition? All holdings of promoter in demat form. Already in the IPO, any company which does an IPO only, after some years it will do the FPO. When you do the IPO, you are an unlisted issuer. After doing the IPO, you will become a listed company. Then you will do the FPO. So here, already in IPO stage itself, we converted all the securities in demat form of the promoter, all the promoter holding. Then no need to do it again in the FPO. So that condition is not there. All shares must be fully paid up. That condition is there. Then 75% firm arrangement. That is the firm arrangement made for 75% of fund. That condition is there. Then amount spending restriction is there as it is. So these are all the general conditions for FPO. Now we have completed the general conditions for IPO and FPO. Now here if you see in this thing in the study material, eligibility requirement for IPO we completed. Then here this SR point, superior right equity share. That point is there pending. We have to do that. Then general condition we have completed. Then additional condition for offer for sale we have to do it. Before that we can see the superior right equity share. That point. If the issuer means the company that is going to issue, which is proposing the issue of shares. The issuer has issued the SR equity share. Then the SR equity share should be as per the following conditions. The SR equity share already issued, it should be as per these conditions. Only then it will be allowed. Only then you will be allowed to do the IPO. The issuer company is engaged in technology field or information technology or nanotechnology, biotechnology, data analytics or intellectual property. In these field, your company is engaged in the business. Then the net worth of the shareholder, the SR shareholder, the shareholder who received the superior right equity share. This, what we can say, the net worth shall not be more than 100 crore rupees, 1000 crore rupees. So the shareholder who is having the SR equity share, whose net worth should be up to 1000 crore. So this net worth you will find it out by using a registered valuer. So that point they have given here. Then the SR share you have to issue only to the promoter or founder. Then the issue of SR shares, you are doing it by a special resolution. You are authorized by special resolution. You got the permission by special resolution. Then sunset provision, the superior right equity share. What is the meaning of superior right equity share? I hope you already know, but just I am giving you a small example. For example, if ordinary equity share, it is having one share equals one vote, then the superior right equity share it will have one share equals 10 vote. So this is the maximum capacity of the superior right equity share. So even if you have 10 shares, you will have 100 votes. But normal shareholder, when they are having 10 shares, they will have only 10 votes. So this is the main thing here. The promoter, they can have the control of the company even if they dilute the company. Even if they issue the shares outside, they will have the control because they are controlling the voting share through the superior right equity share. Now, this cannot be there for a permanent basis. It should be there for a temporary basis only. The sunset provisions should be there. Like after 5 years, the SR equity shares will be converted into normal equity shares. That condition should be there in the special resolution that you have to do it. Then this 5 years is there, right? In between the 5 years, the persons, the promoters or the persons who are having the SR equity share, they cannot sell it. Selling the SR shares is not permitted. So that is also one more condition of SR equity share. Then the SR equity share should have been issued prior to filing of the draft red herring prospectus. So you should have issued the SR equity share earlier itself before filing the draft red herring prospectus. Then the voting rights minimum 2:1, maximum 10:1. Like 10:1 means I already told you one share equals 10 votes. Then the SR equity share can have the same value as should have the same value as the ordinary shares. Only one class of SR equity share can be there. Then it will be equivalent to the ordinary shares in all respects, but only the superior voting rate will be there. When you compare the SR equity share and then the ordinary equity share, there will be no problem, no difference. Only the voting rate will be the single difference that is there between the SR and then the ordinary shares. So that point they have given. This is the SR equity share point. Only if the SR shares in your company complies with all these conditions, only then you can do the listing or the IPO. Now, the next regulation is regulation number 8, which is about the additional condition for an offer for sale. So, the general condition, eligibility requirement, everything we saw for normal. Now, we are having some extra additional condition for an offer for sale. We already saw what is an offer for sale. Promoter or pre-issue shareholder, they are having some holding. That holding, they are going to sell it to the new investor or the public who are going to invest in the shares. That is called as an offer for sale. Now, we can see the additional conditions. For this also, we are having the chart. We can see through that. Then for this regulation 8A, for that also we are having the chart. So that too we can see from the charts. Now here if you see, this is the regulation number 8, additional condition for an offer for sale. Here the shares must be fully paid up. The promoter who's having the existing holding, that shares we are having, right, that shares must be fully paid up. Only then you can sell it to the new investor. Fully paid up, held by sellers for 1 year. So here we already saw that the persons who are selling their existing holdings, they will be called as the selling shareholders. Now, these selling shareholders, they should have held the shares in their name under their ownership for at least 1 year. It should be with them for 1 year. After that only you can sell it through the offer for sale. Held for at least 1 year. Now, if you are having some convertible securities, then that convertible securities became shares. So, for example, we are having one shareholder. He had 100 compulsorily convertible debenture. Now they got converted into 50 shares. Now this convertible debenture he held for 8 months. Now this shares he held for some 4 months. Now total when you see 12 months you are getting 8, 9, 10, 11, 12, 12 months you are getting. This satisfies the 1 year requirement. But when you see just the share, the shares they held for only 4 months only. So whether this is allowed or not, whether this share they can do it as an offer for sale or not, that is the question. When you are considering the share which got converted from the compulsory convertible instruments or convertible instruments, then you should also include the holding period of the such convertible instruments. So total period 8 months plus 4 months you have to check. So that condition is there in proviso 1. Then proviso 2, when you see, holding period should be completed in filing the draft offer document. When you are filing the draft offer document, on that date the 1 year should be completed. When you're seeing as on the draft offer document filing date, 1 year should have been completed. Then convertible securities, conversion should be done before filing the offer document. So if you're having the convertible securities, it is going to be converted into share. When you see the holding period also, it is going to be completed. 1 year is completed. Now you want to make these shares into offer for sale. But the problem is till now it is not yet converted. But it will be converted before filing the offer document. Before filing the offer document, it will get converted. But currently, it is a convertible security only. Now, whether this security is eligible or not, so they are saying that it is also eligible. But conversion must be done before filing the offer document. And this fact should be disclosed in the draft offer document. Before filing the final offer document, the conversion should be done. And then this fact, you are currently having the convertible security, it will get converted into share. That share I am going to offer for sale. That you have to tell it in the draft offer document. So disclosure and then the conversion should be done before the final offer document. So that point we have completed. So these are all the 3 points for the additional condition for OFS. Then exception. The 1 year condition we are having, right. In some cases the 1 year condition is not applicable. So in what cases the 1 year condition is not applicable? If the offer for sale is done by a government company or a statutory authority or a special purpose vehicle controlled by these two, either government company or statutory authority or a special purpose vehicle, a separate company controlled by these two, then also the 1 year will not be applicable. Then shares offered for sale issued by a scheme approved by High Court, NCLT, central government, and original securities held for 1 year. So here what happened is that you are having some shares. Now, these shares, it were involved in some High Court or NCLT or central government case or proceedings. Now, they made a scheme and they approved the scheme. Now, based on this scheme, what happened is that they took back your shares. Instead of that, they gave you new shares. Now, this new shares you held only for a shorter period, less than 1 year. But this original shares you held for more than 1 year. Original shares, for example, you held for 10 years. Now, in the recent past, these things happened and then the new shares were issued. The new shares were only like we can say, half a year old in your hands. Then, whether these shares, new shares, can you offer it for sale? So, this is allowed. They are saying that the original shares, if you are having for 1 year or more, then you can give the new shares also. The new shares should have been issued to you by a scheme approved by High Court, NCLT, central government. Then you can give the new shares also for offer for sale. Then you are having some original share that you held it for 2 years. For example, we can take. Then you got the bonus share. The bonus share you are having only for 6 months. Now, the original share you can give it for offer for sale. There is no problem. Whether the bonus share you can give it for offer for sale, that is the question here. This is also allowed, provided that you had the original shares for more than 1 year. That is, for 1 year or more, you are having the original share. Then you can give the bonus share also for offer for sale, even if the bonus share is not held for 1 year. So normally 1 year should be followed, but in these cases, if the original securities are held for 1 year, but you can also give the new shares or the bonus shares also for offer for sale. Only condition is that original securities should be held for 1 year. So this is the additional condition for offer for sale. Now the same thing when you see for FPO, this thing we saw regulation number 8, it is for IPO. Then when you see the next thing, it is for FPO. Same thing. It should be held for 1 year. Same thing. Holding period of convertible securities will be considered. Holding period should be completed when filing the draft offer document. Conversion should be done before filing the offer document. Disclosure should be given in the draft offer document. Same proviso, same explanation. Exception when you see, same. Government company statutory authority point, then scheme approved by High Court point, then bonus issued out of free reserve, that point. So here one more point, the bonus we saw, right, the bonus shares. The bonus shares should have been issued out of free reserve. So we know that we are having some reserve called as free reserve, and then we are having some the other reserves. Like free reserve means this will be the revenue reserve, this will be the retained earnings. Other reserve means like debenture redemption reserve, capital redemption reserve, or securities premium, like that. These are all the other reserves. Free reserve means revenue reserve which are ready for distribution as dividend. If it is possible, like if you want to do that, you can distribute this revenue reserve as dividend. There is no problem. So such a reserve is called as a free reserve, and out of free reserve you should have got the bonus. If you have got the bonus from revaluation reserve or some other unrealized profit, then that bonus is not eligible. Bonus should be only from the free reserve. Then, so we have completed the additional condition for offer for sale. We saw that regulation number 8A. That point also we are having, so that also we can see. Wait a minute. Yes, regulation number 88. Here if you see, the additional condition for offer for sale under alternative eligibility. So under alternative eligibility, we saw that we should do the book building process plus 75% should be allotted to qualified institutional buyer. So when this condition is not satisfied, QAB condition, you have to refund the entire money. So this condition under the alternative eligibility, you have came into the IPO. Then what are all the conditions you have to follow? Regulation number 88. Here the offer for sale, which shareholder is doing, that you have to check. Like which person is doing, which selling shareholder is doing, that you have to check. If the selling shareholder has more than 20% of the pre-issue shareholding, for example, earlier pre-issue, before starting the issue and all, we are having some 10 crore capital. In that, more than 20%, like 3 crore, it is there with one selling shareholder. Then how much securities he can give for offer for sale? Then if some shareholder out of 10 crore he is having less than 20%, then how much offer for sale can be given by that shareholder? So that when you see here, offer for sale only 50% of their pre-issue shareholding, offer for sale only 10% of their pre-issue shareholding. For example, we can take that one person had a pre-issue shareholding, that he had 30%, then he is coming under the more than 20% category. Now out of this 30% pre-issue shareholding, how much he can give it for offer for sale, how much he can offer for sale to the new investor. So that limit when we are saying, it is up to half of the previous pre-issue shareholding. Like if you are having 30% in the pre-issue shareholding, then in this only 15%, 1 by 2 of 30%, 15% of your 15% of the total company, total pre-issue shares of the company, in that 15% that is held by the person, that only you can give for offer for sale. Other 15% should be there with you only. So pre-issue shareholding, for example, take 10 crore. In that 3 crore is there if with this particular person, selling shareholder. Now he is having more than 20%. Out of this, he can give only 1.5 crore as offer for sale. Remaining 1.5 crore, he has to keep it with himself only. Now, for example, here itself we can modify it. Less than 20% he is having, like 1 crore he is having. Then it will come under the less than 20% category. Then he can give 1/10 or 10% of his pre-issue shareholding. So 1/10 of 1 crore when you see 10 lakh. So this can be given as the offer for sale by this particular selling shareholder. So that only they have given here. This you can see it. More than 20% of pre-issue shareholding, only 50% of their pre-issue shareholding. Less than 20%, you can give only 10% of their pre-issue shareholding. Then here if you see the lock-in period, you are giving for offer for sale, right? The lock-in period, it is 6 months. So what is the lock-in period? For example, you are having this, we can take the more than 20% example. So 10 crore is the total pre-issue shareholding. Out of that, 3 crore is there with this particular selling shareholder. He can give only 50% of that or one half of that. That is 1.5 crore can be given as offer for sale. Now the remaining 1.5 crore he is having, right? That also he cannot sell after completing the issue. For how much period? For 6 months. That is the lock-in period. The shareholding which he is having, that he cannot sell it for 6 months. So that is the meaning of lock-in period. Now we have completed regulation number 8A. So here if you see general condition done, and then the additional condition for offer for sale done, and then the additional condition for alternative eligibility. Alternative eligibility is nothing but regulation 6 sub-regulation 2. 6.2. So 6.1 is the normal eligibility. 6.2 is the alternative eligibility. No need to remember the sub-regulation numbers and all. Just no need to remember the regulation numbers itself. You can just include the concept. You can just remember the concept. If you try to put the regulation number in the beginning, it will become a little bit difficult for you. So first try to remember the concept. At last, if you are having time, try to remember the regulation numbers. Then, so this is the thing for this. Then when you see the FPO, here also in the FPO, when you see the general condition we have completed, and then the additional condition we have completed. So here we are not having the alternative eligibility and all in FPO. So we have completed this. Now, this we saw right requirement 20% of project cost or 20% of issue size, whichever is higher, this special requirement. This we have to follow, and also we have to follow the general requirement also. 20% post issue capital. This we have to follow. This extra 20% issue size for project cost. This also you have to follow. So totally you should have such percentage of the share capital such that you are fulfilling this condition also. Also you are fulfilling this condition. You have to bring this percentage in the form of equity share. So you have to follow this condition. This is mandatory. Then this special requirement. That condition you are bringing such shares that the above condition 20% of post issue capital, that is also fulfilled, and this thing, that is also fulfilled. This you have to bring it only in the form of equity share. So that is the requirement here. Then the next thing, when you see all the requirements should be satisfied prior to 1 day of opening of issue. When the issue is opening for the public to subscribe, before that, before prior to 1 day, you have to follow this requirement. You have to fulfill this requirement. The amount you are contributing. For example, the company is issuing new shares for this requirement, then they are getting the money. That amount they have to keep it in an escrow account, and that should be released along with the issue proceeds to the company. After completing the issue proceeds that they received from the public, that they will be releasing to the company. Along with that, this amount also will be given to the company. Then the minimum promoter contribution, if it is more than 100 crore, if it comes to more than 100 crore, then before the issue opening date, you have to bring 100 crore compulsorily. Then remaining you can bring it on a pro rata basis before the calls are made to the public. So minimum promoter contribution comes to more than 100 crore rupees, then bring 100 crore rupees immediately. Remaining you can bring on a pro rata basis before the calls are made. So this is the minimum promoter contribution in the case of IPO. Now we can see the FPO. Here when you see 20% of the proposed issue or 20% of the post issue capital. So there is option given to the promoters. The option is either you can bring 20% of proposed issue or 20% of the post issue capital. The promoter can choose any one of the option. They have to bring that much amount as the minimum promoter contribution. Then composite issue. Composite issue means we already saw that public issue we are doing along with the right issue we are doing. Right issue, the shares will be given to the existing shareholders at a discount, and then public issue we are giving to the normal public. So that is called as a composite issue. Now in composite issue, the thing will be 20% of proposed issue or 20% of post issue capital. Same only, but excluding the right issue component. Now, when you see after regulation 8A, what we are having is that we are having the issue of convertible debt and then the warrant. So this we can see it separately. This is a separate topic. We can see it, but we can go in the flow. So now when you see this separate topic, when you leave it, they are having the promoter contribution. So the minimum promoter contribution, I told you, after completing the issue also, the promoters, they should have the shareholding in the company. They should be mandated. There should be a lock-in period. Only then they will properly manage the company. They will be involved in the future of the company also. So that thing, that promoter contribution point we are going to see. After that, the lock-in period. Such promoter contribution, minimum promoter contribution, for how much period they cannot sell it. So that lock-in restriction also we are having. When you complete these two for IPO and FPO, a major chunk of the chapter is done. So after that, only small procedural things that not only will be there. So we can start it. So the thing, when you see promoter contribution, this is a little bit what we can say. It will be difficult when you're reading in paragraph. So we have the chart. We can move to the charts. Now, here if you see, this is the chart for the minimum promoter contribution. I have already told you what is the logic for the minimum promoter contribution. Now we can move into the specifics. Like when you see what is the minimum promoter contribution, as I have already told you, it is the 20% of the post-issue capital. After the issue, what is the capital? 20% should be there with the minimum, should be there with the promoter. That should be the minimum promoter's contribution in the capital. Then this should be maintained by the promoter only. Promoter only should keep this 20%, but sometimes 20% is not possible by the promoter itself. So in that time, we need some other contributor. Such people, some other people, they will have the shares, but that will also be counted under the 20% requirement to be fulfilled by the promoter. So other people will have some shares, but that also shall be counted for the 20% requirement for the promoter. Now who are those people other than promoters? Who are the contributors? Who are the contributors towards the 20%? They can be alternative investment fund, foreign venture capital, commercial banks, public financial institution, insurance companies, non-individual public shareholders who is holding 5% of the post-issue capital, then any member of the promoter group other than the promoter. These people, if they are holding, they can also count this also towards the 20%. If promoter is unable to have 20% under his immediate ownership, then even if these people contribute, that will also be considered under the 20%. You can count that also for fulfilling this limit. Then here maximum 10% can be contributed by these people. So these people collectively they can do the help, but the maximum they can do is 10%. Remaining 10% should be mandatorily in the name of the promoter, should be there under the direct control of the promoter. Then where this particular condition will not be applicable, this minimum promoter contribution will not be applicable when there is no identifiable promoter. We cannot even identify the promoter. There is no promoter. Then this condition will not be applicable. Then manner of promoter contribution, how they can do the contribution. This 20% they can do it by way of equity share or convertible securities. Equity share they can have or convertible securities for the purpose of fulfillment of this 20% condition. So when you're giving us convertible securities, when you're maintaining your promoter contribution as convertible securities, and in such convertible securities, the price of equity share on conversion, like we will have the predetermined conversion price, 100 compulsorily convertible debenture we are having, we will have the terms properly, like it will be converted into 50 equity shares. The price of conversion will be 50 rupees per share. At this price, we will convert the debenture into equity share. So like that, the price will be determined. If this price is not determined, then what we have to do is that the promoter should contribute in the public issue of the convertible security. The convertible security should be issued to the public, and in that public issue the promoters should subscribe, the promoters should buy the convertible security from the public issue. Then the promoter should also give one promise that they will subscribe upon the conversion. Since the price is not determined, whenever the instrument, whenever the security, convertible security, it is going to be converted into equity share, the promoter should make a promise that definitely I will convert it to equity share, I will buy the equity share, I will subscribe to the conversion. Like that, the promoters have to give a promise. So this when it will be applicable, you are contributing in the form of convertible securities, and then the price of conversion is not determined. Then the issue of convertible securities. Now I have already told you that when we are doing the issue of the specified securities, this procedure will be applicable. Specified securities includes equity share and then the convertible securities. So when you are issuing the convertible securities, then what is the requirement for the minimum promoter contribution, that we can see. And when you see till now, for example, you are an unlisted company. Now you want to do the listing of your convertible debenture alone. You are not going to list your equity share. You are going to list only your convertible debenture. That also is possible. So for that only we are seeing the next requirement. Unlisted company till now, you are listing only your convertible debenture. So you are issuing the convertible securities to the public issue of convertible securities. The promoter is contributing by equity share. The promoter contribution 20% should be maintained. That is maintained by way of equity share. Then the equity share price, the price at which the promoter contribution is maintained, that should be the weighted average price of conversion. So I will explain a little bit deeper here. So here, how this promoter contribution will be maintained. So for example, 20% of the post-issue capital should be maintained. Now the current holding of the promoter, if you see that current holding is not enough. After the issue, this 20% will not be fulfilled. So now what the promoter should do? He should get new shares. Now this new shares he cannot go to the stock market because till now the company itself is not listed. So you have to get the new shares issued from the company itself. The company will issue new shares to you, so that after the public issue also you will have the 20% that requirement maintained properly. So that new issue you are doing, right, that you will be doing at a price. That price should be minimum the weighted average price of the conversion of the convertible security. So for example, you have issued some convertible security. You are going to issue some convertible security. For example, 1000 compulsory convertible debenture you are going to issue. In that, some compulsory convertible debenture, like 500 of them, will be converted on this particular day at 50 rupees per equity share. That is one terms. Then another 500 will be converted at this date at the rate of 75 rupees per equity share. So this is the conversion price for the compulsory convertible debenture. That is the convertible security that you are going to issue. Now the weighted average price you have to see. What is the weighted average price? And this should be the price at which you are issuing the new shares to the promoter. Why you are issuing the new shares to the promoter? So that the promoter can maintain the 20% post-issue capital minimum promoter contribution requirement. So I hope you understood this. So if you did not understand this, you can go a little bit back and you can rewind the video and you can watch this part alone again. This particular 2 to 3 minutes part alone again, you will understand definitely. So this is this point. The next point, when you see IPO of convertible securities without prior issue of equity share. So the IPO of convertible security without prior issue of equity share. Now the first time you are going to do the public issue, that also you are doing only for the convertible securities. Now the promoter are contributing in the form of equity share. Now how much they have to contribute? Whether it will be 20% of post issue capital? No, we are having a separate requirement. What is the requirement? 20% of the project cost. What is project cost? The project for which you are raising the money. 20% of the project cost or 20% of the issue size, whichever is higher. So 20% of the project cost or the 20% of the issue size. The issue which you are doing in that 20%, whichever is higher, that should be the minimum promoter contribution in the case of issue of convertible securities without prior issue of equity share. This 20% of proposed issue or 20% of post-issue capital, this you have to see it without the rights issue component. So in composite issue, we will do the public issue and the rights issue simultaneously. So we have to exclude the rights issue component. So when you see the proposed issue, in that we will take only the public offer, and then in the post-issue capital, when you see, in that also we will not take the rights issue component. So that is the composite issue special point when you are seeing a minimum promoter contribution percentage. Here, the first exception is the same, no identifiable promoter, then this requirement will not apply, this 20% requirement. Then exception 2, when you see, when these 3 points are fulfilled, then also no need to have the minimum promoter contribution. First point, equity shares are frequently traded. The shares are frequently traded. So since this is an already listed company, the shares will be already getting traded in the stock exchange. Then company is complying with the LODR for the preceding 3 years. LODR requirement the company is properly following for the preceding 3 years. Then the investor complaint received till the end of the previous quarter. Investor complaint received till the end of the previous quarter. 95% of the complaint received like that, that was resolved, that was redressed. So when 95% of the complaints were redressed, which were received till the end of the previous quarter, then also if these 3 conditions are satisfied, these are the 3 points. If these 3 points are satisfied, then you will fall under exception 2, and your company no need to give the any promoter contribution. Your promoter no need to have the minimum promoter contribution. There is no need to fulfill the requirement of the minimum promoter contribution for your company. Then the next point, when you see manner, in which manner they will do the promoter contribution, same thing when we saw 20% by way of equity share or convertible securities, you have to do it. When you are contributing by way of convertible securities, the price of conversion is not determined, then the promoter has to contribute through public issue of the convertible securities, and they have to give a promise that they will subscribe when the securities are getting converted. Then the next point, when you are issuing the convertible securities, the promoter is contributing by way of equity share. The price at which the shares are issued to the promoters for the promoter contribution, it shall not be less than the weighted average price of the conversion. So that also we saw with an example. Then the next point, when you see promoter contributed more than minimum required. So the promoter, for example, if we want 20%, they contributed more than this. Then what will happen? The excess contribution more than the percentage, it will be allotted at a issue price or price as per this regulation, whichever is higher. No need to go deep into this, what is this regulation and all. Just remember like this, issue price or price as per regulation 164, whichever is higher. When the promoter contributes more than the minimum, then we will follow this particular method. Then requirement, you have to satisfy 1 day prior to the opening of issue. 1 day prior to the opening of the issue. The amount of contribution kept in an escrow account, released along with the issue proceeds. Then SR equity share, when you are having the superior rate equity share, that will also be considered for minimum promoter contribution. So that point also they have given. So we have completed the minimum promoter contribution concept for both IPO and then the FPO. Now the next thing we have to see is the lock-in period. Lock-in period means the period for which the minimum promoter contribution shares that you cannot sell it. So after completing the issue, the minimum promoter contribution, you would have designated some shares, you would have allocated some shares for the minimum promoter contribution for the 20% capital. That shares will be marked. That shares you cannot transfer it after the completion of the issue for the particular lock-in period. So here that shares will be marked separately. So that's that particular share loan, shares which are designated for the minimum contribution, that you cannot sell it. That is called as the lock-in period. It will start from the date of allotment. So the lock-in will be from the date of allotment. When they are issued new securities, new shares for the minimum promoter contribution requirement, then from the date of allotment of that particular new share, or else date of allotment of the public issue. So that will be the starting date for the lock-in period. Then if the minimum promoter contribution, if it is done by both promoters and then the contributors other than promoters. So we saw that 7 people, right? The alternative investment fund, insurance companies, those 7 people. So promoter along with these 7 people, they will have the same lock-in period. So what is the lock-in period? In normal cases, it is 18 months. If majority proceeds used for capital expenditure, then the promoter contribution lock-in period will be 3 years. So for the promoter plus the 7 persons, it will be normal cases 18 months. Normal cases 18 months. Majority proceeds used for capital expenditure 3 years. Majority proceeds used for capital expenditure then 3 years. So this timeline you have to remember. This is very, very important. The next point is promoter holding in excess of the minimum contribution. More than the minimum contribution, the holding of the promoter, that will also be locked in, normally for 6 months. And if the majority proceeds used for capital expenditure, then 1 year, normally 6 months. Majority proceeds used for capex, then 1 year. This is the holding in excess of the minimum contribution. Then pre-issue capital held by other than promoter, it will be for 6 months. Other than promoter, there are people who are already holding shares in the company before getting listed. That pre-issue capital, the capital which was held by them before the issue, then that the lock-in period is 6 months. Now, this lock-in period for 6 months, that is for people other than promoter. But if the shares was issued to employees, then it is held by the employee benefit trust, or if it is held by the venture capital fund or alternative investment fund category 1 and 2, or foreign venture capital investor. For these people, even if they are other than promoter, they are having the pre-issue capital, then in that case also this 6 months will not be applicable. Normally pre-issue capital held by other than promoter, 6 months is the lock-in period. But employees, employee benefit trust and these people, if they are having the shares, pre-issue capital, then also this 6 months will not be applicable. They are exempted from the 6 months lock-in period requirement. So this is the lock-in period. Promoter contribution, promoter holding in excess of the minimum contribution, and pre-issue capital held by other than promoter. Then when you see the SR equity share, we saw that SR equity share, what is the meaning? It is having the superior voting right and it is locked in. We cannot sell that during the period of the superior right. After the superior right sunset provisions came into effect, like for after 5 years, the superior right equity share, SR equity share will become ordinary share. After the 5 years, you can sell it. There is no problem. But during that 5 year, you cannot sell it. So that is the lock-in period for the SR equity share. That you have to follow, and along with that, the above lock-in period, whichever is later. So that 5 years we are having, right, the sunset provision, that you have to follow. Along with that, this 18 months or 3 years, that also you have to follow, whichever is later. Then, so this is the lock-in restriction for IPO. Similar to that, we are having the lock-in restriction for FPO too. Here when you see minimum promoter contribution done by both promoter and then contributor other than promoter, the 7%. For that, in normal cases, 18 months. Majority proceeds used for capital expenditure, then 3 years, same provision. Then promoter holding in excess of the minimum contribution, normal cases, 6 months. Majority proceeds used for capital expenditure, 1 year. This also same provision. Here also from date of allotment only, the lock-in period will be there. For SR equity share, the same thing. But here when you see the pre-issue capital held by other than promoter, that will not be there in the FPO. So the lock-in restriction we have completed for both IPO and in the FPO. And this regulation 8A for the alternative eligibility offer for sale additional condition we already completed. Now we can go to the study material and see how much we have completed. Now this convertible debenture, convertible instrument point, that is pending. Now here if you see the minimum promoter contribution, this part we have completed, this part we have completed, and then this part also we have completed, this lock-in period also we have completed, this also we have completed, and from here the lock-in for other things, like other than the things we discussed above, for other lock-in period we are having, that also we have to see, that is pending, this part is pending. Then, so that we have completed, and the FPO when you see, here in FPO also the same, minimum promoter contribution, this point we have completed, and then the lock-in. In that lock-in also we have completed till this particular point. So from here also when you see this point, we are already having it in the IPO. When you complete in the IPO, the same thing will be here also. So if you do in one place, that is enough. In the other place, you can just give a plain reading. So now we can see the lock-in period for the other categories. Now the lock-in period point we are going to see is for the stabilizing agent under the green shoe option. So I will give you just one example of what is the green shoe option. Wait a minute, we can add one page. So here when you see what is the green shoe option, so we saw that we are having the issue, we are doing the public issue. In that we will set a number, like for example we will issue 1 lakh equity share. This is the number fixed by the company. But when you see in reality, the demand will not be the same as 1 lakh. It may be higher or lower. For example, we can take that we are having demand for 2 lakh equity share. 2 lakh people are waiting to buy the equity share. For 2 lakh equity share, there is demand in the market. But we are issuing only 1 lakh. So what will happen? Only some people will get the share. Remaining people will not get the share. Now what will happen? They will raise the demand. The people who were expecting but they did not get the share allotted, they will raise the demand and then the price of share will go up. So it will be a very big fluctuation in the price of the share. If we do this for each and every share, then whenever the IPO comes or FPO comes, the price of share will skyrocket, and once the demand gets completed, it will fall down to the ground. So for avoiding this volatility of the share price, we are going to do one thing that is called as the green shoe option. What is the green shoe option? In case of extra demand, what we will do? First, we will allot the 1 lakh equity share. After that, we will borrow the shares. We will borrow the shares. From whom we will borrow the shares? From the promoter. From the promoters and those people we will borrow the shares, and that borrowed shares we will allot to the extra demand who did not get the shares. For those people we will allot the borrowed shares, and after that when we are allotting to them, they will give the money, right? This will be allotted to the extra demand people. This will be allotted and they will give the money, right, for the shares. This money we will keep it in a special account, and after some time we may get the shares in the market. In the stock market itself, the shares may come for sale. From those places we will buy the share and then we will return the borrowed shares to the promoter. So either we will get the shares from the stock market using the amount that is there in the special account and we will return it to the promoters. Otherwise, if there is no shares in the stock market, everyone is holding the shares, no one is ready to sell the shares in the stock market, we are not able to get the shares in the stock market, secondary market, then what we will do? We will go to the company itself. The company will take the amount in the special account and then it will issue the fresh shares. And this fresh shares we will give it to the promoters instead of the borrowed shares. So what we will do, borrow the shares, allot it to the extra demand, we will get the money, that money we will keep in a special account. Either we will buy from the stock market using the money and we will return it to the promoter, or we will do fresh issue of shares, give the money to the company and we will give the fresh shares to the promoter. So this is the thing that will happen in the green shoe option. I have told you in a simplified manner. So just if you remember this for the green shoe option concept, that will be enough. So for this point only we are seeing the green shoe option. So the lock-in provision will not apply to the securities lent for the purpose of stabilizing agent for green shoe option. The securities you are lending, right? The thing is borrowed. Who is borrowing it? It is borrowed by the stabilizing agent. We will appoint one person as a stabilizing agent. That person only will do this. And when you are lending the shares to the stabilizing agent, on that shares the lock-in will not apply. So that point they have given here. Then partly paid securities. For example, if you are having some partly paid securities as minimum promoter contribution and it is locked in, then the lock-in period will be a special provision. So what is the special provision for such partly paid securities lock-in period? So it will be up to the date in which the partly paid shares become equal to the public issue shares. So here I will give you one example for that. We are having some partly paid up shares. Partly paid up shares as the minimum promoter contribution. So for example, in that partly paid up shares, out of 10 rupees face value, only 7 rupees is called. So we can keep it like that. 7 rupees is the called up value. And then the new public issue we are doing, right? In that, out of the 10 rupees face value, we called 9 rupees. Now here if you see, this partly paid up share is there as the minimum promoter contribution, and the called up money is less than the money called up in the public issue. In public issue we called up 9 rupees, but in partly paid up share as minimum promoter contribution we only called up 7 rupees. Now these partly paid up share will be locked in for the period. When the lock-in will release, when it will release is that after calling the 2 rupees, after making it equivalent to the public issue share, after calling the extra 2 rupees and making it 9 called up, only then these two shares will become equivalent. So here also we have to call 2 rupees and we should make it 9. After that we have to wait 3 years. So make the shares equivalent. That is call the amount. After that wait 3 years. After that only the lock-in will be released. So here if you see, it will be released only on the expiry of 3 years after such securities become pari passu with the securities issued to the public. This means in the same rank, when both become in the same rank. Like here, this is in one rank, 9 rupees called up. If you want to make it to the same rank as this share, you have to call 2 rupees. Only then these two shares will come to the same rank. It will be in the same rank. So after that you have to wait 3 years. After that only the lock-in period will get released. Then if you are going to pledge the locked-in securities, whether you can do it, you can give it, it is possible, but you have to give it to the scheduled commercial bank or public financial institution or systematically important non-banking financial company or a housing finance company. Only to these institutions you can pledge the securities. Then when you do that lock-in and you are pledging it with the particular institution, what will happen is that you have to see in which type that securities are locked in. So there are two types, 16A and then 16B. This is nothing but we already saw. Lock-in in 16A is nothing but 18 months or 3 years. Here it is 6 months or 1 year. There this is the minimum promoter contribution plus the 7 people, and here it is the holding in excess of the minimum promoter contribution. So for this we already saw that 6 months 1 year lock-in period, 18 months 3 year lock-in period. If the lock-in period is 18 months or 3 year, then we will consider the proceeds of the issue in one manner. If the lock-in period is 6 months or 1 year under this regulation 16B, then we will consider it in another manner. So if it is under 16A, then we will consider that the loan is granted to the issuer company for the objective of the issue. So, in this case, we will consider that the loan is being given to the company, not to the promoter. We are giving the loan to the company. Like that, we will assume. Then, if the lock-in period is under this particular case, then we will consider that the loan is given for the purpose of the is one of the terms of sanction of the loan. If it comes under regulation 16B, then we will consider that pledging the securities was one of the terms of sanction of the loan. So that they have given. So that they have given. And one more point here is that even if the loan is not repaid and then the securities was transferred to the particular, like the person got the loan, the promoter or the other person, they got the loan and then the loan they did not repay. Now the bank took over the securities in their custody. Then also the bank will not be able to transfer the securities till the lock-in period gets completed. Even the bank also, they have to keep the securities with themselves till the end of the lock-in period. Then transferability of the locked-in securities. So here they have given that the locked-in securities you can transfer it to another promoter or any other person of the promoter group or a new promoter, you can transfer the locked-in securities also. Then the securities held by other than promoter which are locked in. Like we saw that, right? Persons other than promoter, they are holding the securities, their lock-in period will be 6 months. If your shares are under that particular lock-in, then you can transfer it to another person who is holding another locked-in security. For example, the company is there, that company security you are holding, your lock-in is for 6 months. The company is A limited, you can take. Now this security during the 6 months period you can sell it to another person, but the other person, he should already have the A limited company security which are locked for 6 months. That particular security should already be there with the buyer. Only then you can sell the locked-in security to him. So that point they have given. So this you can just give a reading. Now we have completed all the lock-in provisions. Now it will be applicable in the same manner for the further public offer also. You can give a reading in the FPO part. Now we have completed the lock-in period, that particular regulation. Now the next thing when you see here, we are having the disclosure. What all the disclosure you have to give? That point we are having. This is just the procedural point, but I will give you an idea. Like all the material disclosure should be there in the draft offer document and in the offer document. All the important things should be mentioned there. All the disclosure as per the Companies Act, as per the party of Schedule 6 of this regulation, should be there in the draft offer document and in the offer document. The lead manager should exercise due diligence and then satisfy themselves that all the regulations are properly followed. Then the lead manager shall call the issuer promoter director to fulfill their obligation. Then the information contained are not more than 6 months old. That should be ensured by the lead manager. He should verify that the information is properly up to date, that it is not more than 6 months old. It is the latest information that should be verified by the lead manager. Then, for this process, we are having one chart for this. We can see it there. So, if you see that, it will be over. So, we can see from the chart this filing of draft of a document, this part. So this is the chart for this draft offer document filing and offer document filing. The step 1, what will happen? The company will prepare the draft offer document. It will give 3 copies to SEBI. It will hand over 3 copies to SEBI. And then to the stock exchange, you have to give some details. What are all the details? Passport number or corporate identification number. Individual means passport number. If it's a body corporate company, then corporate identification number. PAN number you have to give. Bank account number, bank account details. You have to give it to the stock exchange. After that, for the website, you have to display the draft offer document in the website of the stock exchange, SEBI, merchant banker. The draft offer document you are filing with SEBI should be displayed in the website of these 3 people for 21 days for inviting public comments. The draft offer document in these website, 21 days for waiting for public comment. You sent for SEBI, right? That you will get the observation from SEBI. That is one more step. The second step, when you see, you have to give the public announcement. You are doing all this in the step 1. After that, after filing with SEBI, within 2 days, you have to give the public announcement. Like we are going to bring an IPO. This is the draft of a document. It will be there in the website. That all you have to give it in the newspaper public announcement. It should be given in one English newspaper, one Hindi newspaper, one regional newspaper. Everything should have the wide circulation in the particular region. Then the regional newspaper, it should be in the region where the registered office of the company is situated. In that region, the newspaper should be circulated. So this is step 2. Step 3, when you see, you send to SEBI, right? SEBI will give the observation or change. What all the modification you have to do, anything you have to include, any disclosure you omitted, that and all will be observation given by SEBI within 30 days. SEBI will give the observation within 30 days. Then step 4, you have to incorporate all those observation or changes. You have to do all the corrections. Then give the updated offer document to the SEBI. SEBI, you have to give the updated offer document. Compulsorily, you have to follow all the observations. That is one important point. After that, step 5, what will happen? The company will send the updated offer document to the ROC and then the stock exchange. First, we are sending to SEBI, then to ROC and the stock exchange. After that, the offer document will be given to the public. Now here you have to ensure that the offer document you are giving to SEBI, ROC, stock exchange, public, everything should be properly updated and should be the same version. You should not give different versions to each people. It should be the same version. That you have to make sure. So this is the filing of draft offer document and then the offer document process. So now we can go to the study material. So here when you see all the points are covered, the 3 copies and then all the points are given here, you can see it. Now the next thing when you see, pricing. What should be the pricing? When you are using the book building process, this should be the pricing mechanism. I already told that a price band will be there and then based on the demand and then the application for bidding, they will decide the final price. Now for that they have given some points that you can read by yourself. Nothing big to explain on that and all. Then differential pricing, you can give the differential pricing for the same security based on the buyer, for the retail individual investor you are issuing, or based on the anchor investor, or you are giving it to the qualified institutional buyer. Based on that, you can change the price. So differential pricing guidelines also they have given. How much maximum discount you can give. How much maximum discount you can give. That will be based on the differential pricing regulation that is given here. And one more point I would like to tell you here, one more important point is that the minimum subscription. We are having the issue right in that minimum subscription should be achieved. Only then the issue will be carried out. Otherwise, it will be considered as a failure of the issue, and every single rupees that they received, it should be refunded. So, what is the minimum subscription? 90%. 90% should be minimum subscribed. Only then it will be a success. Only then they can proceed with the issue. Otherwise, it will be considered as a failure, and then the entire money should be refunded. So, this is why we have to issue the shares. We have to make the people buy even by giving some discount. So that's why discount will be issued in the shares. And this discount, how much maximum you can give, that is based on the differential pricing guidelines that we saw, that I told you to read. That will be applicable when you are giving the discount for different categories of buyer. So that point also I have told you. Now here price band, differential pricing. Now issuance condition and procedure. What is the procedure? Opening of the issue. Then what is the opening of issue? Here the opening of the issue will be within 12 months from the date of observation by SEBI. So the SEBI will give you observation right. From that date you have to open the issue within 12 months. Within 12 months you have to open the issue. Then in case of prospectus and red herring prospectus, you have to open at least after 3 working days from the date of filing. So red herring prospectus you will file it after that within 3 days. Sorry, after 3 days. After red herring prospectus you have to file it after 3 days. You have to open the issue. Opening of issue means the issue will be open and people can purchase the shares. Public can bid or they can purchase the shares. So that is called as opening of issue. And then the minimum subscription, we already saw that 90% should be achieved. Then if the minimum subscription not achieved, then the money should be refunded within 4 days. If you do not refund it properly, 15% interest you have to pay. Then period of subscription, opening of issue is happening. For how much period the issue will be opened? For how much period we can make the application. So that period, that is called as the period of subscription. It will be open for at least 3 working days and not more than 10 working days. So minimum 3, maximum 10 working days, the issue will be open. You can place the application. Then if they are making any revision in the price band, you are changing the price band, then you can extend the period for a minimum of 3 working days. You can extend the period. 3 working days you can give extension, but it should be coming under the 10 working days. Maximum 10 only. Inside that you can give extra 3. There is no problem. But even if after giving 3, it should not go beyond 10. Up to 10 is the maximum limit. Then if there is any unforeseen circumstance like force majeure or banking strike, then in that case you can give 1 day extension subject to the provision of sub-regulation 1. Here also 1 day you can give the extension. Then application and minimum application value. So the minimum application lot they can decide. Minimum for one application this much share you can buy. That minimum application lot they will specify. So that related things also they have given. Then manner of calls. If you are not receiving the entire money in the application itself, you are receiving in calls. In installments you are receiving the money. Then you have to get the entire calls within 12 months from the date of allotment. From the date of allotment within 12 months the entire money should be received and called and received. Then if any applicant is not paying, the entire money will be forfeited. So this and all we would have done in the company accounts, in CA Foundation and all. So that I hope you remember. Then okay, if you are not getting the money within 12 months, like mandatorily you have to get the money within 12 months. But if you are appointing a monitoring agency, we are having monitoring agency, we have to appoint it. If you are appointing that, then you can get the money even after 12 months. There is no problem. Normally 12 months, but if you are appointing the monitoring agency, then you can get the call money even after 12 months. Then allotment procedure and base of allotment, that also they have given. So this and all normal provision only, you can read it, there is no problem. So we would have studied in company accounts, right? If there is oversubscription, what to do, that point and all they have given here. Then allotment, refund, payment of interest. Here only we are having if the securities are not allotted and the application money not refunded, then you have to give the interest at 15% per annum. That point we are having. Then post-issue advertisement. After completing the issue, you have to give an advertisement like details. What are all the details relating to the issue? What is the subscription done? Basis of allotment, number, value, percentage. Everything should be given in the post-issue advertisement. That should be given within 10 days from the completion of various activities. In one English newspaper, one Hindi newspaper, one regional newspaper. Then release of the subscription money. After all the formalities are completed, you can give the intimation to the banker that the banker can release the money to the company. So that related information also they have given. Then if the issuer fails to obtain the listing or trading permission after completing the issue also from the stock exchange, if the issuer does not obtain the trading permission or the listing permission, then you have to refund the entire amount. If you do not refund, you will get 15% interest. The company has to pay 15% interest. Then reporting of the transaction of promoter and promoter group between a particular date, like from the date of filing the draft of a document, from the date of filing draft of a document till the date of closure, you have to in between this period the promoter and then the promoter group members, those people, whatever the transaction they are doing in stock exchange, that they have to report it. Whatever the transaction they are doing in stock, that they have to report to the stock exchange within 24 hours of such transaction. Then post-issue report, they have to prepare a post-issue report and they have to file it. That and all they have given. Then, so we are having one restriction on further capital issue, like from the date of filing the draft offer document till the date the securities are listed. Between this period, you cannot do any new issue. You are already filing one document for one issue. You cannot do any new issue during this period. So, if you want to do any new issue, you have to disclose it in the offer document itself, draft offer document itself. In the draft offer document, if you have given some disclosure, like we are having some other purpose, like that we'll be doing a new issue between this period. If you are giving the disclosure in the draft of a document, then you can do the issue. There is no problem. Normally, you should not do any new issue between this period. But if you are giving the disclosure, then you can do the new issue. So that point also they have given. Then green shoe option, I told you, right? That related option, that points they have given here. The option for stabilizing the price. There is over demand and we are going to borrow the securities and we are going to allot to them. So that related points also they have given here. For this and all, I have explained you the main essence. Just if you read the things, you will be able to understand. Then the securities we are having that you are allotting to the people, you cannot alter the terms and condition of the security, like the voting share, the rights, or that things you cannot alter it after allotment. If you want to change the terms, you have to get the consent of not less than 3/4 of that class. For example, one class of shareholder, you want to change the rights, change the terms. Then you have to get the consent. You have to get the consent of 3/4 of the shareholders in that particular class. Then you can do the change. Or when you're getting the special resolution also, you can do that. Then if you are changing the objective, after doing the issue, you are changing the objective of the proceeds, or you are changing the objective or variation in the terms of contract, then in that case, you have to give an exit offer to the dissenting shareholder. For example, you are doing an issue. You are telling that I will invest it in the steel plant. Like that, you are giving in the draft of a document and you are doing the issue. After completing the issue, you are changing the objective and you are changing it to some particular furniture business. Now, all the people who are now shareholder, they invested in the issue, believing that you will invest it in a steel plant. Now you are changing the objective to furniture business. Now you have to give an exit option. People who don't want to stay in the company after the change in objective, they can get the money and they can go away. So that is the exit option. That also you have to give it. So now we have completed the entire IPO. I have given you the overview of the points and I have given you the deepest explanation of the points wherever needed. So the relevant points, here the symmetrical points, the respective points you will find in the further public offer also, that you read it by yourself one time, you will be able to easily understand. So that is the thing. Then one more thing I told you, that we have to see the convertible debenture, issue of the convertible debenture, debt instrument and warrant. So here if you see, an issuer can be eligible to issue convertible debt even without making a prior public issue. I already told that even without making the public issue of equity share, you can directly do the public issue of the convertible securities. So that also we are having. Then at the time of issue, so when you are doing the issue of the convertible security, default should not be there. That default more than 6 months should not be there. Default more than 6 months should not be there at the time of issue of convertible securities. So this means that even if you are having a default, if it is less than 6 months, then no problem. Default less than 6 months, no problem. Default if it is more than 6 months, then you cannot do the issue. Here if you see, not in default for interest payment or principal repayment for more than 6 months. So up to 6 months default, even if you are having at the time of issue, no problem. More than 6 months default at the time of issue should not be there. Then you should get the credit rating, you should appoint the debenture trustee, you should create the debenture redemption reserve, you should create the charge on the asset. If you are pledging the asset, if you are creating a secured debenture, then you have to keep the asset, you have to create a charge and that asset you have to allocate for that particular debt. If the debt you did not pay properly, the debenture holder, they can sell the asset and they can recover the money. So that related point they have given. So these are normal points only. When you are creating pledge, when you are creating charge, when you are creating on a new asset, there is no problem. But when you are creating on an asset which is already charged means already on the asset and charge has been created. Now on that asset, if you are creating a new charge, then what is the procedure? For that they have given some 2 points. Then how to redeem the debentures? What will be the repayment terms? That will be in the offer document. Then conversion. So you can convert the debentures, convertible instruments. The main feature of the convertible instrument itself is that you can convert it into equity share. So that related points. So here what they have given is that if it is an optionally convertible debt instrument, then you have to convert it only after getting the consent, positive consent of the holder. If it is optionally convertible, you have to get the consent first. And here, if you are getting no reply, you are sending the notice but no reply regarding the conversion. So you should not consider it as a consent. Only if they give the express reply. They should give the proper reply, positive consent. The word positive consent, they have used it. So they have to give express consent. Only then you can convert the securities into equity share. Then no option is provided. So for this point, I will give you one example. So here if you see, we can take one example. We are taking a debt. We are issuing the convertible securities. The total amount we are issuing is 25 crore rupees. And in this 25 crore rupees, at the time of issue, the conversion price we have to decide, right? One debenture will be converted, like the amount will be converted into shares at what price? Conversion price of the share. At the time of issue, we did not determine. Now what happens is that at the time of conversion, at the end of the debenture, at the end of the tenure of the debenture, what happens is that the terms was 50% of the principal amount will be converted to equity share. Only that is given. The price in which it will be converted, that is not there. But the amount will be converted to equity share, 50% of the principal amount. So how much will be converted? 12.5 crore. Now this amount will be, this 12.5 crore will be called as the value of the convertible portion. When this value of the convertible portion becomes more than 10 crore, then what you have to give this, what you have to do is that you have to give an option to the holder. What option you have to give? Option of not converting. You have to give the option of not converting. They can get the cash. That option you have to give them. The value of the convertible portion becomes more than 10 crore. You have to give the option to the holder that they can leave them not converted. Like they can get their cash. Instead of getting the equity share, they can get the cash. So that option you have to give it to them. So that point they have given here. Then if the upper limit of the price and justification is determined and disclosed at the time of making the issue. So the conversion price, that and all they decided at the time of issue itself, then no need to provide such an option. The next point when you see, right to redeem to the issuer. Now here we already saw that the company has to give the option to the holder that they can get their cash. If they demand the cash, you have to settle the cash to them. So that they have given here. And one more point, they initially at the time of issue, they did not decide the conversion price. But now how they will decide the conversion price? It will be decided at a general meeting of the shareholders. The shareholders, they will be conducting a general meeting, and in that general meeting, the shareholders will vote and they will find the price, the conversion price at the end of the tenure. And the price which is decided by the shareholders at the general meeting is not okay for the holders, then they can get their cash. So that point is this right to redeem to the issue, right of redeem to the issuer. Then if they have given disclosure in the offer document, like we will do this, there should not be any opposition from the holders. Like that, they have given something in the offer document. They have given the manner clearly, in which manner it will be done. They have given it clearly. Then there is no option will be given. Like the option to not convert, that null will not be given if this clearly given in the offer document. Now, the issue proceeds of the convertible securities. You are issuing the convertible securities, you are collecting the amount. That amount you cannot use it for this purpose. What is the purpose? The purpose is, first purpose, giving loan to the promoter group members or promoter group companies. So, if you are giving loan to them, then for that purpose you cannot use the amount. And if you are giving, you are using the amount for acquiring the shares of those companies, then also you cannot use the convertible debenture proceeds. That particular amount you cannot use for these purpose. But this is normally, it is not allowed. But you can use it if the convertible debenture tenure is less than 18 months. The tenure of the convertible debenture itself is less than 18 months. Then you can use the proceeds for this purpose also. There is no problem. Normally, for this purpose, the convertible debenture proceeds, that is not allowed. But if the tenure is less than 18 months, then you can use the proceeds for this purpose also. Then issue of warrant, for this we are having one chart, we can see there. So that's all about the issue of convertible debenture. Now the same thing we are having in the FPO, further public offer also. Some 1 or 2 points might be extra or a little bit changes might be there that you can give a reading. You will be easily understanding it because you are understanding this IPO provision clearly. Now we can go to the chart for seeing the warrant provision. Now here if you see, this is the chart for the warrant. Regulation 13, this is from IPO. Now when you see regulation 111, this is from the FPO. So both are same only, but here if you see, the tenure will be up to 18 months. Tenure will be up to 18 months for the warrant. What is a warrant? It is an instrument, it is not a share, but you can use that to get the shares. You can use the warrant to get the shares at a predetermined price. Already the price will be decided for the particular share when you are purchasing the warrant. The warrant you can later you can give it and get the shares. The price will be determined, that is one point. Then to one security you can attach one or more warrant. To one particular security, to one debenture, you can attach two warrant. So this is one package. One debenture plus two warrant will be issued to each person, so that you can do it. Then 25% of the consideration to be paid upfront. So like that, for example, one warrant you are having. In that we have decided that for one equity share, the price will be 10 rupees. Now you are issuing one warrant. One warrant will be giving one equity share. Then in that case, 10 rupees into 25 percentage, 2.5 rupees you have to pay upfront. When you are purchasing the warrant, so you have to pay upfront 2.5 rupees. Later, you can give the warrant, pay the remaining 7.5, and get one equity share. So that is the mechanism of warrant. And you gave the 2.5 rupees, right? And later you did not redeem the warrant. Then the 2.5 rupees will be forfeited. And the time within which you have to give the warrant and pay the 7.5 and get the equity share, that timing will be maximum 18 months. That is the meaning of tenure. Then the tenure, the last day will be there. Last day for exercising. Last day for exercising means you can use the warrant and get the share. So the last day will be there. Within that, after that 3 months we will wait. 3 months from the last day for exercising the warrant, we will wait. If you do not come, we will forfeit the amount, then we will cancel the warrant. So that only we have given here. Same, tenure up to 18 months, one or more warrants can be attached to one security, predetermined exercise price or formula, 25% of consideration to be paid upfront, and if option not exercised within 3 months, then 25% of the upfront consideration that will be forfeited. So this is the issue of the warrant. Now we can see the study material. So here when you see issue of warrant, regulation number 13 we have completed, and the same thing in the FPO, that also we would have completed. In FPO also the warrant provision. Here also we are having the issue of convertible debenture. Issue of the convertible debenture. Here we are having the warrant point. Issue of warrant. This point also we have covered. So when you see majorly all the parts we have covered, but we have not covered some parts that all not that much important, and you can read it by yourself. So those are all will be from the procedural part or like that. So it is not the main essence of the ICDR. So I am not covering it. Now you can cover those parts by yourself, you can read by yourself, you will easily understand. Just the main regulation I have covered here. How much it is possible I have covered within the time that I have allocated for this particular topic. They cannot take too long also. So I have completed this ICDR within the shortest possible time. The main portions, like 80% of the provisions, the main provisions I have covered here. So if you prepare this bill itself, it will be enough for you. So the remaining portion which I have not covered, it is manageable. You can cover it by yourself. So that's all about the ICAI regulations. If you found this video useful, if you learned from this, if you understood my teaching, if you understood my explanation, you can share this with your friends. You can subscribe to the YouTube channel and you can like this video so that this video will be reaching a lot of people and it will be helpful for them also. And you can leave your comment for the suggestion of this video, whether you liked it or not, what you want to change, that now you can tell it in the comments. So that's all about the ICDR regulations. And one more thing, the notes I'm using, the highlighted one, that will be available in the Telegram channel and in the WhatsApp channel. The link will be given in the description and in the pinned comment. You can join those platforms by using those links. Now we can start the substantial acquisition of shares and takeover regulations. So before the insider trading regulations, we are going to see the substantial acquisition of shares and takeover regulations first, because the reference of one term, like the term is open offer. The reference of the term open offer we will be seeing in the insider trading regulations, prohibition of insider trading regulations. So we have to first complete the open offer point. That open offer point is in the substantial acquisition of shares and takeover regulations only. So first we can do this, then we can go to the insider trading regulations. Now, here if you see, what is the meaning of this regulation? First that I will tell you. Now here if you see, what is the meaning of substantial acquisition of shares and takeover? Substantial acquisition of shares and takeover. Now, takeover means we all know that we are going to take over the control of a company. The control of the company will shift. There is a shift in the control. From now on, the new person will control the company. That is the meaning of takeover. Then, when you see the substantial acquisition of shares, so we are buying a lot of shares of the company, buying a high amount of shares. That is the meaning of substantial acquisition of shares. So, what is the meaning? From here also, there might be a change in the control or significant influence you can exercise when you are purchasing a high amount of shares of the company. High amount means for now you can keep it as 25 percentage, for example. 25 percentage will be the value. High amount of shares, if you buy that, you will have a significant influence in the company. Now, control means you are taking over the company entirely. That is another thing. Now, here if you see, what will happen is that we are having one company. Now, that company is normally operating, there is no problem, nothing is having. This company is having its shares listed on a stock exchange. Now, some persons, either individually or as a group, they are purchasing the shares of the company slowly. Purchasing the shares slowly, not in a single transaction, but they are purchasing small amount of shares on a continuous basis. They are doing multiple transactions, then they are slowly accumulating the shares of the company. Now, suddenly, after some months or after some 2 or 3 years, when you see these people, they are having about 40 percentage of the share capital of the company that they are purchasing by the way of shares. Till now, they accumulated the shares by purchasing in small amounts on a continuous basis. Now, at the end, they are having 40% share capital of the company. Now, when you are investing in the company, what you will see? When you are investing in the company, you will see the financial statements. You will see the future of the company, whatever the projects they have acquired, whatever the tender they have acquired, and what is the demand for the product of this company in the future. And at last, you will see the management of the company. Who's the management of the company, who is controlling the company, that you will see. If you have the trust in the management, only then you will invest the money, because this is the management are the persons who are going to run the company. So if they are good, they are having the potential, only if they are having the potential to grow their company, the shareholders will get returns. So the management should be of persons who are having potential to grow the company. Now, management is one big reason why you are investing in any company. Now, suddenly if the management changes, suddenly the control changes, will you have the same trust in the company? That is the question. Management is one important reason. Suddenly it changes, and will you have the same trust? No, definitely not. Because the old management, they had the track record. They had all the prospects, and till now they only built the company to this level. Now, after this, what will be the future of the company? That depends on the management only. If that changes control immediately, then you will not have the same trust. You have to wait and see whether the new management is performing properly or not. So the trust will be lost. Now, what will happen when the trust is lost? All the shareholders, they will try to sell the shares, or else they should be given an exit option. They bought the shares on the trust that the company will be under the control of the old management. Now the new management has come. They will all sell the shares. They should be given an exit option. They should be given an option to exit out of the company because they don't like the new management. They dislike the new management. So this is one particular reason. Now, if 40 percentage of shares are acquired these persons, and now these persons take over not take over, they can significantly influence, or they are going to control the company in any manner, because they are having 40 percentage together in an accumulated way. They are having it, so they can influence any decision of the company. Their voting is also required if you want to take any decision in the general meeting, or whatever the special resolution you want to pass, or ordinary resolution. Everywhere, the consent of these shareholders is very important. These persons who have acquired the shares. Now, the management has indirectly changed the control. Now, these persons will also control the company because they're having a substantial amount of share capital. More than 25%, they're having 25% or more. They're having it. So, this will create a change in the control. Now, for this, what we have to do? Now, after doing this, 40% of share capital, we have to give an exit option. What is the meaning of exit option? All the shareholders who do not like the control of these persons, they will give their shares. They will sell their shares and then they will get their money. They will sell their shares, they will get the cash. Now, for example, this is the company of Reliance. This is currently managed by Mukesh Ambani. He is a key managerial personnel we can take. Now he is the one controlling the company. Immediately we are getting Vijay Mallya. Now he is purchasing the shares of Reliance. Now he gets a substantial amount of share capital. Now all the people who are having shares in the company of Reliance, they will get a doubt. They will not have the trust. So they will try to sell the shares. This will crash the share of the company. This will reduce the share price of the company. So that's why we are having the regulations. According to the regulations, we will give the open offer. And in that open offer, all the shareholders who do not like the Vijay Mallya sitting in the management. Now, what they can do? They can sell their shares, they can get their cash. This will give an exit option for the shareholders who do not like the new management. So that is the entire philosophy of the substantial acquisition of shares and takeover regulations. Now, this is the meaning of open offer. The offer where where the shareholders who do not like the new management, they will offer their shares for sale. They will sell their shares to the new management. The Vijay Mallya, he will buy the shares sold by these shareholders and he will settle the cash for the shareholders who want to exit. So that will be happening under the open offer. Now we can see here. The persons who are acquiring, right, these persons, they will be called as acquirer plus person acting in concert. Acquirer means the person who is acquiring, that is plain meaning. Then person acting in concert means persons who are working with the acquirer with the same objective. Persons having the common objective with the acquirer. The common objective is to purchase the shares of the company and take over or to take control of the company or to influence the company. So that is the meaning of person acting in concert. These two persons, when they are together, they are getting some substantial amount of the capital. Then that will be a problem. For that, we have to give the open offer, exit option. Now here if you see, this is the open offer trigger point. When you have to give the open offer, we already saw that when you're having a substantial amount of shares, you have to give the open offer. When you're getting 25% or more of the shares, either by acquirer or along with the person acting in concert, you have to give the open offer. In the open offer, you have to allow the shareholders to sell their shares and get the cash. Now here if you see, the open offer trigger points, first point, acquirer plus person acting in concert, they are having 25% of voting rights. So they are having some shares. Because of that shares, they will get 25% voting rights. So here we are having we are not having the number of shares properly, but we are having the voting rights clearly defined. The such number of shares you should have such that you are getting 25% of the voting rights. Why we are having this voting rights point, not the direct share capital, is that we are having different types of shares. Normal shares we are having, differential voting rate shares we are having. So this we can also call it as the SR equity shares, superior rights equity shares. Like for example, normal shareholders, they will get one share one vote, but the superior voting rate shareholder, they can fit it in any manner. For one share they may get 100 votes, or for one share they may get 1000 votes. So like that they may get different voting based on the SR equity share. So we are not taking the equity share number, we are taking the voting percentage, voting rights percentage. So 25% voting rights or more, such a number of shares, if it is there with the acquirer plus person acting in concert, they can buy it, but they have to give the open offer. Before buying it, they have to give the open offer. If you are going to buy 25% or more, first you have to give the public announcement, open offer, you have to give an exit option. After that, you can purchase 25%, there is no problem. They should need to make an open offer before acquiring such additional shares. So then acquirer along with person acting in concert, they are already having 25% or more. They are already having 25% or more. Now they want to acquire extra 5% voting rights. Shares for extra 5% voting rights. Additionally, they want to buy shares for extra 5% voting rights. Then also they have to give the open offer. So when they are doing the substantial acquisition 25%, and when they are additionally acquiring 5% in a at the same time, like 25 they are having, now they are slowly purchasing, they are purchasing extra 5%. Now before touching the extra 5%, they have to give the open offer. So they have to give the open offer. After that only they can purchase the shares that gives them additional 5% along with the existing 25%. Now this is a COVID relaxation that is not relevant. Now, if you are purchasing the shares as per a resolution plan under IBC 2016, after the completion of corporate insolvency resolution process, we will get a resolution plan approved by the NCLT. As per the resolution plan, if you are buying the shares, then that obligation is not there is exemption from this obligation. No need to follow this. Then explanation. So here you will take the gross acquisition, this 5% acquisition you are having, right? That you will take the total purchase. Even if you purchase 5% and you sell 2%, net when you see 3% only you have bought the shares. But we will not take this 2%, we will take the 5% only. You are trying to buy the 5%. Before buying that, you have to give the open offer. Then, if you are giving new shares, now the person already has 25% or more shares. Now you are giving new shares to him. Now what we will see is that what was the voting right before and what was the voting rights after. Now this difference will be seen as the additional acquisition. This will be considered as the shares which you have additionally acquired. Then you have to give the open offer that we already saw. Now we have to see the aggregate change, the change in the individual manner, not in the aggregate manner. So here if you see, for example, acquire we are having, person acting in concert we are having. So he had some, they both are holding 25%, there is no problem in that. Additionally, the acquirer had 3%, person acting in concert had 2%. Now here if you see, person acting in concert sold 2%, acquirer acquired 2%. Now total when you see, 25 is same, there is no problem in that. Here, now also 5 we are having, earlier also 3 plus 2, 5 we had. Now there is no change in the total shareholding when you see acquirer plus person acting in concert. But the change in the individual proportion, acquirer only had 3% earlier. Now he is having 5%. So in that case also this open offer will be triggered. Not only, you should not only see the aggregate, you should see the individual proportion also. That also they have given. Then this will not apply to the acquisition by the promoter or shareholder in control. So already we are having some management, the current management, they are holding a majority number of share. Now these people, if they are buying more share, buying additional share, which they have listed in the stock exchange, the people who are in management, they are buying the shares, then this regulation will not apply. So we are not regulating the persons already in the management. We are regulating the persons who are new and they are trying to come into the management. They are trying to take over the company. They are trying to influence the company. We are regulating those persons. Then, if the company has listed the securities on innovators growth platform, so they have listed on the innovators growth platform, then the percentage, 25% or more we are having, right? That we have to see it as 49% or more. We will see 25% normally. If in innovators growth platform we are having shares listed, securities listed, then you have to see 49% or more. Then the open offer will trigger only when you are having 49% shares, when you are trying to acquire 49% voting rights. Then acquisition of control. You shall not get the control without making the open offer. You have to make the open offer. What is the meaning of open offer? Here we are having one term called as the target company. The company in which the acquirer wants to take the control, that is called as the target company. So in the example we saw, this was the target company. Now that is the meaning of target company they have given here. In the target company, to the shareholders, to the existing shareholders of the target company, you have to give an offer. You have to give an offer to purchase the shares which are there with the existing shareholders and settle them cash at a particular price. Now the price and all will be determined as per the regulations only. Then this will provide an exit option as we already saw on account of the change in control. Then a voluntary open offer is an offer made by a person or acquirer plus person acting in concert. They are already holding 25% or more shares. They want to voluntarily give the open offer. They want to voluntarily give the open offer, acquire the shares of the existing shareholders, and they want to increase their voting rights percentage. For that, the persons can give voluntary open offer if they are already having 25% or more shares. Then no need to wait for the 5% additional shares condition. They can give them voluntarily. They can give the open offer voluntarily. The price at which the shares will be purchased by the, what we can say, the acquirer plus person acting in concert, that will be called as the offer price. Then, if the offer price is decided and from the date of opening of the offer, we will have an offer period. We will have an offer period. During this period, the existing shareholders, they can offer their shares. If they do not like the new management or the change in control, they have to offer their shares. They have to tender their shares. Whoever tender their shares, it will be considered by the person. It will be considered by the acquirer plus person acting in concert. They will buy those shares. Now, when they are deciding the offer price and before the offer opening date, before 3 days, if you want to make any upward revision, you can do that. If you want to increase the price, earlier you decided 20 rupees per share, now you want to make it 25, then you can do it prior to 3 working days. That point also they have given here. Now, the next thing when you see direct of the target company. Now, during the offer period we are having, right, till now we have not purchased any shares of the shareholders. They have just given the offer. Now only slowly all the shareholders are coming and they are tendering the shares. They are offering their shares for purchase by the acquirer. So they are now only tendering the shares. Here what will happen is that in between the offer period, in the target company, whether the representative of the acquirer plus person acting in concert can they be appointed as the director in the target company? That is the question. Till now, nothing has happened. Just the open offer has started. After the completion of the entire process only, you can give the representation in the board of directors. When you are appointing the representative of acquirer plus person acting in concert as a director, this means that you are transferring the control. You are putting such person in the board so that they can also view the operations, they can also give the influence, they can also influence the company's decisions. This should happen only after the completion of the open offer. During the open offer period, you should not place any representative of the acquirer plus person acting in concert as the director in the target company. So I hope you understand this. Then and then you will give a detailed public statement. So here you will give a detailed public statement when you are doing the open offer, and from the date of detailed public statement you have to wait for 15 days. And after this 15 days, you have to check whether the money is deposited or not. What money should be deposited? When you see we are having the open offer, in that we will be deciding the consideration. Totally this much shares we are going to buy, totally this much price we are going to pay, like totally 100 crores of the consideration, like that we are having the consideration. Now, after 15 days from the detailed public statement, if the money is deposited, this money 100 crores, it should be deposited in a separate escrow account. That account is specially for the purpose of the substantial acquisition of shares and takeover regulations only. This amount, when they deposit, they cannot withdraw. This can be only used for the payment of consideration for the shareholders. Only for that purpose you can use it. That is the meaning of escrow account. It is a bank account. It is attached with a condition. So that is the meaning of escrow account, that you cannot withdraw. If you check that after 15 days from the detailed public statement, the money is properly deposited, then you can appoint the persons. So they have already deposited the money. Then you can appoint those persons representative as a director in the target company. There is no problem. Now the next point, when you see here, in case of a conditional open offer, you cannot appoint any director. Here we saw that after depositing the money, we can appoint the director. That is in a normal case. Now we are having one more case, which is the conditional open offer. What is the meaning of conditional open offer? Here we are having the open offer, right? During the offer period, the shareholders will be tendering their shares. They will be offering their shares for acquisition by the person. Now there may be some conditions which may be imposed by the acquirer. The acquirer plus person acting in concert, they will give some conditions. What are the conditions? So they will say that approximately minimum 20% of the shareholders, they should offer their shares. Only then I will proceed with the open offer. Only then I will buy their shares. Minimum 20% of the shareholders, they should offer their shares for purchase. Only then the acquirer plus person acting in concert, they will acquire the shares. Like that they can give a condition. That is the meaning of a conditional open offer. This is the meaning of minimum level of acceptance. Minimum 20% of the shareholders, they should offer their shares for purchase. Only then the acquirer plus person acting in concert will buy the shares. So that is the meaning of minimum level of acceptance. And in this case, in any case, you should not appoint any director as the part of representing the acquirer plus person acting in concert. A person representing the acquirer plus person acting in concert, you cannot appoint them as director in any case. Even if you deposit more than the required amount in the bank account, it is not allowed. You should not represent. You should not represent in the board. You should not be appointed in the board. Now, when you see, no director should be introduced during the pendency of the competing offers. When two or three companies, two or three persons, two or three group of acquirers, group 1, group 2, group 3, they are having acquirer plus person acting in concert. They are giving competing offers. All the three people, they are trying to buy the company. They are giving competing offers. Then also you should not appoint any new director. Not even a normal director. Not as a representative. Any new director also you should not appoint. Then, if any director dies or there is an incapacitation or he vacates the office, then the vacancy will be filled after the approval of the shareholders by postal ballot. The shareholders, existing shareholders, they have to give the approval by the postal ballot. After that only we will appoint the new director. Even if some director dies or he vacates the office, we will fill the vacancy only using this procedure. Then, obligation of the acquirer. The persons who are acquiring and person acting in concert, they should be having firm financial arrangement. For paying the 100 crore consideration or the 1000 crore consideration, they should have made proper arrangement of funds. Then they have not declared any intention to alienate any material asset. Then they are debarred from alienating the asset. So, for example, we can see the target company is there. they are going to acquire the target company. The acquirer plus person acting in concert. Now they are having some key asset. Now that key asset, if the acquirer plus person acting in concert, if they are having the intention to sell, the purpose with which they are purchasing the target company is that their intention is to sell the key assets and then take the consideration. So that is their intention. For that only they are taking over the target company. Now, if they are having this intention, they have to declare it in the detailed public statement. Now, only if they declare after taking over the control of the company also, they will be allowed to sell the key assets. Now, if they are if they did not declare it in the detailed public statement, then even after taking absolute control of the target company, they cannot sell these key assets. They cannot alienate these key assets. They cannot dispose these key assets. That's what they have given here. Now, you should declare the intention in the detailed public statement to alienate the assets. Otherwise, you will be debarred from causing such alienation. You will not be able to sell it for a period of 2 years after the offer period. After the end of the offer period, 2 years, you cannot sell those assets. Then, even after that, you did not tell in the detailed public statement, but you want to sell. There is another way. Get the special resolution. Get the special resolution of the shareholders. Then you can do it. There is no problem. Then you have to make sure that whatever the details you give in the public announcement, detailed public statement, letter of offer, this is all you have to file it with SEBI and you have to publish it publicly. So these documents, they are having the true and adequate information, true and fair information. The acquirer shall not sell the shares during the offer period. During the offer period, the acquirer already they are having some shares right, that they should not sell it. Then the acquirer and person acting in concert are jointly and severally responsible. So if they want to pay the 100 crore, even if the acquirer does not pay, the person acting in concert, they have to pay the 100 crore. So they are jointly and severally responsible. Even if one person does not do, the other person has to fulfill it. Then obligation of the target company. The target company, what they have to do? They have to do the business normally. There should be no change in the normal course of the business. It should be conducted normally. Then the board of directors shall not alienate any material assets or affect any material borrowings after the open offer has been announced or after the things have been started. During the open offer period we are having, during the open offer period, the already existing board of directors, the current management, they cannot get any new borrowings, material borrowings. They can get normal small borrowings in the ordinary course of business. That is not a problem. But any material new borrowings, a large amount, they cannot borrow immediately during the offer period. They cannot sell any key assets. Then they cannot issue the unissued securities. They cannot issue a new securities. Issuing new securities is not possible, but you can give the conversion of securities. Already 10 years back, you issued some convertible debenture. Now the conversion due date, the due date of conversion of the debentures into equity shares, it falls in the open offer period. That you can do. There is no problem like that. Some things we are having. Already you have filed the red herring prospectus. Already before the open offer starts, you have filed it, or you have announced the record date of the right issue before the public announcement. Then and all, there is no problem. You can do the issue of shares. But normally, issue of shares is not allowed. Issue of securities itself is not allowed when you are in the open offer period. Then they cannot do the buyback of shares, they cannot amend or they cannot close down the key contract of the company, then they cannot accelerate any contingent vesting, though, so that and all we are having. Then, in the general meeting of the subsidiary of the target company in respect of the matter related to sub-regulation 2, these matter we are having, right? This target company that we are having. Now, this target company, some cases, the target company might not have the value. This target company is the holding company of one subsidiary. That subsidiary is the main valuable company. Now, for taking control of this subsidiary only, the acquirer plus person acting in concert, they are trying to take control of the target company. If they control the target company, automatically they can control the subsidiary. So now the subsidiary, for example, we can take it as having some material contract, or it is having some asset, or it is having some other thing which is very valuable. So for that purpose only they are trying to purchase the company. They are trying to take over the control of the company. Now we have seen that the target company might have value, but in some cases the subsidiary of the target company will be the most valuable item. It will have some valuable asset or valuable contract. Something will be there with the subsidiary. So for acquiring the subsidiary only, the acquirer plus person acting in concert, they will try to take control of the target company. Now we have to see one example here so that you can understand this properly. Now here, for example, we can take one target company and we are having a subsidiary. This subsidiary is having one warehouse, and it is a very big warehouse which is of a lot of worth. It is a high worth asset. Now the target company is the holding company. Now the management of the target company, they want to sell the warehouse. The management of the target company, they want to sell the warehouse. All this is happening during the offer period. The offer period is going on. Now they want to sell the warehouse. They cannot sell it. They have to get the special resolution of the target company shareholders by passing the special resolution through postal ballot. Special resolution through postal ballot is needed. Now what they will do? The target company, it will conduct a general meeting. It will conduct a extraordinary general meeting. And what it will do? It will get the approval through postal ballot. Now the outcome of the resolution, whether the SR is passed or SR is not passed. Now, if SR is passed, that is one outcome. If SR is not passed, that is one outcome. Now, for example, we can take SR is not passed. Then what will happen? The subsidiary will call a general meeting. In the general meeting, the parent company, the target company only is holding the share. The target company only is holding the share. So what will happen? The target company has to vote whether they will sell the warehouse or not. Here, the shareholders of the target company, they told that SR not passed. So they cannot sell the warehouse. This means that they cannot sell the item. Now here target company, when it is voting in the extraordinary general meeting of the subsidiary. Now what they have to vote? They have to vote we should not sell the warehouse. Like that only we have to vote. The vote done by the target company in the general meeting of the subsidiary, that should be the same as the resolution passed by the shareholders of the target company. That is what they are saying. So just this example is enough. No need to go any deeper into this. Now, this is this point. Then, prohibition from fixing a record date. The target company cannot fix any record date after the third working day prior to the commencement of the tendering period and until the expiry of the tendering period. During the tendering period, the offer period, you cannot fix the record date. Not only during the offer period is starting here. The 3 working days prior to that. In these 3 days also, you cannot fix the record date. Record date for any item, you cannot fix it in this time period. Then the next thing, furnishing the list of the shareholders. Now, within 2 working days from the identified date, the list of shareholders should be given to the particular acquirer plus person acting in concert. So, what is identified date they have given here that you can read it. The list of the shareholders must reach the acquirer plus person acting in concert. Then the reasonable cost for sending the list of shareholders, it will be paid by the acquirer plus person acting in concert. Then the next point is, here what will happen is that after everything is done, before the open offer period starts, the target company will form a committee. In that committee, only independent director will be there. They will decide whether the thing is correct or not, whether the open offer, whether it is proper or not. Whether it is proper or not, that will be evaluated by the independent director committee. They will give the recommendation to the target company, whether they have to accept it or not. Those things will be given by the independent director committee to the target company. That will be happening before the open offer period starting, before the beginning of the open offer period. So that they have given here. Then duties of the committee. The committee, what they will do? They will provide the proper recommendation on the open offer along with the reason why they are giving the recommendation. That reason also should be there. That will be published at least 2 working days before the commencement of the open offer period. 2 working days before the open offer period, it should be published. Then the copy of that particular recommendations, this committee report, that will be given to the board and then the stock exchange and then manager of the open offer. Then if there is competing offer, to the manager of every competing offer. Then verification of shares. The shares should be verified. Whatever the shares that were tendered, the shares that were offered for the sale in the offer period, that should be verified, whether the owner is proper or not, whether any problem is there in the title of the shares, that all should be verified properly. The next point is providing of information to the acquirers. Now, for example, we are taking 3 competing offers. Offer number 1 we are having, offer number 2, offer number 3. Now, all these 3 people have given the competing offers. These are all the acquirers. 3 different acquirers. Now, they have given the offers. Here, the company, if it is the target company, if it is giving the information to one acquirer, that information should be shared with the other 2 acquirers also. You cannot partially or with partiality, you can give the information with just only one acquirer. If you are giving the information related to the company to one acquirer, it should be shared with the other acquirers also. Then, after all the conditions followed, after everything completed, you have to register the transfer of shares. The shares should be transferred to the acquirer properly. Then, what is the manager of the open offer? There will be a manager to the open offer, and what are the obligations of the manager? So, the manager, will make sure that the acquirer is able to implement the open offer and firm arrangement for funds. The 100 crore or 1000 crore, we have to make payment right to the shareholders of the shareholders of the shares offered. So that payment, whether it is properly arranged or not, the funds arrangement, that should be checked by the manager of the open offer. Then the manager should ensure that all the detailed public statement, public announcement, everything is properly given. All the information given are true and fair. Then the manager should give a due diligence certificate along with a draft letter of offer to the board. So here board means SEBI. Due diligence certificate should be filed with the SEBI by the manager. The manager should ensure that the intermediaries, the stockbroker, sub-broker, whoever is engaged in the transaction, in the open offer, whether they are registered with the SEBI or not. Then they have to exercise diligence, care, professional judgment, normal point only. Then they should not deal in the own account. They will have the insider information and all. They should not buy the shares, sell the shares. That they should not do on their own account. They shall file a report on the board. The manager should file a report on the board confirming the status of completion of various open offer requirement. The requirement under this regulation, whether they followed it properly or not, that after the open offer, the manager should file a report to the SEBI. These are the obligation of the manager to the open offer. Then disclosure of shareholding and control. And whenever you are getting the shares, whenever you are purchasing the shares, you have to give the disclosure also. So who should give the disclosure? What should be the disclosure? So here the aggregated shareholding of the and voting rights of the acquirer or promoter or every person acting in concert. That should be given as a disclosure. The total shareholding which is and voting rights held by the acquirer, promoter and then every person acting in concert. The acquisition and holding of convertible security will also be treated as shares. If you are having a compulsorily convertible debenture, compulsorily convertible preference share, these two will be considered as equity share only. Then here encumbrance. Here we will be having the disclosure of encumbrance. When you are pledging the shares, that information also you have to report it in a separate form. So encumbrance means what you can say when you are pledging or hypothecating or mortgaging, everything will be called as an encumbrance. It is a charge on the asset. When you do not pay the loan properly, the assets will be sold by the pledgee. So the assets, the shares will be sold by the lender. So that is the meaning of encumbrance. That definition they have given here, that you can read it. Next, threshold for disclosure. Now, acquirer along with person acting in concert, if they are acquiring the shares or voting rights, aggregates to 5% or more of the shares of such target company, they shall disclose their shareholding. So here when you see, we saw that when you are getting 25% share or voting rights, you have to give the open offer. But we will not wait till 25%. You initially, when you are having 0%, now you are acquiring, slowly you are acquiring and 5% you got. You reached a 5% shareholding. Now here also you have to give a disclosure. Disclosure of your aggregate shareholding. So 25% you have to give the open offer. So slowly from 0 to 5% when you reach, in that case itself you have to give the disclosure of aggregate shareholding. So aggregates to 5% or more. Then in case of changing shareholding or voting rights, you are having 5% or more shareholding now. Now you are going to do some transaction, you are going to purchase the shares or you are going to sell the shares. Then in that case, you will be having a change in the shareholding and voting rights. Your voting rights will change. That also you have to give the disclosure. So you are having 5% or more shareholding currently. Now you are doing some change. You are purchasing the shares or selling the shares. The change is 2% or more. Then you have to give the disclosure according to the regulations. Disclosure you have to give in this point. When 2% or more change is there in the shareholding, already you are having 5% or more. The change is 2% or more. So that point they have given here. If the share is listed on an innovator's growth platform, then 5% will become 10% and 2% will be becoming 5%. So here we saw right, when you are getting 5% share, you have to give the disclosure. That will become 10% for the innovator growth platform shares and 2% we saw right, that will become 5%. So that also they have given here. Next point, when you see the disclosure, you have to give it within 2 working days from the receipt of allotment, intimation of allotment of shares. The intimation of allotment, you have got the shares allotted for this transaction, for purchasing a 5% or purchasing the first 5% or change in the 2%. That disclosure you have to give right. That should be done within 2 working days of the allotment of the share to the stock exchange and to the target company at the registered office. Now the next point, when you see shares taken by way of encumbrance is treated as an acquisition. Shares given upon release of encumbrance shall be treated as a disposal. Now I will tell you simply what it is. Here we are having the owner of the shares. Now he is pledging the shares with the lender. Now what will happen? The shares will go to the lender and then the loan will be received by the owner. Now this will be treated as an acquisition for the lender because the shares are going to him. Now after repayment what will happen? Now after repayment the owner will get the shares back and then the loan will be repaid to the lender. Now from the lender the shares are going outside. So for lender this will be treated as a disposal of shares. And this will not be applicable to the banking financial institutions that they have given here like that. Not apply to a scheduled commercial bank. Those points they have given here. Then when you're pledging the shares also, you have to give the disclosure. Like when the promoter of the target company is pledging the shares, then they have to give the disclosure. Then they have to disclose the details of such invocation of such encumbrance. When the encumbrance is forced, you are unable to pay the loan and the shares are sold by the lender, then in that case, that is called as the invocation of encumbrance. You are enforcing the charge on the asset. That also will be disclosed by the promoter. After that, the disclosure will be 7 working days time period from the date of creation of charge or invocation of charge or release of charge to the stock exchange and the target company. Then yearly, every year you have to give an annual declaration also. Annual declaration that you have not made any encumbrance other than the ones declared earlier. When you are making the encumbrance itself, you should make the disclosure. Other than that, annually you have to give one declaration that other than the ones reported, there is not any other encumbrance. Then, for the annual declaration, also 7 working days is the time limit. You have to give the annual declaration to the stock exchange, and here you have to give it to the audit committee. So that's all about this regulation. You have completed everything. Just now, I will just give you one overview of the entire open offer process. Here, some points will be there that are not there in the not given in detail in the regulations and the ICAI study material also. But I am giving an overall view of what will happen in the open offer process. So, first point is trigger point. The trigger point of the open offer we saw. What are the trigger points? So here if you see, from the first, when you see, you will get the three trigger points. So here, when you're getting 25% or more of the voting rights, you have to give the open offer. Then, after having 25% voting rights, additionally, you are purchasing 5% voting rights. Then also, you have to give the open offer. Here, when you see, we are having one regulation. Before acquiring the control, when you are going to acquire the control of the target company, before that, you have to give the open offer. So, three trigger points: 25% voting rights acquisition, 5% additional acquisition, and then the acquiring control of target company. Before doing these actions, you should give the open offer. So what will happen in the open offer? You have to first give the public announcement like the trigger point has reached and we are going to do the open offer process. That public announcement will be given. After that, you have to estimate the, not estimation, you have to give the maximum amount. What is the maximum amount that might be payable under the open offer process, that you have to calculate and deposit it in a escrow account. Escrow account, as we already saw, it is an account with a condition. For that purpose only you can use the amount, or after the process completed you can withdraw the amount. So that escrow account you have to deposit the amount. How to calculate the amount to be deposited, that all is not there in the syllabus, so that is not required for us. Next, the detailed public statement. Along with that, you have to give the detailed public statement also. After that, the draft letter of offer. The draft letter of offer will be filed with the SEBI. Who will file it? The merchant banker. The merchant banker will file the draft letter of offer. Then the SEBI will review it, they will give the observation, and then they will give the approval. After the approval of SEBI, you have to dispatch the final letter of offer to the shareholders. In this final letter of offer only, they will give the details like when the offer period will start, who can give the who are eligible to give the offering, who give the shares for offer. Then those details will be there in the final letter of offer. All the details for the shareholders will be there in the final letter of offer. After that, we will conduct the independent directors committee meeting and all. Then the recommendations will be given by the independent director committee. Recent recommendations about the open offer, we saw that regulation also. After that, the open offer period will start. The open offer period will be exactly for 10 working days. It will be open for 10 working days. After that, it will be ending. Then, after completing the offer period, we will give the post-offer advertisement. Like we conducted the open offer. In the open offer period, this much shares were offered by the shareholders, and we accepted this much shares. That all you have to give the information. After that, final settlement will happen. The payment will be credited to the shareholders who offered the shares and accepted. Here, when you see, for this we are having the timeline also, but I am not going to complicate by adding the timelines and all. Just this is an overview of the open offer process, so that you can understand it well. So other than that, whatever the points given here, that you, if you remember, that will be okay. The open offer trigger points. The open offer trigger points we saw, right? That is an important topic. After that, in this chapter, when you see, The obligation here, this itself is a very small chapter only. So from anywhere they can ask the question. So that's all. You have to read this entire chapter fully. That's all about the substantial acquisition and takeover of shares regulations. Substantial acquisition of shares and takeover regulations. Now we can start the insider trading regulations. So here if you see prohibition of insider trading regulations. So the word prohibition appears in the title. So this means that you should not do the insider trading. Insider trading is a very wrong thing and you should not do it. Here, who's an insider? Insider trading should first know who's an insider. So insider will be a connected person or a person who's having unpublished price sensitive information. So, what is the meaning of unpublished price sensitive information? We are having some kind of an information. That information might be about the financial statements of the company, or might be related to some fraud that is happening inside the company, or related to some loss that has been happened to the company, or related to some kind of an issue that is going on in the company. These are all the issues that are going inside the company. This information, if it is released in the public, it will affect the price of the share. It will affect the price of the share in the stock market. So this kind of information are called as unpublished price sensitive information. So these are unpublished, meaning that it is still not released to the public. Price sensitive means when this information is released, it will cause a change in the price of the share. So whether it may be a positive change or it may be a negative change, but there will be a change in the price of the share. So this is the meaning of unpublished price sensitive information. If you are having such information, then you are also called as an insider. For a particular company, you will be called as an insider. So here if you see connected person having unpublished price sensitive information, those people will come under insider. And any person who's having access to UPSI, definitely they are not having it, but if they want, they can go and get the UPSI. Within the reach, they are having the UPSI. So they will also be considered as an insider. So here when you see what is the meaning of connected person, we saw who is a person having UPSI. This unpublished price sensitive information will be called as UPSI in short. Now, what is the meaning of connected person? Here connected person when you see, for example, we are doing a transaction. We are doing a transaction on this date. Now you have to check whether you are an insider or not. For that you have to check whether you are coming under the definition of connected person or not. So who's the connected person? 6 months prior to the concerned act. 6 months prior to the transaction, you have to see whether you are connected with the company. How you will be connected with the company in any capacity, like you are a director, officer, employee, or you are under any capacity working in the company, or you are in a contract with the company, you are in a fiduciary capacity, in a trustworthy capacity, you are in an employment relationship, you are having frequent communication with the company or the officers, and you are having access to the UPSI, or you are reasonably expected to allow such access. So either you are having the UPSI, then also you will come under connected person. As because of your relationship with the company, you are having UPSI, you are handling UPSI, you will be a connected person. In another case, you are expected to access the UPSI. For example, you are a CEO of the company. You cannot say that I will not have any UPSI. Like that, you cannot say. Obviously, you will have the UPSI. You are reasonably expected to have the UPSI. So that is the thing. Next, along with the generality, this is a general definition. Anyone who's there in the relationship with the company, they will be covered under this definition. After that, we are having some specific people, like relative of the connected person above. If you are a connected person under this point, then your relatives also will be connected persons. Then holding company, associate company, or subsidiary company, intermediary in section 12 of the Act, SEBI Act, like the stockbroker, sub-broker, those people, investment company, trustee company, official of a stock exchange, member of a board of trustees of a mutual fund, then member of board of directors for an employee of the public financial institution, then self-regulatory organization, banker, those people are the professional firms and then the other institutions, financial institutions and other what we can say intermediaries who are working with the company, they will know the financial information of the company, which are the unpublished price sensitive information. So these people will always handle the UPSI. So they will always be connected person in relation to a company. So that we saw what is the meaning of connected person. Now, what is the meaning of generally available information? It is the information that has been released to public, that is verified, and there is no problem in that. Everyone knows that it is on a non-discriminatory basis. Each and everyone knows that. So that is generally available information. And if there is some unverified information, main point is the information should be verified. If there is an unverified information going on in the social media, that will not come under the generally available information. Then unpublished price sensitive information. What are all the main points? Like financial result will be the UPSI, dividend declaration, change in capital structure. You are going to get loan. You are going to issue shares. Everything will come under the UPSI. Merger, demerger, amalgamation, delisting, key managerial personnel changes. You are firing the CEO. You are creating a new CFO. Those people, those changes in the position will also come under the UBSI. Then when you see fundraising, change in the rating, like every company will have a debt rating. The bonds issued by the company, it will contain a rating. credit rating by the credit rating agencies, that rating. Then fraud or default in the company, agreement done with the company, resolution plan that is going to be implemented in the company, admission of the winding up petition. You are going to do a petition for winding up. That petition admitted. Then initiation of forensic audit, outcome of any litigation, giving any guarantee, withdrawal of any license. You are working in an industry where you have to get the license from the government authority. The government authority has withdrawn the license. The license is cancelled. Without having a license, you cannot work. So that license cancellation is a very important event which will be a part of a UPSI. Now the next thing when you see, these are all the things coming under UPSI, just you can give a reading. So when you spot a UPSI, you will be definitely knowing that it is UPSI. So that kind of information only UPSI is. Now we saw what is UPSI. Then what we have to see is that UPSI, we should not trade with it. Why we should not trade with it? That logic you need to understand. For example, you are working in the company, you are an employee. You are an employee in the finance department, like that we can keep. In finance department, you know all the information. What is the loan got by the company? What is the guarantee given by the company? What is the agreement signed by the company? What is the contract entered into by the company? And what are the financial results? Everything will be known by the employees. So you know all these information. Now, based on this, you can judge that whether the share price will go up or it will come down when this particular information is released in the market. Till now, these information are not released to the public. Now, for example, if it is going to be released on 10th of any month, but you are currently on the 2nd of the month. Now you know that after the release of the information, the share price will go up. Currently the share price is 100. After releasing the information, it will become 200. You know this. Now what you will do? You will use your own funds and you will buy some 1000 shares. It will be for a purchase cost of 1 lakh rupees. Now after releasing the information, the share price will become 200. So the value of the 1000 shares will become 2 lakh. Then you will sell the shares, you will have the 1 lakh profit. 1 lakh you will get the profit. But this is very wrong because normal people, they do not have this information. You are having this information because you are an insider. You are working in the company. So this creates an unfair advantage. So this unfair advantage should not be there. Because of that, we should not do the insider trading. That is the only thing here. I hope you all know this. So I am just telling you a brief explanation here. So everyone knows why we should not do insider trading. So the next thing when you see, you should not communicate the UPSI. You are having the sensitive information, UPSI. You should not communicate it to anyone. You should not spread it. Then you should not procure the UPSI. You should not try to obtain UPSI so that you can trade with UPSI. So you should not try to obtain the UPSI. Then for legitimate purpose, you can use it. There is no problem. Here also, except when it is done for legitimate purpose or performance of duties or discharge of legal obligation. Legitimate purpose, discharge of duties and discharge of legal obligation. For these purpose, you can communicate the UPSI. But for other purpose, you should not do it. So what is the legitimate purpose? For that, the board of directors of each company, they will create a policy. For these purpose, you can do it. There is no problem. That will be covered under the legitimate purpose. That detailed policy will be released by board. Based on that, you have to communicate and handle the UPSI. Then, when you see insider, if UPSI is accessed, so this means that you are not an employee or not in any relationship with the company, but you are getting to know the UPSI. You did not try to obtain that also. Accidentally, you got to know about UPSI. You got to know about UPSI. Then you will become an insider. All the regulations in this particular prohibition of insider trading regulations will apply to you. You should not trade with the shares using the information. You should not communicate it to any other person. That and all will be followed by you also. You should follow that. Then open offer. So we already saw in the regulations, like the substantial acquisition of shares and takeover regulations, that we have to do the open offer. According to this regulations, when you're doing the open offer, the acquirer plus person acting in concert, they might need some information about the company. Because they are going to acquire the shares, they need some information about the company. For this purpose, if it is needed, the board of directors can decide and they will allow the UPSI. They will communicate the UPSI to the acquirer plus person acting in concert. So this is the thing. According to this regulation, we are doing the open offer. The board of directors decide that the UPSI communication is in the best interest of the company. It is good for the company. It is the requirement. Then they will communicate it to the acquirer plus person acting in concert when there is a open offer requirement. Then in other cases, we are not having the open offer requirement. Open offer and all, it is not there. But the board of directors, they decide that it is proper and it is in the best interest of the company. What is in the best interest? To communicate the UPSI. Then after using the decision, they can communicate the UPSI. When it is required for the transaction or something like that, they can communicate. There is no problem. For trading and other illegal purpose, for insider trading, you should not do that. So those 2 points are given here. So here, next point, when you see confidentiality agreement. So we saw that when you're getting an open offer, or in other cases, you can communicate the UPSI when the board of directors has taken the decision. When you are communicating in that manner, you have to execute the confidentiality agreement. Like, this is the insider information, we are going to receive it. We will not do the trading based on that. We will follow all the insider trading regulations. We will not communicate it to any other person. We will not use it for illegal purpose. So like that, you have to get the confidentiality agreement signed. You should execute the confidentiality agreement. After that only you have to share the UPSI. Then for the persons to whom you are sharing the UPSI you will share with many persons, to the banker, financial institution, open offer, that person, and then any other contract you are doing, to government, everywhere you will share the UPSI. You should maintain a structured digital database. Structured digital database along with the identifier. So for any person you are giving the UPSI, you have to get the name, details, along with the PAN number of the person who is receiving the information. That details should be there in the structured digital database. It should be maintained internally. Internally means everything, the server, everything should be maintained internally. If you are giving it to third party server, if you are giving it to third party server, it is not allowed. You should maintain the server internally. It should be done properly by the company itself. It should not be given to any other person outside. They cannot outsource it to any other person. Then the entry in that information. So structured digital database, that is within the company, you are going to enter the information into that. Now if the information is passed from within the company, from the company that information is going outside, then you can easily enter it, the database also within the company only, and then the company also, they know what information is there, they will enter it quickly. But some information it is arising out of the company from other party. For example, you are doing a contract with some company, other company, you are the what we can say, the obligated company. For example, your company is doing, we can take partnership firm, your company is doing contract with the partnership firm. Now the partnership firm has given the approval for some agreement you are going to do with the partnership firm for some contract. Now this approval, they have got it, that is a part of the UPSI only. Now this information, it is arising from the outside. This you have to enter it into the structured digital database if you are procuring it to, if you are communicating it to someone. So for that you are having 2 days, 2 working days, within that you have to enter this UPSI into the database. So 2 calendar days from the receipt of information, you have to enter it within the structured digital database. Then the structured digital database, it is applicable to the listed companies, intermediaries and fiduciaries. So listed company, they should maintain it. Intermediary, the stockbroker, sub-broker, investment advisor, research analyst, those people also should maintain the database. To what persons they are communicating the information. Fiduciaries, like trustee, those people who are handling the information in a trustworthy capacity, they also should maintain the structured digital database. Then listed company will, what it will record, the nature of the UPSI, what kind of UPSI it is, then details of the sender, receiver, then PAN number should be there. If it is not available, any other unique identifier you can do. That also you have to record it in the database. Intermediary or fiduciary, he should record the UPSI received or shared, details of the company, regarding which company this UPSI is there, then details of the sender, receiver, everything should be there by the recorded by the intermediary and then the fiduciary also in their particular respective database. The database provided by third-party vendor is not allowed. Then the records shall be updated in the digital database as and when the information gets transmitted. Then preserved for 8 years. The structured digital database, you have to preserve it for 8 years from the completion of the 11th transaction. Then the preservation timeline is very important. They may ask it in MCQ, in SETI or IBS. So 8 years is the preservation timeline. Then trading when in possession of UPSI. When you are having the UPSI, you should not do the trading in the securities. So you should not do trading when you are having the UPSI. Now the next thing is, you should not trade in the securities when you are having the UPSI. But in some cases you can trade. What are all the cases? The transaction is an off-market transfer between insiders who were in possession of the same UPSI. So for normal people only it will be an unfair advantage. But when you are an insider, you are going to do the trade. The other person is also the insider. Both the insider, they know the UPSI. Then there is no problem. They are doing the trade in the off-market terms, off-market transfer. They are doing it as a part of a off-market transfer. They are not doing it in the market. Other than the market, separately they are doing the transfer between two insiders who are having the same UPSI. Then no problem. There is no unfair advantage. Both are on the same ground. So that point is there. That is an exception. Then transaction was carried out through the block deal window mechanism. As per the block deal window mechanism, in that if you are doing some kind of a trading, the transaction, then also it is allowed. After that, It is done in pursuant to a statutory or regulatory obligation. For a bona fide transaction, you are doing a bona fide transaction. That is a genuine transaction you are doing. That also you are doing based on the statutory requirement. According to law, you are having a requirement. Based on that only you are doing the transaction. You are not doing it out of your own wish. Then in pursuant to exercise of stock option in respect of which exercise price was predetermined. So stock option, it will be given to the employees and other people, right? The stock option you are exercising. You are exercising the stock option and then the price was predetermined. The price at which the stock will be issued, that is predetermined. Already it was determined earlier. Then in that case you can do the thing. There is no problem. You can exercise the share option. Then non-individual insider. When the insider is a entity like they are a company or a partnership firm or a trust like that, they are some insider. They are having the UPSI. Then persons in the company, there will be people working normally, and then some people might be there. They are handling the UPSI information. Now these two people are there. Now the person who are doing the trading, who's taking the trading decision, that should be from the normal people. The UPSO information, the people who are handling the UPSO information working inside the company, that group of people, they should not take the trading decision and all. The normal people who do not have the UPSO information, they should take the trading decision. For that, you have to keep a proper controls that and all should be there. So that they have given here to that point. Then you are doing the trading as per the trading plan. The trading plan, what is the meaning of trading plan? We will see it later. This point is the trading plan point. We are having a separate discussion for that. Then here you are having the UPSI, you did the trade. Then we found out that the SEBI or some investigative agency or someone found out that. Then what will happen is that they will assume that you did the trade because you had the UPSI and you saw some advantage. Because of that advantage only you are doing the trade. You are doing it for wrong purpose. That will be the assumption. Normally when you are trading with UPSI, that will be the assumption. That point also they have given here. Then if you are a connected person, you are doing a trade and some complaint is there or SEBI is doing an investigation, then they found out that you are a connected person and you did a trade. Then you have to prove, the connected person has to prove that he did not trade. He did not trade on the basis of UPSI. That should be proved by the connected person. Connected person only should give the proof that I traded on this time, I did not have the UPSI, or I traded but I did not trade it on the basis of UPSI. That all should be proved by the connected person. But in case of other person, if there is any other person on whom an insider trading allegation is there, then SEBI only should prove that the person did the trade based on the UPSI. That should be proved by the SEBI. When you are a connected person, you have to prove that you are innocent. When the case is on other persons, SEBI has to prove that the person is guilty. So that concept also they have given here. Bonus of possessing the UPSI. Then the board may give such other condition requirement and all that also they are having the power. Then we can see what is the meaning of trading plan. Some people they will always have the UPSI. They will always have the UPSI, like the CEO of the company, the CFO of the company, or the employees of the company, all the connected persons you can take. Those people will always have the UPSI. So whether they are banned from trading, that is the question here. Whether they cannot even trade in their lifetime, whether that is a question here now. Now the answer is no. They are not banned from trading. They can do the trading, but they have to do it as per the trading plan. What is a trading plan? Trading plan means it is a proper plan where you will tell all the information like I am going to buy the securities or I am going to sell the securities. I am going to do it on this date. And then the price range. The price range means if the price goes between this range, I will do the buy transaction. If the price goes in this range, I will do the sell transaction. That everything will be there in the plan. That will be called as the trading plan. That trading plan you have to prepare it. All the persons who are always in the position of UPSI, who will always handle UPSI, they should prepare the trading plan. They will give it to the complaints officer of the company. The complaints officer will check that, he will verify that, and then he will approve it. Based on his approval, you can do the trading as per the trading plan. And after creating the trading plan, it is mandatory to follow the trading plan. You have to compulsorily follow the trading plan. If you are not following, you have to do separate procedure for that. You have to intimate to the complaints officer. They will do the discussion on that. Why you did not do that? Everything will be done afterwards. But it is mandatory normally when you are doing a trading plan. So whenever the person who's always having UPSI, they should do the trade only as per the trading plan. So that points they have given here. The trading plan should be prepared by the person. They should present it to the compliance officer. It should also be disclosed to the public. It should also be declared to the public that this is the person they are going to do the trade. That and all they will be giving it to the public also. Then, so this trading plan, one more important point we missed out. So here, the person will always be having UPSI, right? The UPSI that was there with the person when they were formulating the trading plan. When they created the trading plan, they will have some UPSI. This trading plan, you have to start the execution of the trading plan only after this UPSI is released. So, at the time of formulation of trading plan, some UPSI will be there with the person. The trading plan should be starting only after such UPSI is released to the public. So, that is one more point. Then, when you are doing the trading plan also, you should not use it for market abuse. You can do the trading plan, it is a relaxation given to you. You should not use it for market abuse. That is also one more point. So, here when you see that point they have given here, the UPSI should be released. UPSI that was there with the person at the time of formulating the trading plan. Formulation of such plan. Then the trading plan shall start after 120 days of public disclosure. You are preparing the plan, getting the compliance officer approval, everything you are doing after the public disclosure. You are doing the public disclosure. After that, you have to wait 120 days. After 120 days only, you can start the trading plan operations. Why that 120 days wait? In that 120 days, all the UPSI that were there with you at the time of formulation of trading plan, that will get released properly. Normally, it will get released. Any UPSI, it will be released in 120 days. Financial result, dividend, everything will be released. But if it is not released also, you should not start the trading plan till the UPSI is properly released to the public. So that is the restriction we are having here. Then cannot overlap any other trading plan already in existence. If you are already having one trading plan for this time period, you cannot keep another trading plan for this time period. That is not allowed. Only one trading plan at one time period. Then the following information should be there. Value of the trade, how much amount you are going to trade, what is the number of securities you are going to trade, nature of the trade, buy transaction, sell transaction, specific date or time period, not exceeding 5 consecutive days. So the time period between this 10th and then the 20th I will do the trading, like that you can give the range. But the time period should be maximum 5 trading days. Then price limit. For a buy trade, the upper price limit. For a sell trade, the lower price limit. So buy trade means, for example, I am trying to buy the shares. But I will keep an exception that if the share price reaches 1000 rupees, I will not buy. When you are selling the shares also, you can keep an exception. If the share price reaches 800 rupees, I will not sell. Below this, I will not sell. Above this, I will not buy. So like that, you can keep an exception. That information also you should be telling in the particular trading plan. Then details of 1, 2 and 3. Value of trade, nature of trade, date and time period. It is mandatory. Fourth point is optional. Then you should not do the trade for market abuse. Then the compliance officer will review the trading plan. After that, he will approve it. Whether there is any potential for violation, everything will be checked by the compliance officer only. Then after getting the approval of the trading plan, no need to go to compliance officer for getting approval for each and every trade transaction. Once you get the approval, you can do the transaction as per the trading plan without any approval further required. Then mandatorily you have to follow the trading plan. You cannot stop it. Then if you are not implementing the trading plan due to any reason like financial difficulty or some other reason, then you have to intimate the compliance officer within 2 working days. So you are having the date, last date to do the trade as per the trading plan is 20th. Within 2 working days from that date, you have to inform this non-implementation to the compliance officer. You did not do the trade as per the trading plan. Inform it to the compliance officer. After that, the compliance officer will place such information to the audit committee. They will tell it to the audit committee. The audit committee will make a decision whether you are doing it genuinely because of any genuine reason or you are doing it for malpractice. That will be decided by the audit committee. The audit committee will make the decision. After that, after making the decision, the decision will be notified by the compliance officer to the stock exchange. So the compliance officer will tell the decision to the stock exchange. Then whatever the actions that will be taken as per the code of conduct. Every company will have a code of conduct relating to the insider information. As per that, they will take the disciplinary action or any action. Then the compliance officer can approve the plan or reject the plan. That is the decision of the compliance officer, the trading plan. Now, insider, when you're doing the trading, you should give the information. Like, if you are an insider, you should give the disclosure of whatever the trading done by you. So that such disclosure should be in such form, such manner as may be prescribed. Those points are there. Then the disclosure that you have given, that will be given to the company only, and the company should maintain for a period of 5 years. This is important. This point is important. Then remaining point you can read it. There is no problem. Then disclosure by certain person. When you are appointed as a KMP or a director, or you are becoming a promoter, or you are becoming a member of the promoter group, then you have to make a disclosure of whatever the shareholding of your whatever the shareholding that you are maintaining, that you have to give a disclosure. This is a one-time disclosure. Second thing is continual disclosure. Every promoter, member of the promoter group, designated person, and director, everyone should disclose how much securities they have traded. They will be normally trading. When they are trading, they have to do the disclosure. When they have to do the disclosure when the value of the trade exceeds 10 lakh rupees. When the value of the trade exceeds 10 lakh rupees, the value becomes more than 10 lakh, then they have to do the disclosure within 2 working days, 2 trading days. Within 2 trading days, you have to do the disclosure. That point you can find it here. Within 2 trading days, you have to do the disclosure when the traded value becomes more than 10 lakh rupees, in excess of 10 lakh rupees. Then the company will inform it to the stock exchange. The person who traded, he will inform it to the company. The company will inform it to the stock exchange. After that, the time for disclosure, everything will be prescribed. Then other connected person. Now we are having one listed company. For example, we can take they are having a listed company and they are having a lot of employees, and then they are having a lot of CEO, CFO, those people are there. Now the listed company has the power to get the disclosure from these people. These people are insider, connected person. These people should give the disclosure that whatever the trading they did, what are their holdings of the shares, that all should be disclosed. The listed company has the power to get the disclosure from these connected person. So that also they have given for the purpose of this regulation, whether they are doing the trading properly, whether they are using the insider information, that we have to check. For that, the listed company can demand the information, can demand the disclosure from the connected person. Then some person, for example, you are there, you are not connected with any company, but you got the information that some person, like CEO of the listed company, he is doing an insider trade. Like that, you got some information. Now you have to inform this information to SEBI so that they will take the appropriate action and do the investigation. So for that also we are having one provision: original information in voluntary information disclosure form. So you have to give the information in the voluntary information disclosure form. You have to give the information under the informant protection office. There will be a separate office for this. You will be informing the details. For that, you have to give it in the form in the manner of Schedule D. The manner and then the form everything given in Schedule D. You have to fill that form. You have to give the information to the SEBI. You have to submit it to the legal representative. If you are not using the legal representative, you have to come in person and then you have to give the form. Then in the form in which you are giving, your details should not be there because you are an informant. If the company gets to know or the CEO gets to know, he will do something. So you have to expunge the details, you have to delete all the details, you have to erase all the details. The form you are giving, right in that, your personal details, your identification details should not be there. So that point they have given here. This is a normal point only, you can read by yourself. Just I have given the explanation, the context. The next thing, code of fair disclosure. Every company board of directors, they have to create a code of fair disclosure. So code of fair disclosure means UPSA we are having, for what purpose we can disclose it, for what purpose we can disclose it, and for what purpose we should not disclose it. That should be as part of the code of fair disclosure. That all will be created by the board of directors. It will be published in the website of the company. So that code, it will be properly amended, and whatever the amendment you are doing, you should give it to the stock exchange. You should intimate it to the stock exchange. Then in this code of fair disclosure only, we will have the policy for legitimate purpose. We saw that we need to create a policy for legitimate purpose. What are all the legitimate purpose? For that, that policy will be under the code of fair disclosure only. Then code of conduct. Every listed company and then every intermediary, and they should maintain that whether their CEO, their managing director, whether they are creating a proper code of conduct to regulate, monitor, and report the trading by the proper persons. So you will have some designated persons, like these people are insider, these people are connected person, these people are very important and they may have a UPSI. So for those people, whatever the trading they are doing, whatever the shareholding they are having, that we should properly monitor. So for that monitoring, we need a code of conduct. That code of conduct will be prepared by the CEO or the managing director. So we saw that what is the code of conduct? It will be prepared by the CEO or the MD of the company. The board of directors should ensure that the CEO or MD is properly creating the code of conduct. Then that we are having the normal information only. Relating to that, some information they have given, you can read by yourself. This is the concept of code of conduct. Then the designated persons. Who are the designated persons? Why we are creating the code of conduct? We are going to monitor the trading done by the designated persons. Who are the designated persons? For that only we are having the information here. Employees of material subsidiaries, promoter of the listed company, CEO, employees two level below the CEO. CEO is there, below him one level, below him second level. All these employees here along with the CEO, they will be treated as designated person. We will monitor the share trading done by these people. We will check them whether they are using the inside information to do the trade. Any support staff like IT staff, those people also, if they are having the access of the UPSI, then they will also be considered as a designated person. We will monitor the share trading done by these persons. Monitoring the share trading means we will see whether they are doing trading based on UPSI. Then penalty under section 15G. So if you are doing insider trading, we already saw under the SEBI Act 1992 that under section 15G we are having the penalty. Minimum will be 10 lakh, maximum will be 25 crore or 3 times of the profits made, whichever is higher. So this is a very important penalty. They might ask you in the exam. So this penalty you have to mandatorily remember. So that's all about the insider trading regulations. Now I will show you some charts. So here if you see, insider, connected person having UPSI, person having access to UPSI, they will be treated as an insider. A person when he is doing the trade, when he is having the UPSI, it will be assumed that he was motivated by the knowledge of such information. Then next point, when you see the procurement of UPSI, no person should procure the UPSI for the companies which are listed or proposed to be listed. Then insider should not communicate the UPSI, should not provide the UPSI, should not provide access to the UPSI. That is procuring UPSI and communicating the UPSI. Communicating, they can directly communicate, or they can give the document, or they can provide the access. They can allow them to see the UPSI. That also will come under communication only. Then any person should not procure UPSI, should not cause the communication of UPSI. Then UPSI can be communicated for legitimate purpose, performance of duty, discharge of legal obligation. Then here when you see, we are having one more chart. When the person is receiving the UPSI for some transaction like open offer or some other transaction, they are receiving the UPSI, they have to execute the confidentiality agreement. Then the parties, both the parties should keep the UPSI confidential. Whatever the parties that are there, the other party other than the company. So on one side company will be there, on the other side other party will be there. These two people will do the transaction. For that only we are communicating the UPSI. So the other party should keep it confidential. You should not trade. The other party should not do the trading when they are having the UPSI. Then structured digital database, the maintenance, it should be maintained by the board of director or the heads of the organization. They have to ensure, the board of director or heads of the organization, they are having the responsibility to check whether the structured digital database is properly maintained or not. Then content, the nature of the UPSI will be recorded, names of the person will be recorded, PAN number or any other unique ID of the persons will be recorded. The security, the structured digital database, it should not be outsourced to any other person. You should keep it internally. Then preservation, you should keep it for minimum 8 years. Then if any investigation is being done, you have to maintain the data till the completion of the investigation, till the end of the investigation, or 8 years, whichever is later you can say. 8 years even if it completes, currently you are going under investigation, you have to maintain the data till the end of the investigation. You should not erase the data just because 8 years completed. You should wait for the investigation completion. So that's all about the insider trading regulations. We have completed everything in the insider trading. So we have seen everything. Now that's all about the insider trading regulations. Now we have completed the topic successfully and we have reached the end of this video. So that's all about this chapter. We have completed it fully. We have done the full coverage and I have also given you the important points. Wherever they are asking the questions, I have also mentioned it along with the explanation. So that's all for this video. If you found this video helpful, share this to your friends, subscribe to the YouTube channel, like this video and leave a comment whether you like it or not, what are the suggestions that you can tell, and what are all the things that you are having the doubt, and what topics for which you need the next videos. That also you can mention it in the comments. I will try to make videos for those also. So all the best for your exams. Prepare well. Thank you.